Make please, Your Lordship.
Yes.
My Lord, item number 74, clerk has wrongly filed there. It is police inaction.
কালকে তুমি মেনশন দিয়ে দাও। It will appears to be mentioned tomorrow. I'll release it.
Milord,
Must oblige.
Milord, under compelling circumstances, mention, Milord, one matter on mention, Milord, your lordship included in upgraded list. Item number 54. It will take up 5 to 10 minutes. Otherwise, Milord, next week my matter will be infected.
further
Other side, Milord, Mr. Chaturvedi is here.
No further upgradation. Sorry, no.
No, Milord, 2 p.m. or 3 p.m. anytime, Milord. 5 minutes maximum. Milord, before 1st September, or if not, Milord, please
No,
this
no,
order,
no,
Milord.
no, Mr.
Milord,
Chakraborty.
any day, Milord, before
Call
1st September or any day, Milord.
Call on the list.
Milord, any day before
Mention
1st
item
September
number
at 2 p.m.
for
Milord.
One
non-prosecution.
who is appearing.
Milord, in the top any day, Milord, before 1st September.
Lord, I am for the petitioner, my lord.
You not
Lord,
want to
this-
proceed?
This writ petition, my lord, is not filed proper form, my lord. And therefore, my lord, I withdraw this writ petition with
Learned
liberty to-
counsel for the petitioner submits that
liberty
the
to file
petitioner
it
has
as
not been filed in proper form, full stop. Accordingly, on the prayer of the petitioner, WPA 15871 of 2022 is dismissed as withdrawn with liberty to file afresh on the self-same cause of action.
This-
Item 2 for written.
Written notes on
Yes, my lord, it is ready, my lord. My lord, may I just, my lord, file it, my lord?
during the course of that.
Yes, because I just need to, my lord, go through the spelling mistakes, my lord.
Very, very.
Well, I am filing it, my lord.
The written notes of arguments filed by the petitioners be kept on record, full stop. The matter is reserved for judgment, full stop. Leave is granted to the, you are for which respondent?
But,
Union
the-
of India.
My lord, this I am filing on behalf of, my lord, the SFIO, my lord.
6 should be respondent number 6.
Six, thanks. The leave is granted to the respondent number 6, the SFIO to file its written notes of arguments during the course of the day.
Grateful, my lord.
ওটা ফাইল করলে এর মধ্যে দিয়ে আমি পাঠিয়ে
I'll just go through it, my lord. I'll
Please
just
do.
correct the
Very
spellings, my lord, the certain mistakes, my lord.
Is it my lord's pleasure we exchange also our notes, my lord?
You can do it, I mean, why not?
Sign দিয়ে না, আমি
আমি দিয়ে দিচ্ছি তোমাকে।
spelling গুলো correct করে দিই।
Extension of interim order, item 3.
Yes.
But I appear with the authority, my lord.
Lord, I am for the petitioner.
I do not
Yes,
know.
sir. When is it expiring, the interim
My
order?
lord, 31st of August,
I
it
take
is
your lordship
expiring.
and-
My lord, there is an application for vacation also, vacating of this.
আচ্ছা।
But I have filed an app and the nature of interim order passed by your lordship, and I think extension is not needed. My lord. Your lordship kindly peruse the order.
My lord, that is
I'll check.
dated 28th of
But your
June,
lordship kindly hear
2023.
my application for vacating.
Definitely, if I extend before that, I have to hear you. I'll just check.
Yes, yes. দেখি দুটো কাগজ দিন। একটা কাগজ আর একটা দুটো সই করেছো?
Inner page 3, last
He will be
paragraph.
entitled to continue with the order.
Yes, yes.
Yes.
Though your lordship stayed the notice, but otherwise your lordship has granted, restrained us, my lord, from discontinuing the service. So in that event.
No, the notice terminated him.
No,
Not
it is a
termination,
discontinuation. My lord,
Yes. Either of you, yes, you.
Yes, yes, my lord. My
The
lord,
notice, what did the notice do? Just tell me that.
yes, the impugned notice at page 43 says discontinuation. I tell your lordship, it was a tender for 1 year. It was awarded to me. Suddenly, they come with a
Mr.
doc-
Bhattacharya, it has to go hand in hand. The stay of
Page 5, paragraph 6 onwards. My lord, basic, my lord, he was informed, and my lord, there is a clause of arbitration that he has not invoked. Why he has not invoked that clause, my lord? That has not been stated in the writ petition. Number 1, number 2, my lord. Under the clause, there is a power. The authority has the power to terminate even, my lord.
Bhattacharya, all these points were available at the point of time when the writ petitioner was admitted. Writ petition, there was service, but the authorities did not appear. So I'll
Because
get
of
this-
the
these are
communication.
points in the main writ petition, Mr. Bhattacharya. I'll
Yes.
fix the writ petition on some day.
Yes, yes. Let it be
Yeah.
hard out.
Vacating, if it is
My lord,
vacated,
it will take some time. In that event, my lord, I have.
vacating, if I have to hear the vacating, Mr. Bhattacharya, the same points will be involved in the writ
Yes, yes,
petition
that is-
also.
that is-
Yes.
So
Only
in that event,
one thing, my
my
lord.
lord, may I pray one thing, my lord? Your lordship, in that event, kindly set aside this liberty to the authority to proceed afresh in
No.
accordance with.
That cannot be, my lord, because my lord, for 12 months, it has been given to us. In the meantime, during pendency of this work order, they go for another tender with the same work. Now they cannot do it. Now, my lord, from the vacating application itself, it can be established that they have absolutely done it illegally. I show your lordship.
That is a different cause of action, Mr.
Yes.
Lai.
That's they have put in the vacating application.
So
my
Mr.
lord.
Bhattacharya is saying
Yes.
that we can set aside this. We can set aside this and allow the writ petition basically. That can be your only prayer in the writ petition. You have challenged the notice, I am setting that aside.
Yes.
They have conceded to that and I'll give them liberty to proceed afresh.
Difficulties, my lord, they have given the same work to another person.
That is a new cause of action,
fresh cause
Mr.
of
Lai.
action. Yes.
I'll give you that liberty. I'll record that.
My lord, in that case, my lord, I'll be continuing in my work because that has
If
to
I
be.
set aside the notice,
Yes.
your disqualification does not go.
No, there is no disqualification at all. I tell you, lordship, what exactly. That's why I was trying to appraise your lordship. My lord, if your lordship kindly takes the writ petition for once. My lord, kindly take page 23.
What is the present scenario, Mr. Bhattacharya? Are they still
They are,
subject?
Yes,
they are
yes.
continuing because of your lordship's
Yes.
protection.
Yes, we are providing food to
And
the
we are
hospital.
eager to, my lord, judges.
You will continue, but they'll have liberty to take fresh
Yes,
proceedings.
yes, that is one.
In accordance with law.
That is what Mr. Bhattacharya is saying.
Yes.
But my lord, the difficulty is before 12 months, they cannot do it
Why?
because this is
That
an
is a
agreement.
different.
That is agreement, my lord. My lord, kindly see there is an agreement.
It will
Well,
liberty
may
to
I just
challenge
please
that
Understand, Mr. Lahiri? Let me pass my order.
I've
You will
realized,
understand
my
from
lord,
the order.
may I just appraise your lordship for once? For one.
Learned
my lord.
counsel for the respondent authority submits that the interim order granted earlier be vacated, comma. In the alternative, comma, it is submitted that the writ petition be disposed of, comma, if necessary by setting aside the impugned notice and granting liberty to the respondent authorities to proceed afresh against the petitioners in accordance with law. Which of next para, learned counsel appearing for the writ petitioner submits that the period of 12 months
12 months. my
12
lord.
months have to be left as per the clauses of the contract between the parties. Push up next para, be that as it may, comma, since a fair stand has been taken by the respondent authorities, comma, in the light of the observations made in the order dated June 28, 2023, regarding a strong case having been made out by the petitioners for hearing of the writ petition on merits, comma, it is construed that the reasoning given in the order dated June 28, 2023 is adopted for the purpose of final disposal of the writ petition itself. Full stop next para. Taking into consideration the submissions of both sides, comma, WPA 14712 of 2023 is allowed, comma, thereby setting aside the impugned notice dated May 31, 2023 and permitting the writ petitioner to continue with the supply of hospital diet in question for the time being, comma, subject, comma, however, comma, to further action being taken by the respondent authorities in accordance with law. Full stop. It is made clear that the respondent authorities shall be at liberty to take fresh action for termination of the petitioner's contract, comma, strictly in accordance with law and the terms of the contract between the parties. For some, nothing in this order shall preclude the authorities from doing so. No less to cause
My
certain
lord.
certified copies. Can 1 of 2023 is also disposed of accordingly.
I'm grateful to your lordship. Extremely lordship.
No use of keeping
No.
the matter pending.
No, you are
No,
absolutely. This is absolutely
Yes, yes,
justified.
yes, yes. My lord,
Such a stand was taken by all the respondent authorities. I mean,
yes, yes.
no litigation. Will be
Hopefully,
there.
my lord, that liberty will not that trigger them to go in other way.
No, they will definitely do that.
But the liberty, since they would take.
What are you saying?
Because
This
of
is the
the-
best order you could get.
I'm grateful to your
Time
lordship.
that will be taken, and it may not be disposed of within a year. But it
Yes,
might-
now you can rectify your faults.
Also, yes, I'm grateful to your lordship. Extremely grateful.
They have
No, just because they've committed faults in the previous
no.
course of action, you cannot ask for
Continue
a
it for-
right to
absolutely, absolutely.
persist forever.
No, no, no.
Go on
We do not.
forever.
At least-
Definitely not.
No, absolutely, absolutely. Ma'am. Grateful to your lordship.
Item 4.
Yes. Yes, Mr. You are for the petitioner, Mr. Samant.
I am for the petition.
Right,
I'm,
Oh, Mr.
And
Roy
then
was,
Mr. Roy, my lord.
yes, Mr. Roy was that side. Yes, yes, Mr.
That is
Shamsur.
my list. Well, may I reply?
My lord, may I
Yes.
pray one thing, my lord? I think my learned friend will not object, my lord. Mr. Banerjee, seriously.
My lord, on the last occasion, matter was adjourned on the ground of illness of Mr. Banerjee, senior country
Mr.
counsel.
Karan had prayed for more time.
My lord. But I cannot stand in the way.
We don't stand in the way,
I
Arjun.
cannot stand in the way, my lord.
When should I keep it?
After fortnight, my lord,
On the prayer of the, you are for the state.
Yeah.
On the prayer of the state, comma, let the matter stand adjourned for a fortnight and shall next be listed on September 8, 2023,
grateful.
after a fortnight.
In the same position, my lord.
Same, my lord.
In the same position.
This is, my lord.
No, cannot be same position.
Malad, would your lordship kindly, would your lordship kindly indicate that continuation there will not create inequity in favor of the private respondent?
That is, your lordship, they are,
Without looking into the matter, I cannot do that. Yes.
Item 5.
The petition.
Yes.
Well, should I go to that side?
Yes.
My lord, I'm for the writ petition, my lord. This is that matter where I have challenged the proceedings of the National Green Tribunal.
Number 9 and 10.
Sure. Municipality.
All right.
But I had challenged, just to recapitulate, my lord, if your lordship has, my lord, I have challenged the proceedings of
At Green
National
Tribunal.
Yes, Green Tribunal.
Yes.
The challenge lies before your lordship in view of the judgment passed by the Honorable Supreme Court, Madhya Pradesh Bar Association, where Section 14 and Section 22 of the National Green Tribunal Act was challenged, saying that that is contrary to the basic structure of the Constitution, as it bypasses the powers of Article 226, 227. The Honorable Supreme Court held that I have, my lord, on the last occasion handed over one paragraph that I have not placed on the last occasion. I'll place it. Paragraph 6 is the challenge. Paragraph 6 is the challenge. Petitioners argued that though incorporation of Section 14 and Section 22 in the NGT Act, the jurisdiction and role of the High Court under 226, 227 is extinguished, thus therefore has imparted the basic structure of basic feature of the Constitution, and as such provisions of such and such should strike down. 8 is the remedy. Thereafter, I will not trouble your lordship. Kindly comes to one paragraph with regard to Section 22. Paragraph 22 at internal page 7, I have already placed. If your lordship wants, I can place it once again.
You have placed 19, 22.
22, yes. 22.
22 is not marked. You can place it again.
It is also
Noteworthy.
noteworthy that nothing contained in the NGT Act either impliedly or explicitly outstate jurisdiction of the High Court under Article 226, 227. And the power of judicial review remains intact and unaffected by the NGT Act. The prerogative of writ jurisdiction of
Sir, I have read it. Yes.
yes.
226,
Another one
yes.
point
Yes.
why it is not is because the scope of Section 22 is very narrow in view of the fact that the appeal is only restricted the paragraph 38, 31 onwards.
31.
The Supreme Court discusses that the scope of Section 22 of the NGT Act is very narrow. Petitioners have also pleaded that instead of appeal to the Supreme Court under Section 22 from the orders passed by the NGT, an appeal mechanism as a matter of right should also be provided before the concerned high courts. According to them, appeal to Supreme Court is inadequate and unaffordable and therefore inaccessible. On this aspect, it needs to be observed that even when a direct appeal to the Supreme Court is provided by the statute against the decision of the tribunal, the remedy under Section 220 and Article 226, 227 before the High Court remains unexhausted. Moreover,
the appeal under section 22 of the NGT Act is limited to the grounds of section 100 of the CPC, and the Supreme Court does not function as a regular fast appeal court. So these were the reasoning. However, under Article 226, 227, remedies on issues of jurisdiction and also under the principles set out in the associate provisional such and such, this Wensbury Corporation are available for an aggrieved party, subject to the discretion being exercised by the affected litigants, can move the High Court under Article 226, 227, and in such cases, a SLP under such and such could also be maintained to the Supreme Court from the High Court's verdict. So therefore, as in L. Chandra Kumar. L. Chandra Kumar has subsequently been relied upon, and the conclusions I have placed, paragraph 45. And my lord, to substantiate that this should be before the Honorable Single Judge, I have drawn your lordship's kind attention to an order dated August 9, 2023, where we had approached the Honorable Division Bench, and the Honorable Division Bench was pleased to observe
August 9 or November 28?
August 9, 2023. এটা কি? Oh, no,
I've
sorry,
got
sorry, sorry.
November 20.
No, no, November.
Yes, I've got that order marked.
Yes. So therefore, before your lordship, now, my lord, the merits,
Yes.
the petitioner before your lordship, I have drawn your lordship's kind attention to page 145 and 46 to substantiate that the lands are Bagan. Irrespective of that, this is only to satisfy your lordship's conscience.
131.
Page 46 and the live data as of today. Live data is as 131. Yes.
Right.
From
45, 46, 141, 131.
131.
Yes, all these.
In any case, even if it is water body, it will not lie before the National Green Tribunal. That is my contention.
Yes.
Page 137 onwards, I have annexed the original application where Mr. Dotto has made out a case at paragraph 9 at page 147 that it is being converted.
Yes.
And may I just place paragraph 9? The population density in Malda is rapidly increasing, for which habitation areas are expanding towards the bill. English Bazaar municipality has given permission and has sanctioned plans to all who are illegally settled for their conversation. Chatla bill is a vast water body, and by flouting all laws of the land like Land Reforms Act, Environment Protection Act, West Bengal Indian Fisheries Act, Water Prevention and Control Pollution Act, wetlands such and such, it is reported that 4,000, 5,000 have been considered in the converted area of the Chatla bill, and the process of filling up the water body is still continuing in absence of municipal sewerage drainage system and proper solid waste management. 100% of the households of that area are discharging their liquid and solid waste into the bill. If the process of change cannot be arrested, the geography of Chatla bill will be subject matter of history shortly. I have, my lord, disputed that Chatla bill is that particular place. My contention on merits would be it is in Bangladesh. But I am not going into all these things as of today. Now, he has my contention. May I just place the brief and thereafter I'll draw your lordship's candidacy. He has only annexed the Google Maps at page 155. Which are not authenticated data, which allegedly shows one Chatla bill. Your lordship knows that if I mark High Court today as the chamber of
138.
155. If I mark High Court today as my chamber in
Not
Google,
only that it's a water body, it's shown by blue.
yes,
That is also there.
That
It
is
may be a different way.
that is Google Map.
Yes, even Google Map.
Google Map is not an authenticated data. It's not even Google Map. I can mark High Court as my chamber. It will show.
Not a question of marking High Court as a chamber, Mr. Lahiri. It is shown as there is a color coding.
Someone has to mark that as.
No, need not. It has its own mechanism, Google Map.
Mechanism that
From
is
the
not
satellite.
authentic.
No. That is very authentic, Mr. Lahiri. It's very authentic. You may not be aware, it's very authentic.
Even if it
It's
is
done
Google
by
Map, it is
satellite.
different.
there is a distinction between the two.
Well,
If
who
you-
marks?
Mr. Lahiri, let me
Yes,
finish.
yes, yes.
If you mark a place as your chamber,
Ah.
that is only a marking that's shown as a marking. Color coding is for the nature of the terrain. It's definitely a water body. It's seen from the map. Do you deny it's a water body at all?
Well, I do not say which is the
May
water
not
body.
be authentic in that sense for this.
Yes,
You are
but
saying for a court of
land
law.
reform, land records have to show. Huh.
But it is not merely
Oh,
that
acha,
someone.
if my learned junior says that if the Google map is saying this is not even the actual Google map.
Oh, I see.
We have
There
tried
is-
to find out many things, but we are not as of today going, means I'm only prima facie showing.
Very well.
And thereafter, he has taken pictures of him standing there. And thereafter, my lord, the kindly now comes to the order.
Acha, these pictures were produced by him, 162,
Yes,
160.
yes. Entire original application is annexed in the writ petition in
These
view of the.
two, it's not a water body.
Yes, but
mostly
he
not,
is
I mean.
saying that it is. It
Part
was,
of it is probably page 160 on the second
he's
one.
trying to make out a case that that used to be an water body and this is being filled.
Anyway, very
That is his contention.
great. Yes.
Now, my lord, the original application finishes at page 191, I think.
Hmm.
Yes, the immediate cause of action before a lordship is page 192. I have drawn your lordship's kind attention.
Hmm.
Where, my lord, out of the blue, the district magistrate has restricted all the registration of deeds in compliance with the purported compliance, I'll say, passed by the National Green Tribunal in such and such subject matter. It is hereby requested not to execute any deed as per order as known as Chatla Bill. 5 mojas have been marked. As a effect of that, all the loans have been stopped in respect of that will be appearing from 193. And now the order, page 194, which I am saying that National Green Tribunal ought not to have assumed jurisdiction for passing the order. Kindly comes to the ordering part at page 195, paragraph 14. Considering the allegations made, we deem it appropriate to constitute a committee comprising of the following members. Senior scientist, senior representative, senior such and such. Paragraph 15, the committee shall visit Chatla Bill and inspect the site and submit its report with regard to the encroachment alleged to have been made upon the said water body. Next order tate. And it shall suggest remedial measures for restoration of the
Lahiri,
said water
at
body.
the risk of disturbing you,
Yes, sir.
I mean, because you argued at length on the last one. Let me just point out, are these your points or is there something else? You can, after that, continue your argument. The first point you took is Article 226 maintainability.
Yes.
On that, you have cited judgments
Yes,
which
sir.
are on record. One. Secondly, it's a bagan, not a water body. You have cited particularly pages 46 and 131 to show that versus this so-called Google map, which is not so authentic.
Yes.
Second. Third is, even if it's a water body, NGT has no jurisdiction to interfere.
Yes. Yes.
Fourth is, in any event, registration of deeds can't be stopped by the NGT.
Yes.
Fifth is, even the NGT order does not stop registration as such. It
Yes.
says no encroachment.
Yes. No encroachment.
These are your points,
Yes.
basically.
And why NGT is not having jurisdiction? I have relied upon
Yes.
kindly.
Why
comes-
NGT
is not having jurisdiction
over water body?
over this entire area.
Yes, yes.
Yes.
Show me that.
Page 201 is the committee's report,
Yes.
which the committee formed under this. Kindly do not open that. I'll come to that.
Yes.
one.
Yes. Committee report
201.
201. Yes.
The committee lastly says
This is the committee formed by virtue of that order.
that order.
Very well. Yes.
A, last page, A, E. District administration may initiate the process for declaring Chatla Bill as significant water body as per Wetlands Conservation and Management Rules 2017 and send the proposal for such notification to the concerned department. This I am showing before your lordship to substantiate that as of today there is no notification. Now I am just skipping over the Moja map and coming to this rules. Kindly comes to page 204. It starts 205 and kindly comes to the definition, which is starting at 205.
This wetland.
Yes, this is the relevant rules which has to be invoked. Kindly comes to G wetland means any area of marsh, farm, peatland, water, whether natural, artificial, permanent, temporary, with water that is static, flowing, such and such, but does not include river, channel, paddy fields, human-made water bodies, specifically construction for drinking water for the purpose. Applicability of the rules. These rules shall apply to the following wetlands or wetlands complex, namely, one is wetlands categories as wetlands of international importance under Ramsar Convention, which is East Calcutta wetlands. B is wetlands as notified by the central government, state government, and union territory. So it has to be notified. Here there is no notification. Now, the activities which have been prohibited in notified wetlands are at 4.2. Following activities shall be prohibited within the wetlands, namely conversion of non-wetland uses, including encroachment of any kind, setting up of any industry, expansion of industry, manufacture, handling, solid waste dumping, discharge of untreated waste and effluents from industries, cities, towns, villages, and
If
other
it's a wetland under this act, then
these things will
encroachment
come.
also comes in.
Thereafter, the wetland authority has been formed.
Need not go into that. Yes.
Now, my humble submission before your lordship is that on the jurisdiction of the National Green Tribunal Act is,
No,
oh, your lordship is having that book, number 1, page
61.
page 561.
yes.
Section 14 would be at page,
I've got it.
yes, section
Marked on the
14,
Only section labeled in my book.
yes, section 14, section 22, and thereafter the schedule.
Yes.
The jurisdiction is in respect of the tribunal shall have jurisdiction over all civil cases over where a substantial question relating to environment, including enforcement, such and such is involved, and such question arising out of implementation of enactments specified in Schedule 1. Schedule 1 specifies certain acts. One act out of that is the Conservation Act, and under the Conservation Act, these rules have been framed. So therefore, my humble submission.
Conservation Act is Schedule 1 Act.
Yes.
One of the Schedule 1.
Yes.
Very well, yes.
And the rules have been framed under that act.
Mhm.
So therefore, you have to come within the rules for the entire thing. Now, my humble submission before your lordship is that your lordship was pleased to, on the last occasion, my lord, express that is there any other statute where wetland has been defined?
Yes.
There are. East Kolkata Wetland Conservation and Management Act is one act where wetland has been defined.
Does this fall within East Calcutta?
No.
No. Then let us not go into that.
And second would be Inland Fisheries Act.
Inland Fisheries Act is there.
Yes, section 17.
So anything in Inland Fisheries Act to affect you?
It has to come to High Court. Inland Fisheries Act, they have to make a complaint to the chairman of the municipality because under section 17 of.
These are not NGT
No.
Schedule 1 Act.
No, no. Inland Fisheries Act is not there.
It is not there.
If they want to invoke the provisions of Inland Fisheries, they have
Recourse
to
is
go
there.
to the chairman of the municipality who is exercising powers of the first instance under the Inland Fisheries Act.
That's a
Thereafter,
different
there is
setup
an appeal
altogether.
to this authority and thereafter to High Court. So in any case,
Right.
this doesn't fall within Inland Fisheries Act, so therefore gone. Second is, your lordship has recorded it.
No, the last occasion I asked that question because Mr. Bhattacharya was probably not there.
No, Mr. Bhattacharya was not
Because
there.
that was why I was
They have
leveling
filed
for
a short one-page report
yes, yes.
with regard to
So
the definitions.
that is why I played the devil's advocate on the last occasion. Because you are not there. Now you are here, you will argue your case.
Lord, I have,
Mr. Ganguly was there.
yes.
Mr. Ganguly pretends to be innocuous, but don't get taken by that.
No.
His innocuous point may turn the tables. on you.
Exactly.
Yes.
I have gone through yesterday. It has been circulated.
Very well. Wetland and water body. This is under that Wetlands Conservation Act. Very well. The ones you. Those same rules.
Last order.
Yes.
Last order.
Yes.
Well, one order that I will also draw your lordship's kind attention. Last order, not here. National Green Tribunal.
K.
Under 2,
2 there is up to J in this. I, J, K. K is not there.
East Calcutta wetland.
wetlands.
हाँ, এই তো আচ্ছা.
Oh, achha, the last page. I'm sorry. East Kolkata wetland is applicable here?
No.
I don't think so. If Mr. Bihani says no, it's no.
No.
Yes. Anyway,
There is a different authority,
Very well.
different entire thing.
you are the state. You are for the state. Right. No. Thank you very much for that. Absolutely.
I have only two
And one
submissions.
point, my lord, I have just on that day when your lordship was pleased to pass an order staying the operation, staying the entire proceedings, or it was not brought to the notice of the
So what
honorable
was
tribunal.
disturbed? Yes.
This is the order which has been passed on that day, where they have been municipality has been directed to file affidavit and all, my lord. Personal appearance and everything.
Why are you citing this on I mean,
Because to bring it to your lordship's
to bring
attention. If the entire thing goes away, then this is also good.
This proceeding was not known to us. We do not know.
Obviously, yes.
State
At that relevant point of time, it was not pointed out to the tribunal. I do not blame the tribunal. If it is not having jurisdiction, not having.
The only thing your lordship may kindly take into consideration, which the report which was filed, the
4.
page, my lord, this is
206.
201, 202. The last paragraph, further actions which may be taken by district administration. The district administration may initiate the process for declaring the Chhatroville as significant wetland as per Wetlands Conservation and Management Rules 2017. Therefore, my lord, in my very respectful submission, that it has not yet started. This is number one. And second, my lord has taken here, I am repeating, but these are the instructions on behalf of
you
the
are for Mr.
I am appearing on behalf of the municipality, English Bazaar municipality.
Right.
My lord, kindly see the applicability of the rules.
কোন রুলসটা annex in the writ petition, annexed in the writ.
This has been annexed.
Kindly see rule.
These are the rules under the
2017.
These are the rules under the Wetland
Conservation Act.
Conservation and Management Rules
Yes.
2017. Kindly see Rule 3.
This is one of the few matters where Mr. Lahiri has really worked hard. Yes.
He is working hard, my lord. This has not been notified by the central government.
No. Mr. Dattu is not there. He has
Um,
to defend himself. You said on the last occasion it does not appear.
yesterday also he has been mailed.
Mail regarding this
আচ্ছা,
matter.
এখানে আসছেই না তো। বললে হ্যান্ড সার্ভিস করেছি, মেল করেছি।
I'll collate your documents and pass my order later. I mean, a few days. I'll close arguments.
Deeply oppressed.
Arguments are concluded. Judgment it is reserved.
I'm grateful.
Further? Yes. You are for whom? Yes. On the last occasion, you want to. What is your submission basically? I've forgotten. Hard but forgotten. No. Very well. Very well. Very well.
Well, there are,
Then I've heard you.
my lord, other matters.
Yes.
This will be taking care of item 91, 92, 135, 136, 79, 80, 81.
Why didn't you point out before I took up the matter? I would have heard all together.
Not apropos the merit of this matter, but one submission that I have heard Mr. Lahiri right now, that he has cited the digital procedure that is on Madhya Pradesh.
মধ্যবর্তী।
But I will be making a request and submission to your lordship. Your lord, finally, my lord, ascertain this issue. Apropos the maintainability of the petition, because these matters they are contributing to now the Supreme Court order has come.
I'll decide whether the Supreme Court is right or wrong. I mean, what you're asking.
This is why we-
So
No, no.
Supreme Court says it all.
It's
The
very
last
clear.
judgment of the Supreme Court.
Yes, very clear.
Good.
But as to the lordship instruction, then the report.
No, I could have decided the matter right now, but because certain documents had to be
Yes,
collated,
yes.
Yes.
I'll just have to check the page numbers.
Selection will not report.
Oh, that, acha. একটা line প্রথমে দিয়ে দেবেন. As per previous direction, the state has filed a brief report which we kept on.
My lord, item numbers, may I?
Yes, give the item numbers. No, Mr. Lahiri, let me pass my order on this. I'll not take much time on this. Obviously, I'll not take. So after that, just cite this
Yes.
judgment and get orders in the others.
Deep blue.
Upgraded matter, item 6.
Will it be my lord's pleasure to give me a short passover? Mr. Banerjee is leading me. If he is not there in the second call, my lord, I'll start. My lord.
Very well.
Or I can come back at any time, my lord, 12:30 or 2.
No, that's risky. I mean, let us wait for Mr. Banerjee. I'll take up one or two matters after that.
Very
if he
well.
does,
Otherwise, my lord, I start.
two matters pass over.
Grateful, my lord.
Two matters pass over. No.
Item 7.
Lord, I beg to appear on behalf of the petitioners. Lord.
Yes, Mr. Ghosh, what is the matter?
Lord.
Good
the-
service.
Lord, yes.
Good service affected.
Yes, yes.
Yes.
Lord, this matter, the petitioners, through over and across the petitioners dwelling house, Lord, railway height of tension line was drawn up. Lord, initially there was a writ petition before this honorable, after construction it was drawn up. The writ petition was moved before this honorable court. Initially, Lord, his lordship, as his lordship then, Gitesranjan Bhattacharya, as his lordship then was directed a joint inspection and decision by the railway authority and West Bengal State Electricity Board.
Yes.
But railway authority didn't care. Ultimately, West Bengal State Electricity Board held that it is dangerous, it should be removed. But ultimately, my lord, after contempt application, the railway authority also sat together and decided that it is not feasible. Ultimately, my lord, the writ petition was dismissed by his lordship. Ultimately, an appeal was preferred before this honorable court. The division bench of this honorable court held, during hearing, the railway proposed that we shall guard the line by cradle guard, so that it is not affected.
No, yes.
Yes. Lord, in terms of the said order, though, it was the parallel line through this not
Columns.
side by side by upwards parallel, but they didn't do it, but they fixed the cradle guard. But in terms of the order, division bench order, your lordship will get that order at page 27.
$26.
Yes, Lord. No,
Yes.
Yes, page 26.
That was just to solve
No,
the
no,
problem.
that is
and
not the order.
Not that.
The order is not at page 27 and 28. 27 and 28.
27, 28 is this in my copy.
Yes, no, let me-
29 probably.
Yes, no.
9th of November order?
Yes, yes. No.
Yes, my
It is
copy 29.
29.
Yes.
Lord, your lordship kindly come to the third page. Okay,
Yes.
second page of the order.
Right.
Second paragraph. Mr. Mojumdar, the learned advocate, appearing on behalf of the respondent railway authority, has taken instruction from his client and has suggested that the safety and security of the appellant and the members of the family can be appropriately protected by placing cradle guard, and a sketch map proposing such cradle guard has been placed before us. With a copy to Mr. Ghosh, Mr. Mojumdar has taken further written instruction from his client that in addition to that, the railway will also guard the said wiring by fixing a 25 kV danger board on the fencing of the building of the appellant. Mr. Sulan, advocate appearing on behalf of the appellant, has no objection if the line which has been gone over the property of the client is protected. In view of such submissions of the parties, we set aside the order impugned and instead of that, direct the railway authority to protect the safety and security of the inhabitants of the land and building of the appellant by placing cradle guard and also fixing 25 kV danger board on the fencing of the building of the appellant as suggested in the sketch map and also in the written instruction of the Eastern Railway dated 8th November 2006. The aforesaid cradle guard as suggested by Mr. Mojumdar be completed within 6 months from date today. The time fixed by us is mandated. But thus, cradle guard was fixed after, though not within time, but it was fixed. But subsequently, in course of time, it fell down.
Cradle guard fell down.
Yes.
Hmm.
And Lord, we, in spite of our repeated, because it is very urgent and dangerous matter, and Lord, in spite of that, they took no steps. And ultimately,
The railway authorities have to do it.
yes.
Yes.
And Lord, ultimately, Lord, they came, and Lord, instead of keeping a sufficient distance between the roof and the where, they placed it on our roof.
Place it on your roof.
Roof, touching the roof. But in spite of
So
repeated,
then this sketch map was violated.
this
Because
was
this shows a gap between your.
yes.
So
That's
now
why
it is
not-
on your roof.
Yes, it has been placed till now. It has been placed on my the cradle guard. There was a direction that sufficient distance should be maintained between the wire and my roof.
Despite service, none appears for the respondent authorities. Footstep Learned Counsel for the petitioner contends that that on a previous occasion, by virtue of an order of a division bench of this court dated November 9, 2006, the railway authorities were directed to protect the safety and security of the inhabitants of the land and building of the writ petitioner by placing cradle guard and also by fixing a 25 kV danger board on the fencing of the building of the present petitioner as suggested in the sketch map which was handed over to the court and in terms of the written instruction of the Eastern Railway dated November 8, 2006. Footstep, it is submitted that although a time period of 6 months was stipulated for undertaking such action, the said direction was complied with, although after a delay beyond the stipulated period of 6 months. Footstep, next para. Subsequently, however, the cradle guard installed by the railway authorities fell down, upon which the petitioner had to approach the railway authorities afresh. Footstep, upon such approach being made, the railway authorities ultimately reinstalled a cradle guard, however, on the same was done immediately touching the roof of the petitioner. Footstep, it is submitted that such construction shall create more hazards than it would mitigate. Footstep, next para. Since despite service, the respondents choose not to appear in the matter, and in view of the extreme urgency involved due to the apprehended electrical and fire hazard of the petitioner, the writ petition is taken up for adjudication. For next para, a perusal of the sketch map annexed at page 28 of the writ petition, which stands unrebutted, clearly shows that the contemplated cradle guard was to be affixed between the 25 kV transmission line running over the petitioner's property and the roof of the petitioner's property. Footstep, next para. In fact, the sketch map clearly denotes that there has to be some distance between the cradle guard and the petitioner's roof, in order to ensure safety. Footstep, it was recorded in the order dated November 9, 2006, passed by the division bench of this court in MAT 1793 of 2003, that the railway authorities were to protect the safety and security of the inhabitants of the land and building in question by placing cradle guard and also fixing a 25 kV danger board on the fencing of the building within double inverted as suggested in the sketch map, double inverted close. Footstep, next para. There is nothing on record to indicate that such order was ever challenged or modified by any superior forum. Footstep, as such, nothing subsequent has taken place to derogate from such order at this point of time. Full stop, next para. Hence, comma, in view of the nonchalant action of the railway authorities in placing a cradle guard at a very risky position, comma, touching the roof of the petitioners, comma, the petitioners are entitled to the relief as claimed in the writ petition. Full stop. Accordingly, WPA 1055 of 2022 is allowed, comma, thereby directing the railway authorities to set up a cradle guard, comma, sufficiently above the top of the roof of the petitioner's property, comma, as indicated in the sketch map annexed at page 28 of the present writ petition, and in terms of the order dated November 9, 2006, passed in MAT 1793 of 2003, immediately, comma, positively within 1 month, within 2 months from the date of communication of this order to the respondent stroke railway authorities. Full stop, next para. It is made clear that the above time limit is peremptory and mandatory, and the respondent authorities shall comply with the same by treating a server copy of this order to be sufficient for the purpose of compliance. No rest to suggestion. আরেকটা ম্যাটার ডেকে নিই তারপর নিচে দত্তটা।
Item 8.
Yes, Lordship, may I please your Lordship? This is a glaring instance. Writ petition is the fallout of the glaring instance of administrative apathy. Lordship, my section 14 application is pending for more than 6 years. If your Lordship directly come to page number 18 of the writ petition.
Have you made the borrower a party?
Yes. All were served.
What about service on the borrower?
Yes, kindly come to the track report. Initially, it was filed in the original site. Lordship, kindly come to the first affidavit service in WPO number
কোথায় সেটা?
2253 of 2022. একটু জজসাহেবকে অরিজিনাল সাইটের যে রিপিটিশনটা আছে 2253 সেটা একটু দিন, এফিডেভিট সার্ভিসটা এর সঙ্গেই আছে।
আমাদেরকে দেখছি না, আমি বুঝতে পারছি না।
ফাইলের মধ্যে দেখুন, হ্যাঁ 2253 of 2022.
ওনাকে দাও ফাইলটা।
Lordship, may I produce my copy? This is the photocopy.
Borrower is necessary, otherwise.
Lordship.
How long pending?
Since 5th of May 2017. Kindly come to page number 18. At the bottom, Lordship.
Acha, have they preferred anything in the meantime?
No.
Section 17.
No, kindly record my submission. There is no stay.
Put this in the writ petitions.
Lordship,
whenever
henceforth
final.
I will.
Learned counsel for the petitioner stroke bank submits that the application of the bank under section 14 of the SARFAESI Act 2002 is pending since the year 2019.
2017, Lordship.
2017. Full stop, next para. It is contended that the statutory outer limit of 60 days has long been expired. Full stop, next para. Despite service, none appears for the respondents. Full stop. Affidavit of service filed today be kept on record. Full stop. Since the petitioner is justified in arguing that the statutory period of 60 days has long expired and there is no justifiable cause for the application of the bank under section 14 of the 2002 Act to be kept pending, comma, coupled with the submission of learned counsel for the petitioner on instruction that no challenge has been preferred under section 17 of the SARFAESI Act by the borrower, and that there is no subsisting restraint order preventing the district magistrate from proceeding with the section 14 application, comma, the writ petition is taken up for disposal, full stop. In view of the above observations, WPO 2253 of 2022 is allowed, comma, thereby directing the respondent number 2, that is the district magistrate, comma, Nodia, to dispose of the application filed by the petitioner bank under section 14 of the SARFAESI Act 2002 against the private respondent numbers 6 to 8 herein as expeditiously as possible, comma positively within 3 weeks from the date of communication of this order to the respondent number 2. No orders to cause urgency.
I'm grateful, Lordship. Lordship, similar order may be passed in case of item number 29, which is also appearing as upgrade motion.
When it is called on.
Lordship.
Yes.
Pass over matter item 6.
Yes.
My lord, just received a phone call, my lord, from the advocate. My lordship remembers day before yesterday when this matter was called,
Yes.
lordship, and since state was not being represented, Mr. Devopriyo Chatterjee was requested to appear.
Yes,
My lord, there is a bereavement in his family. He personally called and said to keep it next week. Monday, my lord, he is comfortable. If lordship, my lord, permits, I can come back on Monday.
Thank you so much. Yes. An adjournment is sought on behalf of learned counsel for the state by learned counsel for the petitioners.
I thought, my lord, I
Last
should.
portion to the No. Thank you so much for that. I cannot record that
No,
for other.
I understand. My lord.
An adjournment is sought on the ground of learned counsel for the state. Full stop. Let the matter stand adjourned accordingly and shall be listed under the same heading on August 28, 2023. Orithro eta jeram position ache, eram position again. Very.
Grateful, my lord.
Item 9.
My lord, I am for the petitioner, my lord.
My lord, Ms. Sushmita Shah Datta is appearing for the respondent, my lord. My lord, she is in emergency meeting with His Excellency at Raj Bhavan, my lord. I am praying
Let her
for.
be there. His Excellency at Raj Bhavan cannot dictate the orders of court.
My lord, I am praying
Definitely
for
not.
very
No.
short.
No. For that ground, I'll take up the matter. Yes. What is that?
Lordship, lordship, the
She
petition.
actually told you to ask for adjournment on this ground. Must have. Yes. Please move the matter. I'll record her ground and I'll reject it. Yes. You move the matter. What
Lordship.
is that to you?
Lordship, the petitioner, lordship, the petitioner is a married wife of the respondent number 9, lordship.
And
The
there cannot be any other wife. Oh. What is married wife?
Lordship.
Legally married wife.
lordship, legally married wife, lordship, and
Please, after you'll have to say woman. A woman who has entered the nuptial bond probably.
lordship, the after marriage, after few days of marriage, the petitioner came to learn that the husband has extramarital affairs, lordship, and thereafter torture has been started, lordship, and reconciliation was done, but no result came out, lordship, and
What are you
thereafter.
wanting now? What is the-
Lordship, he is a Indian Army, lordship, and there is a provision that they can give me the maintenance directly. I have a 5 years old son, lordship. I am not
With the
getting.
provision, have you got a provision? Got the
Lordship,
provision?
lordship, the communication, lordship, annexed. I have annexed their communication. The authority asked me
Page
to
number?
page number, lordship, first annexed P3. Annexed P3, page 21, lordship. They asked me to produce some documents so that my maintenance claim can be considered, lordship.
Do you have a copy of your application on which this was communicated?
Lordship,
This was a response to your application.
yes, lordship. That copy I don't have, lordship, because
Anyway, let us see.
and subsequently, lordship, I have submitted, lordship. I have submitted all the documents, lordship, and lordship.
Documents of what?
Lordship, the affidavit, they asked for a affidavit,
You
lordship.
have
That is
submitted
also,
documents to them.
yes, lordship. Lordship, I have annexed, lordship, the affidavit, what they have asked, lordship, that is page.
But they're not taking any action on them.
No, only it is pending. Everything is completed, lordship. Lastly, after filing my writ application, lordship, they.
So I have to know at least what
Lordship,
application you made to them. I mean, you have stated in a writ petition.
Lordship, yes,
I
lordship.
cannot direct something which is rehearsal.
No, lordship, not that. They have only delaying, lordship, nothing else. They have meeting with my husband, and it is decided that I will get the maintenance. But lordship, lastly, lordship, may I hand over this after filing writ application? This documents came, lordship. The
Yes.
second document is their documents.
Educational qualification of you. Why? Your educational qualification certificate,
They asked and I have submitted.
Ms. Hassin, you have to show me some law under which I can direct. If there is no law, I cannot direct the respondents to grant maintenance. Or
Lordship,
it
Lordship,
will not be
the,
effective for you.
Lordship, the communication, from the communication, it would be evident that they are seven. I have again submitted the FIR, what they have asked. All these communication for getting the remuneration, and
The
they
army letter, the army communication to you at page 21 only says claim for maintenance allowance. That is your claim.
yes, Lordship.
They say it is intimated that on receipt of your application, your husband number such and such was interviewed. You are requested to forward an affidavit on non-judicial paper, whatever, showing you income, source of income, etc. Very well. So that does not confer any power on them. I mean, very well, I'll direct them to you give your educational qualification to them.
Yes, I have submitted, Lordship. First page of the envelope, Lordship, I have just handed over referral.
Envelope, how
No,
can the envelope be with you?
Lordship,
You have
the first
submitted.
page, that is. With my letter, I have,
So I'll direct them to take action on your.
yes, Lordship.
That I'll do.
Within a stipulated period, because they are,
Yes.
My lord, my senior just received a message from army, my lord. May I read, my lord?
Yes.
My
What
lord,
is your name, please?
Madhurima Basu. Madhurima Basu.
Basu. Yes. Yes, Miss Basu.
My lord, in their the so-called notice stage and maintenance case shall be decided by next month by army authority.
Thank
This
you.
is the message, ma'am.
You are also on the panel of the army.
No, my lord.
But I'll record your name. I'll direct you to be, I mean, not in the panel, I cannot say. Acha, learned counsel for the petitioner contends that the petitioner is an unfortunate wife of an army personnel, namely Abdul Ohed Sheikh, comma, who has not been granting maintenance to the petitioner, and the child, you have got one child,
Lordship.
and the child of the petitioner for a considerable time. Full stop. Accordingly, the petitioner applied for disbursal of maintenance to the employer of the husband, that is the respondent authorities. Full stop. Upon such application of the petitioner, comma, the respondent authorities communicated with a letter dated February 19, 2020, annexed at page 21 of the writ petition, comma, asking for certain details, comma, upon which they would apparently take appropriate steps regarding the disbursal of maintenance. Full stop. Next para, the petitioner submitted such documents. Full stop. Thereafter, the petitioner was also asked to furnish copies of documents regarding her educational qualification, comma, during pendency of the writ petition, comma, which was also done by the petitioner duly. Full stop. The present prayer of the petitioner is that the respondents be directed to take immediate steps for ensuring that proper maintenance is disbursed by the petitioner's husband to the petitioner. Full stop. Next para. Ms. Basu, comma, appearing for the respondent authorities submits. Now, Ms. Basu appearing with her senior Ms.
Smita Shah.
Shahadattu, comma, submits that the respondent authorities are willing to consider and take appropriate steps within 1 month.
Yes, my lord.
Within 1 month on the issue. Full stop. Appreciating such fair stand of the respondents and keeping in view the present condition of the petitioner, comma, WPA 14160 of 2022 is disposed of by directing. Which authority should I direct? She cannot say. How can she? Which one?
Your Lordship, the rule is actually section 90 of the Arms Act.
Section 90.
Of the Arms Act, read with, I think, rule 193.
Thank you so much. Thanks. By directing the respondent numbers 228 to dispose of the petitioner's application for maintenance and ensure that adequate maintenance is granted to the petitioner by the pro forma respondent number 9. Full stop. It is expected that the respondents shall take steps and complete the entire exercise as indicated above within 1 month from date. Full stop. The respondent shall also ensure that due alimony is started to be disbursed in favor of the petitioner within a fortnight after such disposal.
Grateful, Lordship.
No address to cause, urgent certificate.
Grateful, Lordship.
Thank you very much. Yes.
Arvind Sweet actually, not sure the commanding officer as per 190.
Commanding officer is respondent number?
Commanding officer is responding.
সুস্মিতা শাহ দত্ত না ও আচ্ছা আচ্ছা ওটা দিতে হবে সুস্মিতা শাহ দত্ত করে কমান্ডিং অফিসার ইজ রেসপন্ড নাম্বার 2 তাহলে রেসপন্ডেন্টস
Lordship, let
নাম্বার
it-
2 to 8 যেখানে বলেছি ওখানে রেসপন্ডেন্ট 2 করে
Lordship, let it be 2 to 8, Lordship, kindly.
লেট ইট বি হোয়াটএভার
Grateful, Lordship.
নেক্সট কোন নেক্সট 10
My
yes
application.
7
10.
yes
But I
that
appear for
yes,
the
right
National Medical Commission.
yes
No, no, এটা একটা. Needn't be troubled with the papers, not very short.
this is another matter
This is a very short point.
yes
You know, just whether a degree that is granted to like a MD, a postgraduate degree
yes
to a doctor that is granted in the United States is to be recognized and allowed for practice in India under the Act.
can we decide that
You know, the Act says that it has to be. The schedule recognizes this degree
yes
that I obtained from a foreign university and I do that course and I come back. The Medical Council of India will have to recognize me as a holder of a postgraduate degree and allow me to practice. So I do my now I'll have to take your lordship through 4 pages only. That I do my MBBS from Nepal. I come back here. The MCI, which is the Medical Council of India, there's a regulatory body under the Act.
yes
They recognize me, give me a certificate. Thereafter, I go to America and I sit for this examination. Manoj, this is United States Medical Licensure Examination. Lordship will just make a note of the abbreviation USMLE.
yes
I pass that, then I undergo a 3-year training program. They issue a certificate where I'm recognized as an MD. With that MD certificate, I get enrolled under South Carolina, under the state, yes, under state South Carolina. I work there. Then I apply, come back to India. They allow me to practice as a doctor, but they don't recognize me as a postgraduate degree holder. And the refusal possibly is contrary to what the Act envisages. You know, there's a refusal by way of an order, which is at page 26. I'll take your lordship to that first, you know, page 26.
yes Twenty-six yes
Yes, Manoj.
yes
This is MCI, Medical Council of India.
Right.
This is in reference, may I, Manoj?
yes yes
This is in reference to your application dated 13 November 2017 and further letter dated 13th March regarding registration of additional qualification under section 26 of the IMC Act. In this regard, this is to inform you that the matter with regard to grant of registration for additional qualification, that is residency training in internal medicine, was considered by the registration equivalence committee for the council as meeting held on so and so. The operative part of the extract of the decision of the committee is reproduced as under. Dr. Agarwal, this is the petitioner, has obtained a certificate of 3 years residency training in internal medicine from Westlake Hospital and has not been awarded any degree in internal medicine by a university. The committee further noted that Dr. Agarwal, by his letter dated 13th March 2018, has confirmed that he has not appeared or has been awarded any certificate from the American Board of Internal Medicine, USA, admitted. In view of the above, the RAC further considered the matter and the committees of the considered view that on the basis of 3 years residency training in internal medicine, the registration of additional qualification, that is residency training in internal medicine, cannot be granted in respect of the petitioner under section 26 of the Act. The aforesaid decision has been approved. So it appears that the reasoning is twofold. One is that I have done a 3-year training program that does not suffice. And second, that I have not got any certificate from American Board of Internal Medicine, USA. Lordship will kindly make a note. This we've checked up and it's in the public domain. This American Board of Internal Medicine, USA is a private body. Its certification has absolutely no validity or a requirement under the law. If I get it, I get it. If I don't get it, I don't get it. It's a private body. It's like a SABYASACHI. It's a private body which gives out the certificate. So somebody who has not passed the examination gets the certificate somehow.
Not recognized by any board of
Nothing.
very well, yes.
Nothing. And I have this literature available on the internet, which we've checked up this morning.
Yes.
And it says it's a private body to practice in America. This is not required at all. Also, what is recognized under the law is a degree that is conferred by a university in America. Certification by a private body is not contemplated by the act or the rules under that.
So where is your university degree?
Yes, this your lordship will kindly now come to page 18 once, just to cross the first hurdle that I am an MBBS. So Medical Council of India registration certificate, your lordship will find the name of the petitioner, disregards that now.
Yes.
Page 19. Internal Medicine Residency Program. Resurrection Medical Center and Westlake Hospital certify that Harshvardhan Agarwal, kindly mark the next two abbreviation, my lord, MD, has completed 3 years of internal medicine residency from June to June. Now, your lordship will just turn over, my lord, to the next page. This is the State Board of Medical Examiners of South Carolina. Name of the petitioner. This certifies that the petitioner MD has practiced in so-and-so surgery within the state and completed all requirements of prescribed by applicable law, the State Board Medical of South Carolina. Now, my lord, so if I did not have page 19, I would not have been an MD.
Mr. Banerjee, what is the system in the USA? I mean, there's a general central body for the entire United States of America.
Yes, my lord,
Or it's a federal structure. There are for states also there is something.
there is a central, like the Supreme Court.
Yes.
And then there are federal, where for a lawyer to practice, he'll have to get for a particular state. Same with a doctor. So the federal one, I mean the central one.
So a person having a degree from South Carolina, he won't be able to practice in other states,
No, the person having a degree with the center undertakes that training.
Yes. Where is your degree from the center in America?
Yes, this your lordship will find. That's why I wanted to show 19.
19 years.
Well, if I did not have this 3-year training program, I would not have been allowed. Now, this program is allowed only after I have passed this examination, which is United States Medical Licensor Examination. This is like the MBBS or the higher that we have in India.
Where do I get that?
Yes, this I'll just show to your lordship. Kindly have a look at this. At the top, your lordship will find United States Medical Licensing Examination.
You have
Students,
not annexed this here.
this is, my lord, this is just to show what this examination is about. And if your lordship, yes, one document should have been a part of it, which is, if your lordship turns over, my lord, to the 4th document of that bunch. Copy আছে? This is Educational Commission for Foreign Medical Graduates, certifies that the petitioner has satisfied all the requirements of the commission, successfully passed his examination, has been awarded this certificate.
But these are for the respondents to consider, Mr. Banerjee.
I agree.
Court cannot assess the strength of these documents.
Yes, my lord, but then they'll
these are
look at these. And this, your lordship will set aside with regard to that private body.
Acha, very well.
That, my lord, and one document allows me to show page 35 and page 46.
Yes.
Page 35
Yes.
is a part of the schedule of the Act. For your lordship's convenience, we've just annexed a schedule.
Yes.
Certificates or diploma of the, sorry.
Indian Medical Council Act.
Yes, my lord. Certificates or diploma of the following approved examining boards of USA.
Right.
Your lordship will come to American Board of Internal Medicine. About 7 from top. This I have. So the consideration appears to be contrary to the Act and their own notification, which also I shall show. So American Board of Internal Medicine, if it grants a degree or a diploma or a certificate, that is more important. No?
Where is the certificate from American Board of Internal Medicine?
No, so no, this, my lord, your lordship will find
Yes.
that I have from that state Carolina.
That is different.
My lord, so this is what is there. Now your lordship will just turn over to 46 once. 46 is the notification of the ministry. Just the last one, my lord. It's probably underlined even in your lordship's.
No, not.
The last paragraph. All postgraduate medical qualification awarded in United States of America and recognized for enrollment as medical practitioners in the concerned specialties in that country. Well, this they can't get out of. If I have that, sir, disregards my entire case. With page 20, I'm recognized now to practice in America as an MD with page 19 and 20. This is the State Board of Medical Examiners. They certify that I have enrolled as and passed as an MD. There's a certification also showing I am an MD. So this all postgraduate medical qualification awarded in United States and this, the last part, recognized for enrollment as medical practitioners. But I agree, Lord, that this is probably an exercise that they might have to undertake again. It will be slightly foolhardy on my part to expect your lordship
for
to
enrollment as medical practitioners. I mean, that part has to be gone into by them.
that has to be gone into. But this requirement, the rest I'll satisfy that. This requirement at page, the impugned order at page 26.
American Board of Internal Medicine.
This I'll be able to show to your lordship is a private body. This cannot be considered again when they look it up, because admittedly I have not done it. But whether this can be a basis for rejection, in otherwise, whether this is a mandatory requirement in America to get this I'll be able to show, my lord, albeit from the
at best, Mr. Banerjee, subject to hearing Mr. Rai, at best we can redirect them to consider these aspects. Your arguments basically, one is that this is a private body. They have to consider whether this is necessary at all. But from here, I won't be saying that it's a private body. I mean, subject to hearing him. So this aspect of the argument has to be considered by them. And also these clauses, the clause at page 46, that has to be considered by them. Vis-a-vis your documents, whatever documents you have produced. Let me hear Mr. Rai on this. Yes, Mr. Rai.
Now, my lord, first, on the point of American Board of Internal Medicine.
Yes.
That is, my lord, a part of the schedule of the Act. So it is recognized. Whether it is private, whether it is government is irrelevant. The law is that if a person gets a degree or a diploma from any institution outside India for the purpose of recognition of that degree or diploma as an additional qualification over and above the graduation, it has to be a part of the schedule of the Act. Now, my lord, what my learned friend is arguing, American Board of Internal Medicine is there in the schedule. But in the writ petition, I do not find any document that this American Board of Internal Medicine has certified that the petitioner has got a postgraduate degree. That's one. Malad, the second point is page 19 and 20. Your Lordship considers again kindly, Malad. First, Malad, kindly take 19. Resurrection Westlake Internal Medicine Residency Program. Page 19.
Yes.
Now, this Resurrection Westlake is not in the schedule. Institute, this is the institute, it's not in the schedule. Second is, Malad, page 20. State Board of Medical Examiners of South Carolina. This is also not in the schedule. So he is not entitled to. Third, Malad, your Lordship will kindly consider. This page 19 is neither a degree nor a diploma. It's a mere certification that he has
Residency program he has done.
program he has attended for 3 years.
Right.
That's all. Now, Malad,
There he has been mentioned as an MD, only that much.
MD, Malad,
Now,
where is that MD degree?
yes, exactly. There's nothing
That
to show. There is-
because the graduation degree is MBBS from Kathmandu, Nepal. That is there in the schedule. So he has been granted registration.
Banerjee's client is probably following the route of Charles Shovraj
Now, Malad, that's one.
through India and all.
The second is that he must have a degree or diploma which is in the schedule. Now, this is neither a degree nor a diploma. It's a mere certification. Secondly, Malad, there is an admission to that effect on his part. Malad, if your Lordship kindly takes, Malad, take page 20, kindly take I have not. There's an admission. Kindly, Malad, give me a moment. But page 25.
Yes.
This is, Malad, a communication from the petitioner to the Assistant Secretary of the Medical Council of India.
Right.
Dated 13 March 2018. This is in reference to your letter dated 12/1/2018 regarding grant of recognition of additional qualification under section 26(1) of the Indian Medical Act. I would like to state that I have not appeared or have been awarded any certificate from the American Board of Internal Medicine. So the submission made here and the admission of the petitioner is contrary to each other.
No, he says that he has not obtained any certificate.
Right. So therefore,
He's not disputed.
Therefore, he does not have a degree or a diploma from a recognized institution. If he does not have it from a recognized institution, he cannot be given that additional qualification or rather recognition of that additional qualification. Now, Malad, this issue has been settled by the division bench, and the division bench has held that a person acquiring a qualification from abroad has no legal right to have that degree recognized in India. Malad, it is an unreported decision of the Honorable Division Bench. Kindly, Malad, have a look at this. But may I just, it's a very short order. Kindly, Malad, may I just read it out? By this intra-court appeal, the petitioner has challenged the order of the learned single judge dated such and such, whereby WPO such and such has been dismissed. The appellant had approached the writ court with the plea that she had passed MBBS successfully and was registered with the West Bengal Medical Council on 4th February 1998 with a permanent registration number such and such. Her further case was that thereafter she had completed postgraduate degree in the year 2007 in obstetrics and gynecology from Ryazan State IP Pavlov Medical University, Russia. Malad, kindly mark that she had a degree. Even then it was not allowed. The appellant had made an application for updation of her postgraduate qualification in registration as medical practitioner. As the same was not accepted, the writ petition was filed. The learned single judge has taken note of the stand of the National Medical Council that Ryazan State IP Pavlov Medical University of the federal agency is not recognized by the National Medical Council. Therefore, question of recognizing any purported post-graduation in obstetrics and gynecology does not arise. Therefore, no relief could be granted to the appellant. Accordingly, the petition has been dismissed. Submission of the learned counsel for the appellant is that the recognition of the said degree should be granted under section 40 of the National Medical Commission Act, since the National Medical Council has committed an error in sending the communication dated 30th September 2021. Learned counsel for the NMC has pointed out that section 40 applies to the recognition of graduation medical degree and has also drawn attention of this court to the proviso to section 40 read with section 15 of the Act, which provides for the national exit test for granting license to practice medicine as a medical practitioner and for enrollment in the state register or the national register. He has also submitted that in terms of section 36 of the National Medical Commission Act 2019, for recognition of a medical qualification granted by a medical institution outside India, the concerned authority of that country is required to make an application to the Commission for granting recognition to such medical qualification. But pausing here for a moment, I only want to stress on that the law is that if a degree or a diploma is to be recognized, the application is to be made by that institute of that country. It cannot be made by an individual. Learned counsel for the State Medical Council has also submitted that postgraduate qualification obtained by the appellant is not recognized by the State Medical Council. Having heard learned counsel for the parties and on perusal of the records, it is noticed that the appellant is trying to set up a new case based on section 40 of the Act, whereas in the writ petition, there was no such pleading or prayer. In Schedule 2 of the Indian Medical Council Act, the recognized medical qualification granted by medical institutes outside India are contained. Undisputedly, the post-graduation qualification obtained by the appellant is not included in the said schedule. Counsel for the appellant also does not dispute that under the 2019 Act, also the postgraduate qualification obtained by the appellant is not covered. That apart, we find substance in the submission of counsel for the NMC that section 40 applies to the basic medical qualification, whereas section 36 provides for recognition of the medical qualification granted by the institution. And kindly see the last paragraph. There is the finding. In view of this, we find no error committed by the learned single judge in dismissing the writ petition, as no legal right has been pointed out by the counsel for the appellant in her favor, which can entitle her to pray for a direction for recognition of the postgraduate degree. Therefore, Malad, in what my learned friend is praying today, that the order be set aside and it be sent back, Malad, will not serve any purpose. The institute from where he has done his residency has to apply, and then Malad, if the council finds that yes, it can be recognized, it will be recognized, he will get benefit of that. But an individual, Malad, has no right. Now, Malad, I must be candid before your lordship. There was a review filed that has also been dismissed. But Malad, today, Malad, I do not have a copy of the review judgment passed by the same bench. Yes, the review has been dismissed. Today, I missed the order.
Since I accept your submission that a review has been filed, I have to take the admission as a whole.
I'm grateful.
I'll consider that it has been dismissed also.
Yes.
Very well. Yes, Mr. Banerjee, what remains?
Just two things, Malad. The problem with appearing against him is he knows all this inside out. And we
no, Malad, it's not that I'm doing these matters regularly. That's the
Yes.
reason why.
Definitely.
Only one thing. Malad, this schedule that I had referred to, and so is the Indian Medical Council, that your lordship will find is appended to the Act. And it's a part of section 13, which schedule B, schedule 4, part 2, schedule 2 or 4, I think. That kindly comes back to page 46. I don't know why, neither was this pointed out before the Honorable Division Bench, nor did the authority look at it while considering my application. They can't get out of this. This is in addition to that, by a notification exercising power under the Act. In exercise of powers conferred under subsection 4 of section 13 of the Indian Medical Council Act, the central government, after consultation with the Medical Council of India, hereby makes the following further amendments in part 2 of the 3rd schedule to the said Act, namely, now restricting me only to that particular examination or certification by that board is possibly contrary to their own amendments now, which is at page 46. This last part has completely failed their consideration.
No, I'm sorry, my lord, I did not answer to this. I'm sorry, it is my mistake. I ought to have answered. No, I ought to have answered it. My lord, kindly read the line. I'll just explain.
This is circumscribed by recognized.
It has to be a qualification and in a speciality. Kindly, my lord, read it. All postgraduate
Its
medical
specialty is doing residencies.
that has to be certified by the authority. Kindly see the certificate once again on page 20.
Internal medicine is also there.
No, it's not there. It is not there. That
Page
is why
20.
I am saying.
Page 20.
Kindly see page
Page 20. The better copy আছে পড়ার জন্য?
19 and 20.
19 is part B of
Alert,
the exam.
page 20, kindly see once.
Yes.
Name of the exam.
State Board of Medical Examiners of South Carolina. License to practice medicine and surgery. License to practice medicine and surgery is MBBS. There has to be, where is your specialization?
The Lordship sees that.
No. You are, my lord, kindly consider this. Kindly consider the language. আমি ওই পার্টটা আনসার দিয়ে দিই তারপর তুই বল। I missed it. I'm sorry.
Yes.
Page 46, if your lordship sees, all postgraduate medical qualification. First of all, my lord, it has to be a qualification. That's why I said, my lord, degree or diploma. Awarded in the United States of America and recognized for enrollment as medical practitioners in concerned specialties in that country. So therefore, it has to be a postgraduate degree or a diploma which is recognized in that particular specialty. But that is not borne out from page 19 and 20.
But page 20 says, Mr. Rai,
Yes.
License to practice medicine and surgery within this state and having complied with all requirements as prescribed by applicable law, State Medical Board of Examiners of South Carolina, under authority granted by acts of the General Assembly of the State of South Carolina,
Yes.
does hereby grant this license.
Yes.
And there he has been described as an MD.
No, true. But where is the specialty mentioned that he is entitled to practice as a specialist in internal medicine? Post-graduation, malad, is specialization. This is MD, malad, your lordship will find from the schedule itself. Malad, it's all MD. If your lordship sees German degrees, French degrees, it's Russian degrees, MD is the basic qualification. It is parallel to or equivalent to MBBS. MD, malad, here we have three sets. One is MBBS, that's graduation. MD is post-graduation and DM is the super specialty. 3 grades. But abroad, malad, the nomenclature is different. Even, malad, the graduation is sometimes called MD. But this relates to postgraduate. Malad, page 46 relates to all postgraduate medical qualification. Your lordship will not find that this is postgraduate. And where is the qualification? It is merely attending a residency program. It is neither a qualification nor a degree nor a diploma. That's the reason why.
Well, I'll pass my order.
Could I just indicate one thing in 30 seconds?
Yes.
Lord, comes back to that page 20, Lord.
Yes.
Name of the petitioner, license to practice medicine and surgery. So the speciality that my learned friend is
That was what I
indicating.
read out.
MBBS is
So
medicine
that
and
is
surgery.
there.
Meghnad,
MBBS is medicine and surgery.
No, that is saying
Counsel-
ICS.
Learned counsel for the petitioner contends that the petitioner's application for recognition of a postgraduate degree obtained in the United States of America has been turned down by the Medical Council of India. Full stop. The writ petitioner challenges the communication in that regard annexed at page 26 of the writ petition. Full stop. In the said communication, comma, the Medical Council of India within bracket MCI, comma, cites primarily 2 reasons for such refusal. Full stop. The first reason is that the petitioner has not appeared or been awarded any certificate from the American Board of Internal Medicine, comma, USA. Full stop. The second reason is that on the basis of 3 years residency training in internal medicine, comma, the registration of additional qualification, that is residency training in internal medicine, cannot be granted in respect of the petitioner under section 26 of the IMC Act, comma, 1956. Full stop. Learned counsel places reliance in particular on the documents annexed at pages 19 and 20 of the writ petition. Full stop. The first is a certificate issued by the Resurrection-Westlake, regarding an internal medicine residency program done by the petitioner upon completion of 3 years of internal medicine residency training. Full stop. In the said certificate, the petitioner has been described as within double inverted M full stop D full stop. Next para. In the second annexed at page 20, the State Board of Medical Examiners of South Carolina certify that the petitioner, who has been described to be an MD again, having complied with all requirements as prescribed by applicable law, has been granted the license to practice medicine and surgery. Full stop. Learned Counsel further places reliance on an amendment notification dated March 7, 2008, issued by the Ministry of Health and Family Welfare, Government of India, which carries out, which introduces an amendment, including the phrase within double inverted, all postgraduate medical qualification awarded in United States of America and recognized for enrollment as medical practitioners in the concerned specialties in that country, double inverted close, to be included within the recognized postdoctoral degrees in India. Full stop. Next para. It is contended by Learned Counsel for the petitioner that the American Board of Internal Medicine USA, is a private body and, as such, non-issuance of any certificate by the said authority to the petitioner is irrelevant for the present purpose and was erroneously relied on by the MCI. Full stop. Next parallel. Learned Counsel appearing for the National Medical Commission Commission places reliance on the certificates and diplomas, which have been appended to the third schedule, part 2 of the Indian Medical Council Act 1956, which specifically includes the American Board of Internal Medicine as one of the recognized institutions, recognized boards of USA. Full stop. It is submitted that thus, non-issuance / award of any certificate by the said board to the petitioner is indeed a germane factor in the present consideration. Full stop. That apart, Learned Counsel submits that there is nothing in the license to practice medicine and surgery issued by the State Board of Medical Examiners of South Carolina, which indicates that the petitioner obtained a postgraduate degree, in the field of specialization as claimed by the petitioner. Full stop. Next para. A perusal of the documents annexed to the writ petition indicates that the petitioner obtained his MBBS degree from Kathmandu, which is not in question in the present matter. Full stop. Next para. More importantly, the State Board of Medical Examiners of South Carolina has certified that the petitioner is licensed to practice medicine and surgery within the state of South Carolina, which is admittedly a state in the United States of America, and, having complied with all requirements as prescribed by within double inverted applicable law, double inverted close, the State Board of Medical Examiners of South Carolina, under authority granted by acts of the General Assembly of the said state, grants the license. Full stop. Next para. Hence, it transpires prima facie that the petitioner has been issued a license to practice medicine and surgery by the State Board of Medical Examiners of South Carolina, which is a valid degree to practice medicine and surgery in at least the said state of the United States of America. Full stop. A closer scrutiny of the amendments notification dated March 7, 2008, issued by the Ministry of Health and Family Welfare, suggests that the same has incorporated as a valid qualification, comma, all postgraduate medical qualifications awarded in the USA and recognized for enrollment as medical practitioners in the concerned specialties in that country. Full stop. Next para. The question whether the petitioner's specialization in the field of internal medicine is germane and or the fact that the petitioner has been granted a license to practice in the specific field of medicine and surgery in a state of the United States of America, comma, with regard to the clause in the 7th March 2008 notification was required to be considered by the MCI while refusing the petitioner the recognition to hold a postgraduate degree in medicine. Full stop. Next para. In the absence of such consideration, comma, the impugned communication and refusal of the petitioner's application for consideration of such degree cannot be sustained. Full stop. Next para. What is to be looked into is whether, comma, despite the petitioner having not obtained a degree from the American Board of Internal Medicine, comma, which is one of the recognized boards in USA, comma, the petitioner comes within the purview of the wider ambit of the expression as incorporated in the notification dated March 7, 2008, comma, which also contemplates all postgraduate medical qualifications awarded in the USA and recognized for enrollment as medical practitioners in the concerned specialties in that country. Full stop. Next para. In such view of the matter, comma, WPA 22821 of 2022 is allowed, comma, thereby setting aside the impugned refusal by the MCI to consider the petitioner's application for being recognized to hold a postgraduate degree in the field of medicine in India, and directing the Medical Council of India.
No, Malad, it will be now the national.
I'm sorry. Directing the respondent number, you are number 2. The respondent number, yes, respondent number 2, comma, the National Medical Commission, comma, to reconsider the petitioner's application for grant of registration of additional qualification under Section 26 of the IMC Act 1956. Full stop. It is expected that such reassessment shall be concluded within a month from date. More than that, within 2 months from date, and the outcome thereof be intimated to the petitioner in writing within a week thereafter.
Now, could I just prefer a hearing before them? Or at least to give additional some.
In the event they feel necessary, Mr. Banerjee. In the event the NMC is of the opinion that the petitioner is required to be heard to clarify any aspect of the petitioner's application or the documents and degrees produced by the petitioner, comma, such a hearing shall be given to the petitioner by the NMC for the purpose of coming to a decision as indicated above.
Very great.
May I make a humble prayer, Malad? Kindly do not take me away.
No.
But kindly refer to the division bench judgment in one
Achha.
line, Malad, otherwise I will
Very,
face
very.
some embarrassment before my client.
আচ্ছা, প্রথমেই একটা লাইন প্যারাগ্রাফ দিন। Learned counsel for the respondent number 2, the NMC takes an objection to the maintainability of the writ petition, comma, since it is argued, comma, on the strength of an unreported division bench judgment of this court dated December 23, 2022, passed in Dr. Boisakhi Pine Roy versus Union of India and others, comma, where the division bench observed that a petitioner claiming to get recognition of a degree conferred by a foreign university does not have any legal right to prefer a writ petition. Full stop. Next para. I have to deal with this also, so I'll add another sentence.
That is the facts and, I'm sorry.
I'll just give one more sentence.
Whatever what you feel.
I'll give one more sentence. Why? Because I
Kindly distinguish it, but.
no, you're right. However, such objection as to maintainability cannot be accepted since the challenge in the present case is not confined to the petitioner's legal right to have recognition of a degree conferred by a foreign university, but the petitioner's legal right based on the notifications of the Medical Council of India itself, which according to the petitioner confers a specific right on the petitioner to have his postgraduate degree recognized in India, even within the contemplation of the prevalent law and regulations in India. Full stop. As such, the writ petition is taken up for hearing.
I'm good.
Very good, sir. I'll take up the next matter after 10 minutes.
The lordship's kindly, may I file the 10 notes in connection with item 2?
All right, since you're saying so, it is a matter. I'll take up the next matter after 10 minutes.
At the very outset, my lord, I am for the respondent, my lord, affidavits, my lord, are complete. So may I pray for a judicial grace of adjournment till next week, lordship, because my lord, 22 matter, it's our 2022. I need some recollect.
week?
Any day next
Yes,
week.
so
lordship.
any day suits both of you.
May I just, my lord, pray on confirmation.
On the prayer of the state, the matter is adjourned till August 29, 2023.
Let it retain its position, my lord. I will, my lord.
Under the same heading.
I will.
Same heading area.
My lord, could I file my affidavit in reply?
Opposition have filed.
Yes,
Everything
opposition they filed.
Already,
If any reply filed today, we kept on.
lordship. Grateful to your lordship.
হ্যাঁ, written it, বললো তো, এখানেই থাকবে।
Yes.
Item 12.
Yes.
Your lordship,
Yes.
item number 12.
My lord, may I file my affidavit in opposition?
Opposition? Yes.
আপনি authority, ROC. Your lordship, there is an order which was passed.
Are you filing any reply, Mr. Sinha?
Yeah, we have filed.
Yes.
We filed with it. Already filed.
Reply before opposition outcome. No.
Number 3.
No, it's not been filed.
I don't think so.
Your lordship, I don't think there is a requirement any of
Very
it.
well. Let us hear.
Yes, there is
Yes,
nothing
that's-
much in this because
Right.
there was already an order passed. Your lordship is in the record on 23rd December 2022. I'll give you a gist of what has happened.
Right.
Basically, this is a charitable association. Though it's called an association, it's a charitable company under Section 8 of the 2013 Companies Act. Under this, it is a law which is there from 1956 Act also. If the amendment, there has to be any kind of amendment in charitable organizations with regard to their articles of association or memorandum of association, there has to be a permission which is required to be taken from the central government. The erstwhile committee which was in charge of this company, I am not going into how they got it done and all that, surreptitiously or whatever. They attempted to get something passed and file it, and it was filed and it was uploaded by the ROC as an amendment without getting this permission. So when this was filed, this petition was filed by saying that this is completely illegal. This entire thing is illegal. So the court came to a conclusion. Your lordship will see in the order that 8(4) under which the permission is required is a mandatory provision, and that is a law, entire gamut of judgments all through from 56. That's a mandatory provision and it cannot be derogated from. So the two filings which are there, that form MGT 14 and GNL1, has to be reconsidered, and it is not correct. How uploading has been correct. Now so we also wanted some extension of time, which was not granted, but anyway, AGM happened within time. All of that has happened. Now today, what we are in situation is, there is nothing left because they in their affidavit have said that they have turned it defective. They have held it defective under the orders and everything. So all that is required left in this matter is to confirm the order, and it is those
Remains, my lord.
nothing remains. Nothing remains. ROC is also here. Nothing remains in this matter anymore. Your lordship will confirm this order and only hold that it has already been held defective, and the earlier one, which was the original.
Stated in paragraph 4,
Four,
my lord, of my affidavit.
yes, the
Of
paragraph
court
4.
that we have acted, marked it defective and not to take in record.
Not to be taken on record. It is there in the paragraph 4. Yes.
So nothing remains, my lord.
They have said so in their affidavit. We don't need to file a reply, your lordship, on this.
So I'll dispose of the writ petition on this.
On this ground, and holding that the original AOA which was there, that will continue to have effect. That is all, your lordship. That is only this much. There's nothing left in this writ petition in
the original articles.
Original articles which was there, that would continue to hold sway, because they themselves have rejected it now, and so there is no question of anything like that.
The writ petition itself, as rightly contended by learned counsel for the parties, has spent its force in view of the ROC, in the meantime, having considered the matter and marked defective the E form MGT-14 filed vide SRN-T 99254823 and E-Form GNL-1 filed vide SRN space F01722982 having been marked as NTBR within bracket not to be taken on record, bracket closed, full stop. Hence, comma, the effect is that the original articles of the company, petitioner number one company,
Yes.
of the petitioner number one company remains, full stop. With such observations, comma, nothing remains to be adjudicated further in the present writ petition. Full stop. Accordingly, WPA 25922 of 2022 is disposed of as infructuous in the light of the above observations. No address to cause.
Your lordship will not say.
Affidavit in opposition filed today be kept
Your
on
lordship may not say infractions in terms of the offer order.
disposed of very as infructuous kotara bad diye. Disposed of in the light of the above observations.
Much
Very,
obliged.
thank you.
Much
Everything in opposition, my lord, may be
Yeah,
kept.
that is the first line which I have incorporated. Thank you.
much obliged.
Thank you.
13,
Yes.
My lord, innocuous prayer at the time of mentionment.
Innocuous prayer that the petition be allowed.
Yeah, no. It should be directed to consider because some unauthorized and unlicensed sawmills are.
What about service here?
My lord,
Good service has been affected.
good, well, it was the chief conservative officer, he is the real authority.
But where is the representation?
Is 73. Well, earlier the petitioners themselves filed. Then, my lord, page 73, I requested the authority, a series of complaints have been made, you decide. Last 3 pages.
Service has not been completed actually.
But they have, my lord, a series of, my lord, AD cards I have got bar karo. They have received. So all
Etiquettes
these-
have not been annexed here.
but that I have. Only, my lord, they should consider.
Very well. The affidavit of service filed today be kept on record. File the AD cards also.
দিয়ে দাও সবগুলো।
Please just staple them and staple
আমাকে
করে রেখে দিও.
দিন আমি মেরে দিচ্ছি।
The affidavit in opposition as well as the acknowledgement due cards which have returned be kept on record. Full stop. In view of the innocuous nature of the prayer, no further service is being directed. Full stop. The petitioner seeks a consideration of the representation of the petitioner annexed at page 73 of the writ petition by which respondent?
My lord, the principal chief conservator of forest, he is the main.
By respondent number 4. Full stop. Accordingly, WPA 26995 of 2022 is disposed of by directing respondent number 4 to consider and dispose of the representation dated October 31, 2022 made by the writ petitioner, comma, if necessary, comma, giving the writ petitioner a hearing in that regard. Full stop. After such consideration, comma, which is expected to be done within 1 month from date, comma, the outcome of the same shall be communicated in writing to the writ petitioner by the respondent number 4. Full stop. It is made clear that the merits of the representation have not been gone into by this court. Full stop. No address to cause.
Series of unauthorized and unlicensed sawmills are running. We have raised objections that you would close it.
Fair enough.
So, yes. Other officials are also there.
So they can also give you a hearing if they feel less.
Kindly indicate that, my lord.
I have indicated.
Yes, I am grateful. My
item
At the
14,
time of mention, I mentioned that it is innocuous.
Yes.
14,
Lordship, in this matter, I am for the petitioner.
So,
Right.
I am
The
grateful, my lord.
petitioner is the sole proprietor of Malda.
What about service?
Yes, Your Lordship. On the earlier.
Good service has been affected. Have you checked up?
Your
This is
Lordship,
not service. Affidavit of service has to be filed.
on the
Why did you have it upgraded?
because the hospital is closed down.
You should
to
be
the-
prepared with an affidavit of service, ma'am.
Yes, Your Lordship, but I just give them the postal receipt is there, but
Postal receipt is not good service. You have to serve them first. I cannot take up the matter. I'll take it up next week. I'll keep it next week. File an affidavit of service. Since the affidavit of service is not ready in the matter, comma, the same is adjourned till August 31, 2023, when it will be listed under the same heading. It will remain in the upgraded list, but on 31st,
31st,
next Thursday.
much okay.
Please come prepared with the affidavit of service. Please give your name, give your name, give your name.
15,
I appear for the petitioner, your lordship.
Section 14.
Lordship, service is complete.
I'll start refusing this. The banks are pouncing upon the poor borrowers.
Your lordship.
One after another matter.
They are not the poor borrowers.
The rich borrowers.
Lordship, this
Anyway,
is, has.
so how long is the application pending?
1st April 2022, more than a year, your lordship.
Learned counsel for the petitioner bank submits that the petitioner's application under section 14 of the SABYASACHI Act 2002 is pending since April 1, 2022. Since the petitioner is justified in arguing that the statutory outer limit of 60 days is long over, comma, WPA 3029 of 2023 is disposed of by directing the respondent number 2, that is the district magistrate, North 24 Parganas, to dispose of the petitioner's application under section 14 of the SABYASACHI Act 2002 as expeditiously as possible, comma, positively within 3 weeks from the date of communication of this order to the respondent number 2. Affidavit of size filed today be kept on record. প্রথমে লিখে নিও, আরেকটা লাইন লিখো, despite service none appears for the respondents. Thank you.
16,
Similar matter, your lordship, all party has. been
Filed on section 14 filed on
In March 2022, your lordship.
আচ্ছা on April 1 2022 বদলে in March 2022 filing date টা বাকি সব same. Good service you have checked up.
Lordship, I have checked. Everybody has been.
Yes. Yes.
17,
Yes,
Please, Lord,
Sabah,
I'm
what is
appearing
it?
for respondent number 5 in the.
Respondent,
I am
yes,
appearing for respondent 6.
6, right.
My lord, I am appearing for the petitioner, my lord.
Yes. What is the matter, please?
My lord, the learned advocate is on virtual mode, my lord.
Why?
My lord, due to some professional work, she went to Delhi, my lord.
Let her come back.
She's appearing virtually, my lord.
My lord, if I may, I had to come to Delhi on some professional work. May I be allowed
Yes,
to?
what is the matter? What is the matter? Please move the matter. Right.
My lord, this is, I am appearing for the petitioner. The affidavit of service has been effected. It is a good service.
Yes.
My junior colleague will present it before you.
Right.
My lord, this is a sensitive issue, one which is actually almost cinematic. The petitioner was adopted about 35 years ago when he was about a year old by a Swiss couple. This was in 1988, which was even prior to the framing of the adoption regulations under the JJ Act. And in fact, even prior to the adoption of the Convention on the Rights of the Child, which came in 92, and the Hague Convention, which was adopted in 93. The adoption, my lord, was effected in terms of the guidelines framed under the Lakshmikant Pandey judgment, which is part of the petition. This was delivered by the Honorable Supreme Court in 1985. I will come to the legal conspectus in a bit, your lordship. The factual matrix is that for the past few years, the petitioner as an adoptee has been in search for his biological parents without much success. And he has himself, as well as through his constituted attorney, have written to the respondent authorities and private respondents seeking a copy of the surrender deed or the relinquishment deed of his biological mother in order to be able to search his mother. It is my humble submission, my lord, that an older adoptee has a right to know his roots or biological parents, and the onus to facilitate this root search is on the respondent authorities. There have been several
legal bar. Is there any legal bar?
There is no legal bar. The right is in fact inscribed in the Child Rights Convention and the Hague Convention on intra-country adoption, and the manner in which this may be done is encoded in the adoption regulations framed under the JJ Act. The adoption regulations, my lord, encapsulates the essence of the Lakshmikant Pandey judgment. My lord, my junior colleague has a copy of the Juvenile Justice Act, and the adoption regulations are available from page 289. So, my lord, if I may.
Yes, please.
So the
adoption regulations, actually, they encapsulate the essence of the Lakshmikant Pandey judgment. I will refer to the Lakshmikant Pandey judgment in some time. The legal framework, as I understand, is thus this, that when the biological parents decide to give up or surrender a child, they have to do so by drawing up a surrender deed in favor of the specialized adoption agency. The surrender deed is then produced before the learned court, which is in exercise of his jurisdiction under Section 10 of the Guardians and Wards Act. And then the adoption is effected. There is a scrutinizing process, and a scrutinizing agent is also appointed by the learned court. My lord, what has happened here is this, that in 1988, the adoption was effected. And when the adoption was effected, there had to be a surrender deed. Now, the surrender deed, the petitioner has been writing through himself as well as through his learned, through his constituted attorney for the surrender deed, and requesting the respondent authority to facilitate the root search process. What has come up before the respondent, before the petitioner, is that there has been a series of refusal to share the surrender deed or share any information about the information about biological mother to the constituted attorney. And then finally, the State Adoption Resource Authority, who's the respondent, one of the respondent authorities, had asked the petitioner's constituted attorney to ask the petitioner to write himself to SARA. And he did so, and this is available on page 80 of the petition, my lord. And even after that, there has been no response. The only response that has come from the private respondent, who has washed their hands off and said that you go to the court, we surrendered, we gave a surrender deed there, furnished a surrender deed there, and it should be available on the record of the court. The entire court record has been produced by way of obtaining a certified copy, my lord, and there has been no surrender deed there. However, the court records, your lordship, mention that this is page 68 and 72, that the mother was an unmarried mother. So which means that there has to be a surrender deed which was effected because the mother gave up the child in adoption. My prayer is very limited, my lord. A bare look at the adoption regulations. This regulation 31T in particular, 31, my mistake, my lord, 31G. There is an onus. This is page 316.
Yes.
There is an onus on the authorized adoption agency. This is talking about the foreign adoption agency. This applies squarely to there is something very similar for Indian adoption agency as well. So page, my lord, my mistake, page 311. This is regulation 31T.
Yes.
311 and then 312. It starts from 311. It is on 312. The title is Function of Specialized Adoption Agency, Function Towards Children. So function towards children under 31T includes the function, facilitating root search by adoptees in the manner as provided under Regulation 47. Then, my lord, there is 30 clause 2C for surrendering parents, and Regulation 30 clause 3C7 for adoptive parents. Again, these functions towards biological parents and function towards adoptive parents for root search are mentioned, and the onus is squarely on the specialized adoption agency. Now, my lord, coming to root search provision, which is part of section 47, my apologies, the regulation 47.
Yes.
Root 47.1, if the biological parents at the time of surrender of the child have specifically requested anonymity, then the consent in writing of the biological parents shall be taken by the specialized adoption agency or the district child protection unit, as the case may be, before divulging information. We have no way to understand whether this exists because there is no surrender deed on record. Clause 2, in cases of root search by older adoptees, the agencies or authorities concerned, that is the authorized foreign adoption agency, central authority, Indian diplomatic mission authority, state adoption resource agency or district child protection unit or specialized adoption agency, whenever contacted by any adoptee, shall facilitate their root search. This is the most significant part and point, my lords. Number 3, persons above 18 years can apply independently online, while children below 18 years shall apply jointly with their adoptive parents to the authority seeking facilitation of root search. My lord, there is I believe this question may come from your lordship that there is clause, there's a sub-regulation 5, a root search by a third party shall not be permitted, and the agencies or authorities concerned shall not make any information public relating to biological parents, adoptive parents, or adopted child, because your lordship might rightfully ask that this is being done by a constituted attorney, and therefore there is this bar applies. My lord, this has been clarified by the Bombay High Court in Beena Makhijani Mueller versus the Commissioner. My junior colleague has a copy of that judgment. The Bombay High Court has stated categorically, this is available in paragraph 6 and 7, that the bar, regulation, sub-regulation 547 clause 5 bar, that is lifted when the person, when the adoptee himself or herself is appointing a third party. In fact, in this particular judgment, the constituted attorney was the same person who's the constituted attorney in this particular case, and this is what she specializes in. She runs her own organization, and she has been connecting older adoptees with their biological parents, and she does this in a very discreet manner, honoring the privacy of the biological parents as well. My lord, my only request, my submission and my humble prayer before your lordship is that notice may be issued in terms of my prayers, which is available page 18 onwards. And the respondent authorities, they may, we have already served the petition, the affidavit of service is in place. A notice may be issued so that the petitioner may be successful in finding and tracing his parent. My lord, if you would like, I can place the convention, the Child Rights Convention and the Hague Convention before you as well. My junior colleague has a copy of both, because Article 7 of the Child Rights Convention and Article 30 of the Hague Convention categorically provide that there.
Ma'am, since we have specific statutes now, so these have been incorporated into the statute also, and you have placed regulation 46 as well. So we have, you have a statutory right now subject to this.
Absolutely, certainly.
Incorporated in the law. So let us not waste time on that, unless necessary. So let us what the respondents say first. Yes. You are for the?
I am appearing for Indian Society for Rehabilitation of Children.
What is your stand on the matter?
My stand, I've taken instruction. First of all, I must submit it's a very sensitive matter, and it is not an adversarial litigation. I'm trying to assist the court, my lord. My lord, I have first taken instruction before I go into the merits and the law, my lord. I've taken instruction whether it is at all available. My lord, we can, my lord, make out a, my lord, not a precedent, but my lord, if it is required, we can, my lord, try and assist. But I was told, that the then secretary is no longer there, and these records are not available. That's the first instruction I've taken.
That is the first instruction you always get in old matters, but you have to pursue this.
That is my instruction.
35-year-old. Otherwise, there would be no case in which the older adopted.
Also, I also tried and
they have to have some.
I tried to search whether there is a law, which mandates this authority whom I am representing to maintain the records for a specific period of time. I could not find any, my lord. There is no law. I could not find any. Now, my lord, rule, this is a very sensitive, because, my lord, it's two facets of Article 21. That was my first reading of the papers, my lord, that it is a right to know by the child, and, my lord, the right of privacy of the biological parents. That, my lord, finds, my lord, incorporation in...
We shall not override the right of the biological parents to have their privacy. that I won't override. Section 47(1) is there. But in the first place, you have to say that it is there. I mean, she says that he has not found, the petition has not found anything to show that there was any surrender deed at all.
But kindly see 47(4) and 47(6). 47(4) may I read out, my lord?
Yes.
In case of denial by the biological parents, I'm not on that part, the second part, or non-traceability of the parents in surrendered cases. The reasons and the circumstances under which the information is not being made available shall be disclosed to the adoptee. That's one, my lord. And sub-regulation 6, the right of an adopted child shall not infringe the right to privacy of the
That is always there. That is always there. That has to be protected, definitely.
Because today, if not, it's a general, I won't say it's a general order, but not an order with that we have to disclose. First of all, the records are not available. That is my first
We cannot direct you to disclose if there is a clause there's a rider in the surrender deed that yes, she or he, the parent, the biological parent wants a privacy. Then we probably cannot override that, being a court of law. But here there is nothing from your end to say that it is there at all. Even if it is there, you can take her consent or his consent and disclose it.
Yes,
because so it's not a question of their privacy here. In the first place, you have to disclose the documents at least.
My instruction in my lord that this document is not available. I'll again kindly give me some time to come back. I'll again try and persuade and know, my lord, whether it is at all available. Because then, my lord, I do not want to go into the other nitty-gritties. It's not required, my lord. I want to make this over if it is available.
I'll direct you to file a report then on this.
Lord, kindly.
On this, indicating the location, whether the records are available. Even if the records are available, I'll also put that. You will also put that in your report whether there is any restriction from the end of the biological parent to disclose the identity.
We'll do so.
Both you will disclose in the report.
We'll do
the moment the report is filed, but do it within a reasonable. What will be a reasonable period, Mr. Bag? I mean,
my lord, any time.
Any period you won't be able to do it then.
Yes, my lord.
What will be a reasonable period for you?
Fortnight, my lord.
Fortnight is sufficiently reasonable. Yes, ma'am, we'll direct them to do it file a report within a fortnight. There will be two aspects of the report. One is that they'll disclose whether the records are available, they could trace out the records. And second, if it could be traced out, whether there is any clause. Biological.
Grateful. My lord, just one small submission that I intend to make is that since this was at a time when the adoption regulation was not around, the regulation came much later, the Lakshmikant Pandey judgment, categorically, there is an onus on the specialized adoption agency. Even in the Lakshmikant Pandey judgment, this is available para 14 onwards, where the specialized adoption agencies are required to preserve the surrender deeds. So it is not like it is not a situation that suddenly the adoption regulation have come into force and the older documents are not traceable.
One difficulty might come your way. I mean, the difficulty being that yes, you're right on that they should preserve it. That is the rider of Lakshmikant. But the difficulty is after the 22 regulations. Yes, 22 regulations have come in force. Now, since they have to disclose now, these regulations, it is arguable whether these regulations are applicable now as of present.
Indeed.
That is one of the questions which, if it's intended to be adversarial by them, that will be one of the issues which the court can answer at any point of time.
Indeed.
But now, for the time being, let us have that report. I mean, what they say.
Yes.
If the records are physically not available, then we will have to think of other things. I mean, you may be entitled to damages, but that won't solve your issue.
No, I understand. I understand. I think a report is.
Learned counsel.
May I please submit this, my lord? As of now,
yes.
Otherwise, if it is adversarial, I'll try and indicate why Lakshmikant.
So as of now, it is not adversarial.
Yes, and also that we had applied before the court. I'll make that submission on the next day.
Yes, adoption Act 8 application is there.
Yes,
I did not go into it in deliberations.
Yes. I don't want to
what
go
happened
there right
there?
now.
It was refused.
My lord, it was not disclosed, my lord. It was still, my lord, because kindly see page 67 is that petition, my lord. And
yes, I saw there was an Act 8 application and all.
Yes, my lord, and it was, my lord,
happened
considered and, my lord, the same effect that it was not available. But we tried our, my lord, best to have it with us so that.
Then this will meet with the same fate.
Yes, my lord. And it is not really, my lord, I'll also indicate the next day because it is fallen from your lordship that they'll be entitled to damages. My lord, whether there is a law which specifically requires us to do this, then we are in breach of that contract. And then we are, I'll argue that. But before doing, before going into anything, I want to come back.
The petitioner has raised an arguable question as to whether, in terms of the ratio laid down in Lakshmikant Pandey versus Union of India, reported at 1984 to SCC 244, read in the spirit of the governing international treaties and resolutions, in the context of the adoption regulations, 2022, the petitioner has a right to know regarding her biological parents. Full stop, next para. In the facts of the present case, a Swiss couple adopted the petitioner as long back as in the year 1988. Full stop, being an older adoptee, the petitioner now seeks to know the whereabouts of his biological parents. Full stop. The petitioner, for such purpose, has engaged a constituted attorney. Full stop. It is submitted that it has been held by the division bench of the Bombay High Court in the unreported judgment of Bina within bracket Lina bracket closed Makhijani Muller. এখান থেকে দেখে নামটা করে দিন। Delivered on October 9, 2019, that within the contemplation of regulation 44 within bracket 6 of the 2022 regulations, a constituted attorney of the adopted person himself or herself cannot be treated to be a stranger within the contemplation of the said provision. Full stop, next para. However, the petitioner's endeavor to get the whereabouts of her parents, biological parents, did not fructify till date. Full stop, next para. Learned counsel appearing for respondent number 5. Right. Respondent number 5 submits that the respondent number 5 has not yet been able to trace out the concerned records regarding the petitioner's adoption. Full stop. However, the said respondent assures court that that it will make all efforts to trace out the records. Full stop. Accordingly, before passing any substantial orders in the writ petition, which is, as yet, not adversarial in nature as such, the respondent number 5 is directed to file a report on the next returnable date, indicating whether the records of the adoption of the petitioner could be traced out. Full stop. In the said report, in the event the said records are traced out, the respondent number 5 shall also indicate as to whether there is any specific clause in the surrender deed or other corresponding document, where the biological parents have specifically requested their privacy to be maintained. Full stop. Next para. An advance copy of the said report shall be served on the learned advocate on record for the petitioner before the next returnable date. Full stop. The matter shall next be listed on September 12, 2023 under the heading upgraded matters for passing further orders and for filing of the report.
I'm deeply obliged.
Please come back on 12th of September.
Very deep.
Grateful.
Next.
I
beg to appear for the petitioner, Your Lordship.
Yes.
I'm for the respondent.
Both the respondents.
No, affidavit.
Respond Union of India, my lord.
Achha, regional passport office.
All covers.
Basically that, yes.
Yes.
What is your grievance?
Your
Passport
Lordship,
seized.
No, not seized, Your Lordship.
Not granted.
No, Your Lordship, my passport expired in 2016, Your Lordship, and I applied for renewal on the 2nd of August 2022. And since then, Your Lordship, the application is pending. Your Lordship, the major reason that has been given for me that in 2007, I was charged under Section 354 of the Indian Penal Code. And since then, Your Lordship, the proceeding is continuing. In 2013, the trial started, and so far it is continuing. The next date is tomorrow, Your Lordship, kept for evidence. The trial has not yet concluded, Your Lordship. And the primary reason why I'm seeking for renewal of my passport is that, Your Lordship, my daughter is studying in abroad, pursuing her higher studies. And on several occasions, she has asked me to come to her and see her. And that is why I'm seeking the renewal of my passport.
Daughter is studying where?
In Sweden right now.
In?
Sweden.
Sweden. What is this? I mean, she's doing her graduation or what?
MS, Master of Science.
MS. There is no occasion as such.
Lordship, but
Convocation or something, but no occasion as such.
no, but
Just to see her studying.
no, sir, Lordship, she has insisted me to come on. I don't know what is the problem, but she asked me to come on. Lordship, since 2007,
Anyway, on other grounds also. So where is the bar? In the Passport Act, there is a bar.
Your Lordship, in Section 6, subsection 2, clause F, it says about issuance of passport or travel of document. I'm seeking for renewal of passport. The question, if the question arises about
Why doesn't the same principle apply? Issuance and renewal.
Lordship, it is my understanding that I think that is it is different.
Yes.
Subject to correction. Lordship, my passport expired in 2016. The trial started in 2013. I have appeared. I am on bail. If the question of running away from the land of the law arises, I would have tried to at least do that beforehand. But since it is an urgency that I have to visit my daughter,
Do you have a copy of the Passport Act?
Yes. 62F.
Thank you. 62F. পাসপোর্ট একটা আছে, এটা একটু ফেরত দিয়ে দাও তো। আছে? এটা ফেরত দিয়ে দাও। Where is the provision for renewal? Let me hear them, because I'll come back to you in reply. Where is the provision for renewal? Is there any other provision? Let us check that out. Duration is Section 7 and extension of period of passport. Yes, Section 8 is very clear. In your favor, I mean, in the respondent's favor. The provisions of this act apply to such extension as they apply to the issue thereof.
And my lord, there is an exemption, my lord. Or my lord, I can say, my lord, the 62F, my lord, there is an exemption in a my lord, Gazette notification, which says that he can approach the concerned court and seeking permission.
Yes, that is always there.
Lord, you kindly consider, my lord, this exemption, my lord. If we can, the concerned court can permit him, my lord, we have no my lord, objection to grant, my lord, or to renew the passport.
In the lookout circulars also similar provision
Yes,
is
my lord,
there.
similar provision. But kindly consider B and C.
Yes, I'll grant you that liberty is right.
Lordship,
You can approach the session or wherever you the criminal court where you might.
Lordship, on 11th of August 2023, in WPN number 14132 of 2023, Your Lordship, similar matter was heard before Your Lordship. Yeah. Worship, there's a certain similarity in this case also in my case. The petitioner herein is a 21-year-old lady. She was accused or she was indicted in a criminal case on allegation she had abetted suicide of a young boy. Your Lordship, the only difference is that she approached the lower court below for no objection certificate, for no objection application.
That is the procedure.
Your Lordship, I am here seeking just renewal of my passport, and I shall also pray before Your Lordship for granting me liberty to apply for an application seeking permission to travel abroad.
That liberty I'll give you. In any event, I have to give you. But the other part, I cannot usurp the jurisdiction of the jurisdictional court. That I cannot. And I would not also.
Your Lordship, but just my, I'm sorry for my junior member of the bar, but I'm just seeking, Your Lordship, that renewal of passport will not automatically allow me to travel abroad. Then there's a further procedure, application of visa, and then there's ticket. And Your Lordship, I shall also, I'm submitting, Your Lordship, that if the
Section 2F, according to me, is applicable to a renewal also. Dispel that notion. Because of section 8 also. Because 8 applies the provision regarding issuance of a passport to extension also. So the same principle should be incorporated here also, which is quite natural. I mean, logical.
That one submission, Lordship. If Your Lordship is pleased to allow renewal of my passport, I shall file an undertaking along with an affidavit that I shall submit my passport.
Go to the jurisdictional court and apply for that. It's for the criminal court to decide what is the stage of the trial or all other.
Your Lordship, the next date is tomorrow for evidence, and it is going on for 10 years. Last 10 years, it's not reached.
Then I'll immediately pass my order so that you can go tomorrow and make that application. Actually, that. I mean, I'm not joking with you. Do that. Learned counsel for the petitioner contends that the petitioner had a valid passport which expired in the year 2016. Full stop. In the meantime, the petitioner was accused in a proceeding for an offense under Section 354 of the Indian Penal Code primarily. Full stop. Trial in that regard is still pending and has not yet been concluded. Full stop. When the petitioner's passport fell for renewal, the petitioner was not granted such renewal on the ground of pendency of the criminal proceeding. Full stop. It is argued that Section 6 within bracket 2 of the Passports Act is relevant only in the context of issuance of a fresh passport. Full stop. The petitioner, however, was already the holder of a valid passport, and the present question pertains only to renewal. Full stop. As such, it is submitted that the petitioner is required to go abroad to meet his daughter, who is pursuing her higher studies in Sweden. In Sweden. Full stop. Next para. Learned counsel appearing for the petitioner also cites an unreported judgment of this court delivered on August 11, 2023 in WPA 14132 of 2023 in support of his contentions. Full stop. Next para. Learned counsel appearing for the respondent authorities places reliance on Section 6 within bracket 2 within bracket small f of the Passports Act, 1967, and submits that the same debars the issuance of passports in the event any proceedings in respect of an offense alleged to have been committed by the applicant is pending before a criminal court in India. Full stop. It is argued that the same principle is also applicable for renewal / issuance of a fresh passport. Full stop. Next para. Upon hearing learned counsel, Section 6 within bracket 2 within bracket small f clearly stipulates that no passport can be issued to an applicant, criminal proceedings with regard to whom are pending before a criminal court in India. Full stop. Next para. A comprehensive perusal of the Passports Act indicates that the duration of passports and travel documents has been mentioned in Section 7, which indicates that a passport shall continue in force for such period as may be prescribed. Full stop. Next para. Section 8 deals with extension of period of passport and, inter alia, provides that the provisions of the Act shall apply to such extension as they apply to the issue thereof. full stop, next para, as such, comma, in the present case, comma, there is no justification for not applying the bar as stipulated in section 6 within bracket 2 of the 1967 Act, even to renewal of passport or grant of fresh passport to the petitioner. Full stop, next para. Hence, comma, the remedy of the petitioner does not lie in this court, but, comma, pursuant to a notification of the Ministry of External Affairs, comma, Union of India, dated August 25, 1993, comma, which has been fairly cited by learned counsel for the respondents, comma, which provides for an application before the jurisdictional court in seizing of the criminal proceeding against the applicant. Full stop. In certain circumstances, as stipulated therein, comma, the said court can permit the petitioner to travel. Full stop. Borrowing the said principle, comma, in the present case, comma, the petitioner is entitled to move the jurisdictional criminal court where the criminal proceeding against him is pending, comma, for the purpose of getting permission to travel abroad, full stop. Upon such permission being granted, comma, there will be no fetter within the contemplation of section 6 within bracket 2 within bracket small f to renew the passport of the petitioner. Full stop, next para. However, comma, insofar as the judgment cited by the petitioner is concerned, comma, the same was in different factual circumstances, comma, where the applicant had actually applied before the additional sessions judge, comma, where the criminal case against the applicant was pending, full stop. While disposing of the said writ petition, comma, this court had observed that this court had directed the additional sessions judge, comma, who was in seizing of such criminal case, comma, to immediately grant a no objection to the petitioner in the context as specified therein. Full stop. Next para. As such, comma, the facts of the said case are entirely distinguishable from the present case, and as such, comma, the ratio therein cannot be imported in the present case. Full stop. Be that as it may, comma, in view of the above discussions, WPA 4017 of 2023 is disposed of by granting the petitioner liberty to approach the jurisdictional criminal court where the petitioners where the criminal proceeding against the petitioner is now pending for permission to leave for abroad, full stop. Upon such permission being granted by the said jurisdictional court, comma, if the said jurisdictional court so deems fit in accordance with law, comma, the petitioner will be entitled to immediately approach the respondent number 2 for renewal of his passport, full stop. If so approached, comma, the respondent number 2 shall consider such renewal and, comma, subject to compliance of all other formalities by the petitioner, comma, renew the same as required in as contemplated in law. No rest to cause urgency. Arekta line add kore daw, all concerned shall act on the communication of the learned advocate for the petitioner for the purpose of compliance of the same. This is to facilitate so that the criminal court takes up your matter.
Grateful.
Mr. Bhattacharya, I am keeping this on record. Thank you for this. Yes.
I am for the petitioner.
Yes.
The beg to appear with the state respondent.
A primary teachers training institute is before lordship. 2018, its initial constitution of management. 2013, it got recognition from the NCRT. Now, 2016, there is a change of management reported to the NCT. That was 2016.
Yes.
Reported to them all NCRT. Now they paid for certain clarification. That was also given. Ultimately, that was accepted by them by way of resolution. Now, but the present management, they got missing 2 security deposit because those are required to keep for getting recognition and extension of the recognition. We lost a GD, kindly come to page 30. With the police authority, that these two reserve fund security deposit, one is of 5 lakh, another is of 3 lakhs, those are missing. This is dated 24th of January 2022. Now, on next page, 27th April 2022, we make an application before them, kindly issue a duplicate copy. But kindly turns to page 35. I'm sorry, my lord. While all these things were going on, page 41. The erstwhile secretary, who was from 2011, but after reconstitution in 2016, is no more there, and that has been accepted. 27th of April 2022, using the letterhead of this institution, claiming himself as the secretary, he raised objection before the police authority. Laws and FIR. Police entertained the same. Police seized those documents from him because he was in possession of that. Now, my lord, the last occasion, my learned senior friend, my lord, submitted before this court, police, after getting receipt of the same, returned back to the complainant. So fact remains, a person who was removed from the post in 2016. He lost FIR in 2022, claiming himself as the secretary. And for that reason, the present management are not being allowed to renew the fixed deposit. We are not getting duplicate copy, and we are not being allowed to, my lord, operate our current account, which we are maintaining in the UCO Bank.
Here, he was not acting as a secretary of your concern.
Yes.
When he made that objection. This is regarding a criminal allegation against him.
No, he claiming himself as the secretary.
Suppose he's not a secretary. Even as an individual, he can raise an objection.
He can raise an objection.
He can say that that is a forged document. Why not?
No.
And he was there at the relevant point of time when the those certificates were issued, securities were issued.
He's saying we have withdrawn money. Those are things. That's a different. Then let that be continued.
We will continue after the recess.
Yes,
I'll continue.
For the petitioner. Kindly come to page 26 once. I will show only 4 documents to your lordship. Page 26, dated 3rd of April 2017, clarification to the regional officer,
Yes.
NCT. Now there we have said the bottom portion, in terms of 14th September 2011, that was our managing committee. Now Abu Tahir Khan, he was the president. Rafiqul Ali Khan, he was the secretary. Now, next page 27, continuation of that letter clarification. In terms of 2016, this is our latest constitution. Now, Moriam Bibi president, Abu Tahir Khan is the secretary, and your lordship will not get the name of that Rafiqul. He's not in the managing committee anymore. And this change that has been accepted by the NCT, page 28, relevant portion is at page 29. Middle portion, bold, in view of the above, the committee decides under change of governing body of the management of institution is accepted and noted. Now, this is of 18 February 2018, page 28. Now, when we don't get our original FD of the institution, now we lost the GT, page 30.
You didn't get means you lost it, I mean.
That was not available in our office record.
Yes.
That's why we lost this, page 30.
Right.
And page 31, we requested them issue a duplicate copy of the fixed deposit. Now, the FIR, as has been lodged against the present petitioner, page 41. Now, what is the contention of that FIR? He's claiming, Odhiner Binito Nivedon, page 41, Malor, Ami Rafiq Ali Khan, Peter Swanso, Sompadok of SAK Primary Teachers Training Institute. He's claiming himself as Sompadok. ঘাটালের ইউকো ব্যাংকে প্রতিষ্ঠানের নামে একটি কারেন্ট অ্যাকাউন্ট আছে নাম্বার সোয়েনসো, যেটি জয়েন্ট অপারেটর আমি ও গোপাল পাল ট্রেজারার হলেও এই অ্যাকাউন্ট থেকে টাকা লেনদেন সম্পূর্ণ অধিকার কর্তৃপক্ষ রেজলিউশন করে আমার উপর দিয়েছে। আমি ব্যাংক মারফত গতকাল জানতে পারি সভাপতি আবু তাহের খাঁ আমার নাম আমাকে না জানিয়ে এবং আমার সহিজাল করে গত 20/9/2029 তারিখে এত টাকা তুলে নেয়। When this is lost, 20th of September 2018 is the date of allegation, when he was no more in the committee itself. So he cannot operate the bank account. This is the allegation. And for this reason, he submitted, police come for seizure, he submitted the 2 FD, original FD, which he had. He was possessing, my lord. After taking receipt of that, police return it back to the Rafiqul. This is one aspect. I am before lordship for 2 reasons. Let the bank allow us to operate our bank account, the current account, as well as, my lord, let there be direction so that we can operate, renew, and, my lord, get a duplicate copy so that we can produce it before the NCT, because for extension of our recognition purpose, that's needed.
No, the difficulty is here. Is there any criminal case pending against you?
Yes, yes.
On the allegation of
this.
What is the stage of that criminal? What is the stage of that criminal proceeding?
No charge sheet has yet been filed. We have obtained an anticipatory bail.
But if there's a criminal case pending in respect of the specific that document, that whatever this was,
one current account,
not current account, the other thing,
to the fixed deposit.
It was a fixed deposit certificate sort of thing.
Yes, yes. One is of
a specific criminal case going on regarding that certificate. It's not a case where it has been located. It is with somebody. There is a dispute regarding whether it was issued. I mean, now you say he was no longer there. Yes, very well, I can appreciate that. But since it has been located, where is the question of issuing a duplicate again?
So we must get access to the account because we have to operate it.
Page 42, my lord. I'm appearing for the bank.
No, I'll come to you. Yes, this is all.
That's
yes, you are for the bank. I'll come back to you, Mr.
Lordship.
42 years.
Page 42.
Take up page 42, your lord.
42 and there, yes.
FD is, my lord, season list, item number 5. FDR regarding such and such SK primary teachers training institute for rupees 5 lakhs and 3 lakhs.
Oh, that has been seized by the
That
court.
is seized by the police authority.
Police, yes.
And last occasion quoted by Mr. Gali, that has been returned back to him.
Take it, yes.
But on, it was actually handed over to Mr. Rafiq Ali Khan, the respondent number 8, who had also given an acknowledgement receipt.
Bang Dich.
Mr. Anay, it is lying with him. Later, subsequently, it was seized by the police.
This is a registered society. It was opened in the name of the account is in the name of the society.
Lord.
Or its secretary or
Institute. Institute.
it's an institute means it's a society under the Societies Act.
Under society, an institution has been
Institution is there is no legal entity called institute. An institute has to be a society or a company or
it's a
something.
society.
So it's a
and-
society under the law. So the society that is the holder of the account. So shouldn't it have the right to operate its own account? I mean, you have put a freeze on the account also.
No objection to that, my lord.
No, what you have put a hold on the account also.
Yes, my lord, because of this dispute between them.
That's a very well. Let us hear the state on this. Yes.
My lord, no, principal fight is between Tahir Ali Khan, the petitioner, and Rafiq Ali Khan, the private respondent. Tahir Ali Khan is claiming to be the present secretary of the Teachers Training Institute. Rafiq Ali Khan, as per the statement or submission of the petitioner, Rafiq Ali Khan is the erstwhile secretary of the institute. Milord, the state, Milord's police receives an FIR from the Rafiq Ali Khan. That my learned friend has shown at page 41. Allegation against Tahir Ali Khan. FIR registered, Caesar list prepared. Kindly see page 42, Caesar list. In the Caesar list, kindly see, Milord, item 5, that FDR is part of this criminal prosecution.
What about return of that to Rafiqul?
Now, Milord, the instruction, Milord, submitted dated 10th April 2023. This matter has been pending since long. The OC of this Ghatal PS, he says that on 14th September 2022, Xerox were taken, original were returned to the de facto complainant. That is Rafiq Ali Khan.
Why and how?
Against Jimmanama.
How could he? If a criminal case is, yes, the investigation is not
No,
yet over.
Jimmanama is that.
Whatever nama, Mr.
No, as and when he is bound to produce it before the criminal trial. That is
given back to the
permissible.
complainant.
Alamat against Jimmanama, it is to be proved at the time of trial, he is bound. So now the fact remains, these two FDRs, which are part and parcel of this criminal case, part of the Caesar list, the present petitioner claiming to be secretary wants to want that back so that they can renew it.
When was the complaint lodged by Rafiqul?
That was on 27th April 2022.
2022.
This is at page 41.
So this is the first complaint of Rafiqul.
This is the only complaint and a FIR registered on the basis of this complaint. And thereafter 42 is the Caesar list. And instruction, my lord, says that this was returned to him. That is, he is the de facto complainant claiming to be the secretary. So he lodged the FIR in the capacity of secretary. That is first issue. So if the present secretary is so much, so he is an accused, Tahir Ali Khan in this case, and on anticipatory bail.
He has at best, Rafiqul has a civil dispute regarding the certificates. Regarding the certificate, there is no allegation here. In the FIR or in the complaint also, the complaint says, আমি ব্যাংক মারফত জানতে পারি সভাপতি আবু তাহের আমাকে না জানিয়ে এবং আমার সহি জাল করে গত 7 তারিখে 30,000 টাকা তুলে নেয়।
The second paragraph then.
Second paragraph says
দুটি FDR
নামে জয়েন্ট মোডে দুটি এফডিআর উক্ত ব্যাংকের তাদের অ্যামাউন্ট গুলি হলো যথাক্রমে সাচ আমি জানতে পারি আবু তাহের খান উপর বর্ণিত অরিজিনাল সার্টিফিকেট দুটিকে ডুপ্লিকেট বানিয়ে ভাঙাবার চেষ্টা করছে। That's a civil dispute. ভাঙাবার চেষ্টা করছে is not a criminal allegation at all.
It is part and parcel of this FIR. It is the contents of the FIR contains this allegation.
Kali, what is the criminal offense even as per this complaint regarding the FD certificates? Tell me that.
No, Lordship, we don't have any say in this. See, Lordship, the FIR complaint is
I'm not
received,
asking you that.
FIR
I'm
registered.
not asking you that, Mr. Khalib. I'm asking you, any criminal offense, has it been disclosed? Any criminal offense, has it been disclosed in this, from this complaint event?
As because
Mr. Khalib, you don't understand my question going on answering. What is your answer? Let me hear that first then I'll put the question to you. If you want to put the horse reverse. My simple question is, what allegation is disclosed in the FIR against him? He's regarding the FC, regarding his deposit certificate. Show me the allegation from his complaint, Rafiqul's complaint.
Milord, allegation in the complaint is cognizable offense.
What is the complaint at all regarding the certificate? Please read out.
Milord, second paragraph.
Read out the second paragraph. Please read out.
Lordship, may I just read? I am
read out the second paragraph.
এছাড়া SAK প্রাইমারি টিচার্স ট্রেনিং ইনস্টিটিউট ও রিজিনাল ডিরেক্টর ERC ভুবনেশ্বর নামে জয়েন্ট মোডে দুটি FDR উক্ত ব্যাংকে আছে, যাদের অ্যামাউন্ট দুটি হলো এত এবং দুটোরই অরিজিনাল সার্টিফিকেট বর্তমান। আমি জানিতে পারি যে আবু তাহের খান উপরি বর্ণিত অরিজিনাল সার্টিফিকেট দুটিকেই ডুপ্লিকেট বানিয়ে চেষ্টা করছে।
So what is the allegation, criminal offense disclosed there regarding the certificate?
No, then he'll have to go for quashing of the criminal proceeding. That is what my respectful submission is.
Khalib, is there any offense disclosed? My question is very simple. I don't know why you feign ignorance on this. What is the offense, criminal offense disclosed regarding this certificate? That is my simple question to you.
He said duplicate বানিয়ে
Taking out a duplicate by the secretary of the institute society, is that an offense even under the criminal procedure code, under the IPC? What is the offense? What is the section under which this is an offense?
Lordship, kindly appreciate, my lord, whether he is the secretary or Rafiq Ali secretary, my lord, that is not a part of criminal investigation.
That is my precise point.
No,
the
but
dispute
here,
is civil regarding the certificate.
Lordship, that is, I'm not on that issue. I'm just narrating the fact that there was an FIR.
Narrated enough, Mr. Khalib. Thank you.
Lordship, no, second point, I have second submission.
What is the
So
second
it is part, these two FDRs are part of.
Very good. What is the second
case.
submission?
And so far as my learned friend is telling that he is the secretary, and kindly my learned friend has shown your lordship.
Yes.
That is on different footing, my lordship.
What sort of footing?
Page 26. My learned friend is telling that he's this on 3rd April 2017, Rafiq Ali Khan was the secretary appointed of the institute governing body. My learned friend draws the attention of this honorable court at page 27 that by this 3rd April 2017, Rafiq goes, Abu Tahir Khan comes in. And my learned friend has drawn the attention of this honorable court at page 28, that is the NCT, this resolution, that this resolution of the society appointing Tahir Khan has been ratified. Kindly see what is the ratification. My learned friend has read half, not the full. Kindly see 29. In view of the above, lordship got that page 29 relevant portion. In view of the above, the committee decided as under. SAK Primary Tier Training Institute, so and so, so and so. In the box, the institution was granted recognition for conducting DL with an intake of 50 from the academic session, so and so. A representation dated 13 November 2016 received from the management of the institution regarding a reconstitution of the governing body. As decided in 229th ERC meeting, a letter dated so and so dated 8 March 2017 issued to the institution to submit the related information and documentary proof. Reply dated 3rd April 2017 submitted by the institution enclosing certain documents. 3rd April 2017, kindly pause lordship for may I pause for a moment. 3rd April 2017 at page 26. 26 keeps Rafiq Ali Khan as the secretary. So what ratification is taking place before this committee? So another representation dated 14th April 2017 received from the management of the institution requesting to grant permission for change of its premises. That is different thing. The committee considered the matter and observed as under to give land deeds, same thing, different thing as per government records of that land the land area so and so, so and so. In view of the above, the committee decided as under: one, change of governing body of the managing committee, management of institution is accepted and noted. Which one? Page 26. Page 27 is not there before them. Page 26, Rafiq Ali.
Have you read page 26 clearly, Mr. Galib? Have you even read the previous sentence? You're very sarcastic about it. Please read out the sentence. It is in plain English. (26) and 27 are a part of the same document. What are you arguing? You only know. So surprised.
No, but first part.
Have you read the first part? Read it out. The difficulty is that you want to say more than you read. Please read out for my help.
Both for lordship.
Lordship. You get a good spanking from me, Mr. Galib. If I was that side, you'd get a good spanking from me, I'm telling you.
Lordship.
I cannot spank you sitting here.
And second one thing,
You got a very good spanking from the court.
And society, my lord,
Thank
as
you.
on date. Now, one more thing, lordship, there is a law point in this.
Oh,
I
law
don't know-
point. What is
Yes,
the law
lordship.
point?
One
Yes.
thing. This society is changing secretary one from other. But so far as a law, this institute is governed by one 2003 regulation.
You are appealing for Rafiq or the state?
No, I am not appearing for anybody. Also, it is a point of law I am raising, my lord, because I am for a prosecution. Case is going on. Lordship was asking for an update. What is the update? I do not know.
For prosecution under this act.
No, this so far as FIR is concerned, so I shall not place this then.
That is why my first query to you, Mr. Galib, was as per the complaint of Rafiqul himself, what is the criminal allegation? What is the criminal offense disclosed from the complaint of Rafiqul in respect of the certificate? That was my simple question to you, because we are now concerned only with the certificate. So you have said that no, you are only whatever you have said. I mean, you have said nothing on that actually.
The police have started, and now the FDR is lying with the de facto.
There is no complaint disclosed regarding the certificates. You have initiated an FIR on that. The complaint is on that 30,000 with being withdrawn with his fourth signature. With his fourth signature, he has withdrawn.
Talking of criminal
Regarding withdrawal of the 30,000, that is the criminal offense disclosed. Regarding if the certificate, there is no criminal offense disclosed at all.
My lord, they should have gone for quashing, my lord, if there is no cog offense made out, lordship.
If there is no offense made out against me, I'll go and quash it. Please include an offense against me.
FIR has been registered. Seizure has been made.
A complaint is made. No cognizable offense or any offense has been disclosed against me. I'll ask for quashing of that.
My lord,
A suit is filed against me without any relief against me. I'll go and say, please quash that.
FIR is registered only when cog offense is made out.
May I pass my order now?
Lordship, certainly, lordship.
Yes. The petitioner's complaint is that the petitioner is an institute, comma, which is a registered society. Full stop. It is argued that the pro forma respondent one Rafiq Ali Khan had been included as a secretary with a meeting dated September 14, 2011. Full stop. However, comma, by the resolution dated April 3, 2017, annexed at page 26 of the writ petition, comma, the managing committee was reconstituted and the pro forma respondent was removed from his post. Full stop. Such resolution was subsequently ratified by the meeting dated February 17-18, 2018 by the society, comma, the minutes of which have been annexed at page 28 of the writ petition. Full stop. Next para. Subsequently, the petitioner society found
page 28 by the NCT, not by the institution.
Sorry.
Our change accepted by the
ratified by the society, ratified by the ERC-NCTE. Full stop. Next para. Subsequently, the society, comma, represented through the petitioner in the writ petition, comma, could not trace out two fixed deposit certificates of the said society. Full stop. Accordingly, duplicate copies were sought to be issued by the bank. Full stop. However, comma, the bank did not issue such duplicate copies, comma, apparently on the premise of a pending criminal case in that regard. Full stop. Next para. It is submitted that the pro forma respondent, comma, although removed as a secretary and part of the governing committee long back, comma, lodged a complaint with the officer in charge of the HON'BLE police station on April 27, 2022, with an allegation of alleged forgery of signature with regard to a withdrawal from the bank account of the society. Full stop. In the said complaint, comma, the fixed deposit certificates were also mentioned. Full stop. As it appears from the search/seizure list, comma, in connection with the said investigation, comma, the certificates were recovered by the police from the pro forma respondent. Full stop. However, comma, the state now takes a stand that those were returned to the complainant/pro forma respondent subsequently in due process of law. Full stop. Next para. However, comma, it is submitted that since the pro forma respondent did not have any locus standi to claim himself to be a secretary or any portfolio holder in the society at the relevant point of time, comma, that is on July 20, 2018, comma, when the alleged forgery was perpetrated, comma, the bank is acting dehors its authority in refusing to issue duplicates of the said certificates to the petitioner. Full stop. Next para. Learned counsel for the bank submits that the operation of the account in question as well as issuance of duplicate certificates has been withheld by the bank due to pendency of the criminal proceeding, comma, in due diligence, comma, for the protection of the account holder. Full stop. Next para. Learned counsel for the state contends that since a criminal proceeding has been initiated, since a criminal investigation has been initiated on the complaint of the pro forma respondent, and the two certificates in question were a part of the seizure, comma, in the event duplicates of those are issued at present, comma, the criminal investigation may be affected. So that apart, comma, it is sought to be pointed out that the alleged ratification of the change of the managing committee of the society is not valid in the eye of the law, eye of law. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it transpires that the present position is that these fixed deposit certificates in question were recovered by the police from the pro forma respondent, but were subsequently handed back to the pro forma private respondent actually, to the handed back to the private respondent. Full stop. Thus, comma, it cannot be said that the whereabouts of the said certificates cannot be traced out. Full stop. Next para. However, comma, the position as it stands today is that certain allegations have been made by the private respondent against the petitioner number 2. Full stop. Petitioner number 2, na, against the
Secretary of the
against Abu Tahir Khan, comma, the alleged secretary of the petitioner society. Full stop. Next para. A perusal of the said complaint, comma, which was the genesis of the FIR lodged by the police, comma, is annexed at page 41 of the writ petition. Full stop. The said complaint dated April 27, 2022 has two components. Full stop. The allegation, comma, giving rise to an apprehended criminal offense, comma, pertains only to the purported forgery of signature of the private respondent by the said Abu Taher with regard to withdrawal of an amount of 30,000 rupees 30,000 from the bank account. Full stop, next para. However, comma, insofar as the allegation pertaining to the fixed deposit certificates is concerned, comma, the same, comma, apparently, now ex facie, comma, does not indicate any criminal offense. Full stop, the exact nature of the allegation is that both the original certificates are at present with the private respondent, comma, but Abu Taher is seeking to obtain duplicates of the same and to use the same for withdrawing the amount. Full stop, next para. Insofar as the alleged attempt of Abu Taher to obtain duplicates and obtain a disbursal of the amount is concerned, comma, the same does not come within the contemplation of a criminal offense, but falls within the domain of a civil dispute raised by the private respondent. Full stop, the dispute is whether the private respondent was validly removed as a member of the governing committee as well as the secretary of the petitioner society at the relevant point of time, that is by the resolution dated April 3, 2017, comma, subsequently ratified. Full stop, next para. The said dispute can only be resolved before an appropriate civil forum stroke court. Full stop, insofar as the present disputes are concerned, comma, there cannot be an impediment of the society, comma, through the said Abu Taher, comma, its present secretary, or otherwise, comma, to obtain duplicates of the fixed deposit certificates, comma, since those are admittedly not in possession of the society. Full stop, next para. In the event the private respondent has a civil dispute against the society or Abu Taher, comma, relating to his locus and status on the relevant date, comma, it will be open to the private respondent to approach a competent civil forum for adjudication of the same. Full stop. However, comma, insofar as the bank is concerned, comma, its liability is only to the account holder, that is the petitioner society, and the internal disputes between the portfolio holders and ex-portfolio holders of the said society cannot be a stimulus for the bank to withhold the issuance of duplicate certificates and stroke or freeze the operation of the account. Full stop, next para. Inasmuch as the criminal allegation against Abu Taher by private respondent is concerned, comma, till date, comma, there is nothing on record to show that the investigation has culminated in a charge sheet. Full stop, that apart, comma, there are certain palpable discrepancies insofar as the complaint is concerned, comma, for which the apprehension of a backlash and afterthought cannot be ruled out. Full stop. In the said complaint, comma, which was lodged only on April 27, 2022, comma, a past incident of
20th September 2018.
Of 2018, of the year 2018 is ventilated. Full stop. No explanation has been given in the complaint or anywhere else, comma, to indicate as to what prevented the private respondent from lodging the complaint regarding the alleged forgery of signature for the 4 years between 2018 and 2022. Full stop. Insofar as the fixed deposit certificates are concerned, comma, it transpires from the annexures to the present writ petition that there was an apparent change in the constitution of the governing body, governing committee, and that the private respondent was removed as a secretary of the society. Full stop. Hence, comma, as on the face of it, comma, there is nothing to impede the bank from issuing duplicates in due process of law, comma, and in consonance with banking regulations otherwise, comma, to the account holder, that is the petitioner society, comma, through its portfolio holders, present portfolio holders, comma, if so applied for. Full stop. Moreover, comma, there is nothing in law to prevent the petitioner society from operating the bank account, comma, since there is no allegation regarding operation of the bank account, comma, which has even reached the stage of trial till date. Full stop. Mere pendency of an investigation on an application on a complaint lodged much later than the alleged incident cannot be a fetter for the bank to permit its legitimate account holder society to operate its account. Full stop. Next para, in view of the above observations, WPA 4165 of 2023 is allowed, comma, thereby directing the respondent directing which 2 or 3, whom should I direct? Or 4? 4. 4 is branch manager. Directing respondent number 4, that is the branch manager, comma, UCO Bank, comma, Ghatal branch, to ensure that the duplicates of the certificates of fixed deposits standing in the name of the petitioner society with the bank be issued to the petitioner at the earliest, comma, subject to compliance of due formalities in that regard by the petitioner society through its present portfolio holders. Full stop. Next para. The bank shall also permit the petitioner society, comma, through its present members stroke office bearers, comma, to operate its bank account standing, its savings bank account, current account is its account standing with the UCO Bank, comma, Ghatal branch. Full stop. It is, comma, however, comma, made clear that nothing in this order shall create any special right or equity in favor of the petitioner as well as Abu Tahir, comma, its present secretary, comma, and in the event any civil proceeding is instituted by the private respondent against the petitioner or Abu Tahir, comma, nothing in this order shall influence unduly the said competent civil court or other forum from deciding the said dispute independently and in accordance with law. Full stop. It is further added that nothing in this order pertains to the merits of the allegations made against the petitioner, comma, which is the subject matter of investigation at present, and the investigation will take its own logical course, comma, independent and irrespective of the observations made herein. No rest to cause.
Lordship, may I put the report of the OC on record?
The report filed by learned counsel, the report of the OC filed by learned counsel for the state be kept on record. What is this? This was handed over by whom?
So, my lord, I handed over showing that Mr. Rafiq Ali Khan was having the original FD on.
Oh, that is I've recorded.
One pair, my lord.
Yes.
Let a time period be there by which they will issue.
Yes. Time frame for what?
For issuing the duplicate copy, my lord.
No.
Maximum limit 2 months or some.
Tomorrow also they can do it. Get the certified copy, take the server copy and place it.
Kindly fix it.
No time limit. What is the question? Where is the question of a time limit for this?
Upon the bank.
Call on the next one.
Great, my lord.
Lordship, I'm sorry for having gone out of bounds.
No, you did not. Yes, it took over. Next.
Item 20.
I'm appearing on behalf of the petitioner,
Yes.
Your Lordship. On the last occasion, my Lord Justice Bhattacharya passed an order on 18th of May
Yes.
directing the respondent number 12, that is the AGOT, Administrator General and Official Trustee, to file a report regarding one inventory is to be made. They have not
No, no.
yet filed an affidavit.
Affidavit, my lord.
Affidavit.
My lord, there was a direction upon the respondent number 12 to file an.
Please use the microphone.
My
Yes.
lord,
12
there
to
was
file, yes.
to file an affidavit, my lord.
By 12th of June.
By 12th of June, my lord, but certain telephonic conversation between the petitioner and the respondent number 12 is thought to be put on record, my lord. For that, we have written to the cellular department, my lord, the cellular department. We need 2 weeks time to file the reply.
What is
my
the
lord.
matter about?
This matter is about the petitioner is basically a farmer, your lordship, but he is a passionate collector of antiquities. One day in the month of January this year, the official Administrator General and official trustee came with his people and seized several, I think, thousands of antiquities and seized those and dumped in somewhere in AGOT office.
What is his
Thereafter-
what is his occupation otherwise?
He's basically a farmer, but he
Farmer?
farmer.
Acha, he collects
He
antiquities.
has acquired such adeptness and skill in preserving, and his work is very much appreciated.
Acha.
I could show it.
All right. Then what happened after that? Please
There-
continue where you stop.
Thereafter, it was basically malhandled, and then we came up before this honorable court.
So who
and
took it away?
the AGOT, the Administrator General and official trustee.
Why? Under what pretext?
Nothing. He had no jurisdiction at that point of time.
You have asked for recovery of those.
We have asked for recovery. Honorable Justice Bhattacharya allowed
Yes.
23 order. Passed an interim order in favor of us. We wanted one inventory to be made on that day, and it was granted.
No, why was it taken? Because it is state property. I mean,
No, it was not straight property.
Your Lordship, I am for the Archaeological Department of India.
yes. What is your pretext for taking this away?
Basically,
Your Lordship, not me.
Lordship,
It is
may-
not my
may I
authorities
finish?
who has taken.
Let her finish, then I'll come to yes. Yes.
Thereafter, on 20th of March, Honorable Justice Bhattacharya granted us this interim relief
Yes.
that the inventory can be made. As the petitioner is a farmer, he is not that much literate. So the daughter of your petitioner, who is an practicing advocate of this honorable court, directed by Lordship Bhattacharya to assist him. They went there, they faced certain disturbances there, they were harassed. That's why we brought those things into the kind notice of this honorable court by way of a supplementary affidavit, and the order of 18th of May was passed. May I place that order before your
Yes.
lordship?
Yes.
And I'm reading it in its entirety. An order was passed on 23/2023, directing an inventory to be made of the articles removed from the petitioner's house. The interim relief was given on the ground that the Administrator General / Respondent number 12 did not make an inventory at the time of removing the antiques from the petitioner's house. The inventory was also directed to be done by a responsible officer of the Archaeological Survey of India in the presence of the petitioner, the petitioner's daughter, and the Administrator General by 28/3/2023. A report was to be filed on 3/4/2023. The petitioner has filed a supplementary affidavit in court today containing various allegations inter alia against the respondent number 12, Administrator General and official trustee. The petitioner has also stated that the inventory was only started from 13/4/2023. That was basically 10 days delay, contrary to the direction passed by the court. The allegation with regard to the conduct of the respondent number 12 are serious. The allegations include the behavior and attitude of the respondent number 12 as against the petitioner and his daughter. The petitioner is a farmer in a village in North 24 Parganas, and the daughter is a practicing advocate of the court. Before the court comes to any conclusions on the allegations made in the supplementary affidavit, the respondent number 12 must also be given an opportunity to rebut the allegations in an affidavit. The affidavit is to be filed by 9 June 2023. The inventory, which was due to be completed by 28th of March 2023 and is woefully behind schedule, is also directed to be completed by 9th of June 2023. The respondent number 1 to 4, that is Archaeological Survey of India, will take necessary steps in this regard. The parties who are directed to be present during the inventory will be present at 10:30 a.m. in the morning, and the inventory will continue on a day-to-day basis. The parties will give all assistance so that the inventory is completed within the time directed, that is by 9th of June 2023. The submissions made on behalf of the parties required certain other directions to be passed. The petitioner / his daughter will be permitted to take 5 or 6 photographs during the course of inventory of the items, which were removed from the petitioner's residence. These photographs will be shared with the assistant sub-inspector as well as the respondent number 12 through WhatsApp. The petitioner / his daughter will also be liberty of seeking the assistance of police, including a lady police officer, if the situation so warrants, and if there is any incident which causes discomfort to any of the parties before the court. The respondent number 12 shall file an affidavit by 12th of June 2023. It is also made clear that the inventory will not be interrupted in the absence of the petitioner's daughter if and when she is called to the court for professional reasons. Mr. Oniban Roy, the learned government pleader who is present in the court, is requested to call the parties to his chamber or at any other place which is comfortable for all to look into the allegations made by the petitioner / his daughter in the supplementary affidavit. The court thanks to Mr. Ray for the assistance. List this matter on 30.
So was the thanks justified?
They had a talk in his chamber, I guess, and thereafter the inventory was done. But right now they want to file an affidavit, and we want to get hold of those affidavits because
They filed the supplementary affidavit opposition.
no, not yet.
So anything else you want to add, then I'll hear them.
No.
Yes, whom should I hear first? Who is the more,
Malab kindly gives us 2 weeks. I'm led by Mr.
no question of 2 weeks, sir.
Malab 1 week's time.
Time is over.
Malab, I'm
Pay costs, no.
Malab.
I'll impose exemplary cost. First you take away these things from a farmer and then you do these things. He's not merely a farmer because he's a collector, as it appears from the records at least.
Malab, I'm led by Mr. Ashok Kumar Banerjee in this matter, Malab. Kindly gives us 1 week time, Malab. Let me come back with an affidavit, Malab. The affidavit is required, Malab.
Sufficient time has been given to you. The inventory has been completed.
Inventory has been completed.
So you have nothing to do right now. You are directed to be there in the inventory. The inventory, you have to file the report, one. Secondly, you have to file an
report was to be filed by
you.
my client. Yes.
So what about the report? Oh, the report is ready.
The report is ready, Malab.
For that affidavits, opposition to supplementary affidavit. No, I'll close arguments. I'll close affidavits on that, and I'll hold in my order that the allegations there are right. They go uncontroverted. No.
Lordship.
What is the question of refuting them now?
Kindly 7 days time, Malab.
For what?
Kindly come up with an.
For what?
Malab,
What prevented you from filing that during this time?
Kindly, Malab.
You are given a direction to file affidavit on 18th of May, 3 months back. Definitely not. And you have to file it by 9th June.
Malab,
Today we are on 23rd of August. 2 months have elapsed.
Malab, the telephonic conversation.
What telephonic conversation with whom? That is a post facto fact.
Kindly 7 days time.
When did the telephonic conversation take place?
In the month of January, Malab.
January.
January.
Between whom?
Between the petitioner and the respondent number 12, Malab.
There are certain
What do you want? What do you insinuate?
Malab, the petitioner voluntarily gave those articles to the respondent number 12, Malab.
And is spending so much money for filing writ petition before court? Ridiculous. No, you pay costs of 50,000 to them. Absolutely.
Kindly,
Pay cost of, either I'll close that affidavit, right? Or you'll pay cost of 50,000.
kindly,
No question of anything.
Malab, kindly keeps it on Monday, Malab.
No. Yes, what do you say?
Your Lordship,
I'll take your report on record.
Your Lordship, I'm filing this report
My
on
lord.
2 volumes, Your Lordship. Your Lordship, the age and the whether the articles are original or not, we have not gone into. We have just made an inventory
No, you
stating-
need not, because that is not.
Your lordship.
Lordship, may I get a copy of those?
Your lordship, my
The
lord, let me
invented copy,
apply
I'll
for the
direct,
certified copy.
No, no, no.
Because
Circulate copies.
Yes, your lordship.
Archaeological Survey of India is sufficiently solvent. Circulate copies to them. Do you need a copy? You don't need. You seize the documents.
present-
You know what document, seize the articles.
Still, my
No,
lord.
I'll impose cost on you.
My lord, my lord. Kindly give the 7 days time, my lord.
No.
Let me come back. my lord.
Refused. Refused.
My lord,
একটা order record করো।
my lord, kindly, my lord.
The facts of the present writ petition revolve around the allegation that the respondent number 12, the Administrator General and official trustee, West Bengal, forcibly seized certain antique pieces and artifacts and materials of historical value from the petitioner, who is a collector of such items. Full stop. Next para. It is seen from the records that a direction was initially passed for an inventory to be held with regard to the said articles, and a report was to be filed by April 3, 2023. Full stop. Subsequently, due to certain circumstances, the report could not be filed, for which appropriate directions were passed by a coordinate bench with a order dated May 18, 2023. Full stop. The report, pursuant to the said direction, is filed today by the Archaeological Survey of India and be kept on record. Full stop. A copy of the said report be handed over to the learned advocate on record for the petitioner by the Archaeological Survey of India.
has been your lordship.
It has already.
Acha, be given, has been given by ja bolam tai, here and now. Full stop. Next para. Insofar as the other direction passed in the order dated May 18, 2023 is concerned, the respondent number 12 stroke Administrator General was to file an affidavit to rebut the allegations made in a supplementary affidavit filed by the petitioner. Full stop. Next para. It was recorded in the order dated May 18, 2023 that there were several serious allegations leveled against the respondent number 12, the Administrator General and official trustee, in the said supplementary affidavit, for which the court considered it appropriate to give an opportunity to the respondent number 12 to use an affidavit. Full stop. It is also recorded that the allegations in the supplementary affidavit include the behavior and attitude of the respondent number 12 as against the petitioner, who is a farmer in a village, and his daughter, a practicing advocate of this court. Full stop. Next para. Despite such opportunity being given, the affidavit, which was to be filed by June 9, 2023, has not yet been prepared by the respondent number 12. Full stop. Even today, when the matter is called on for hearing, an adjournment is sought and a further extension of time for filing such affidavit is asked for by the respondent number 12. Full stop. Next para. It is clear that the direction for filing of affidavit was filed suo motu by the court as long back as on May 18, 2023, after which about more than 3 months have elapsed. Full stop. The last date of filing the affidavit was June 9, 2023, even after which much time has passed by. Full stop. Next para. The respondent number 12 shows its nonchalance in not preparing the affidavit till date, particularly in the teeth of the serious allegations made in the supplementary affidavit. Full stop. However, in deference to the previous opportunity given to the respondent number 12 to use an affidavit in opposition to the supplementary affidavit, a last opportunity is being given to the respondent number 12 to file their opposition to the supplemented affidavit. Full stop. Accordingly, the time for filing affidavit in opposition stroke rejoinder against the supplemented affidavit filed by the petitioner, comma, is extended on the prayer of respondent number 12 till till September 8, 2023, when the matter shall next be listed fairly at the top of the list. Full stop. Next para. Such extension of time for filing affidavit, comma, however, comma, is subject to the respondent number 12 paying costs of rupees 20,000 to the petitioner before the next returnable date. Full stop. It is made clear that in the event the said costs are not paid, comma, the matter will proceed without the said affidavit of the respondent number 12, comma, on the premise that the allegations made in the supplemented affidavit remain uncontroverted. Thank you.
Lordship,
30,000 because you are quite junior.
Lordship, there is one correction.
30 কমিয়েছে, 50 বলেছে, 30 কমিয়েছে ও junior.
Lordship, there is one correction. They were about to file this affidavit by 12th of June. And the inventory was to be done within 9th of June.
What did I say?
9th of June, the affidavit to be filed.
12 করে affidavit টা 9, 12.
Not only supplementary affidavit and affidavit in opposition also.
To the main petition also. That was also the direction.
Yes.
Hello, opposition যেখানে বলছি to the
No,
supplementary affidavit.
opposition is to be
I don't
filed
think so.
9th.
No.
See,
Opposition to the main writ petition was also directed by that order.
no.
I don't think so.
No. Opposition to the supplementary.
But
Only supplementary affidavit opportunity
Yes,
was given
yes,
because
yes.
there was serious allegation.
Yes.
I read out that order itself. I mean, from the
my lord, but we need to file an opposition also, my lord. Can we file it by 8th, my lord?
that you will have to file within a week then. Because they have to have a week for
My lord.
very well.
Apply.
On the arekta line add kodab, on the prayer of learned counsel for the respondent number 12, comma, leave is granted to the respondents to file their affidavit within bracket S in opposition, comma, if any, comma, within a week from date. Full stop. Reply, if any, shall be filed by the petitioner on the next returnable date. 1 week, 1 week.
Deeply obliged.
Thank you.
My lord, can I get the copy of the inventory, my lord?
Not now. You were led by whom?
Mr. Ashok Kumar Banerjee, my lord.
The senior Mr. Ashok Kumar Banerjee?
Yeah, sir.
Very
And Indrodil Nandi. And Indrodil Nandi.
Yes. You also belong to the same chamber?
Yes, my lord.
Yes.
21.
Yes, what happened before the governor? You are still alive, that is sufficient. Time was paid for in my court in the morning on the ground that you had a serious meeting with the governor, His Excellency the Governor, that was the line. And I refused it.
No, my lord.
Obviously, I refused it.
My lord, I was on my way for attending this
Jadavpur is still
matter.
functioning, Jadavpur University, after your meeting?
I'm the AC member over there, my lord. So it's for that, my lord. For
That is the reason what is happening. Are you the reason or the remedy?
That is why, my lord, His Excellency called me for on an emergent basis. I was about to reach your lordship's
The
court.
Excellency also has to think about the court. Court stopped functioning because you were there.
I apologize, my lord. I tender
No,
my
I passed my order, recording your name.
Deeply obliged.
Whatever
my lord.
happened, ask from your junior. Yes, call on this.
21.
My lord, I am appearing for the petition.
Yes.
My lord, this is a passport matter, my lord.
Should I release the other matters, Mr. Sinha, for the rest?
No, my lord, it will merely take 5 minutes, my lord.
Yes.
Why my other learned friends will suffer, my lord, for me.
No, what is the matter?
My lord, may I take your lordship to page number 26, my lord? My lord, petitioner is a Bangladeshi national. And my lord, he has been married to an Indian national. And on that pretext, my lord, earlier passport has been issued. My lord, his passport has been impounded in Kuwait, but without passing any impounding order, my lord. And without
in Kuwait?
In Kuwait, in the first round of litigation, my lord. And without any impounding order or so-called issuance, it has been impounded. And afterwards, your lordship's order, only the order of impounding has been passed. My lord, at page 24. My lord, thereafter, the earlier file was closed.
You are a Bangladeshi national.
My lord.
So how did you reach Kuwait?
Section, my lord, I have been married with an Indian national, and under section 51C of the Indian Citizenship Act, my lord, my marriage has been consummated in the year 2006. So, my lord, I have been in India since 2006. So I am entitled for Indian citizenship by virtue of registration under section 51C of the Citizenship Act 19.
I'll look into that later. Yes.
My
Then
lord,
how did you go?
my lord,
You went to Kuwait.
My lord, I went to Kuwait for my job purpose. I was there
Yes.
and doing my job. And my lord, on that point of time, my passport was impounded by the authorities.
Yes.
The Indian passport official written a letter to the Indian embassy at Kuwait, and it has been impounded illegally without passing the order of impounding or so cause. My lord, thereafter, only after a writ petition has been filed before your lordship has been pleased to direct the authorities to pass a order.
Both your passports have been seized.
My lord, only one passport.
So why are both of you petitioners? The wife.
My lord, because section 51C of the Citizenship Act. My lord, he's a Bangladeshi national. Article 21 will prevail, but other for making.
Why is the wife a party? She's an Indian national.
She's an Indian national. My
Why
lord.
is she also a petitioner?
My lord, because of establishing 51C of the Indian Citizenship Act.
Achha,
That
very well.
only that one legal right, my lord, entitlement.
So what happened? Let us see the impugned order.
My lord, in this writ petition, I have filed writ petition for non-consideration of my application for renewal of my passport, which is at page number 26. This is the prayer in this writ petition, my lord.
Only that?
Only that. My lord, page number 25. May kindly see, my lord. After impounding of my passport and closure of my earlier file, I have been advised by the RPO to take an appointment and file a fresh passport application. When I have filed a fresh passport application, instead of considering it, my client has been advised you go to home or else.
Yes, impoundment remains.
My lord.
Yes, passport is impounded.
My lord, it has been impounded and file has been closed. It has been reflected in the order of the RPO, my lord.
So you are not debarred for that?
No, my lord, I am not debarred.
Very well.
Now I can apply a fresh. My lord,
so you are asking for renewal of what?
My lord, because I have the earlier passport issued in my name.
Renewal of the impounded passport?
Renewal or grant of fresh passport. Those two terms, my lord. I have applied for grant of passport, my lord. I'm sorry.
So they have not refused it as yet?
No, my lord. My lord, when I have, my lord, page number 25 may kindly be referred, my lord.
Yes, very well.
In this
you
regard,
want only a consideration of your, this is.
My lord, under section 20 of the Passport Act.
Yes, Ms. Sadat, what do you say?
My lord, under section 20 of the Passport Act.
Yes.
My lord,
My lord, the passport authority can grant a passport to a foreigner subject to approval, my lord. They have the discretion. Issue of passport and travel document to person who are not citizen of
It is necessary to do so in the public interest. What is the public interest involved?
My lord, public
Your
interest.
passport was impounded for whatever reason. It was impounded.
My lord.
Now you seek a new passport, thereby trying to bypass that
my lord.
Impoundment. And now you are seeking to invoke section 20 is not applicable.
My lord,
your passport is not
my
a
lord,
public interest.
It's not a public interest, it's a private interest. My lord, my humble submission with regard to this, my lord.
It's not applicable.
My lord.
How can I direct them to do something illegal?
My lord.
So I'll reject it.
My lord, if your lordship, in the interest of justice, my lord, rejects my petition, my lord, I will suffer because, my lord, I have 2 kids, which I need to feed, my lord.
We cannot bend the law like this.
My lord,
a 50-50 scenario, we can think it over.
My lord, in the Geneva Convention, my lord,
this
also.
Is -1 versus 101.
My lord, I definitely appreciate
Geneva
this.
Convention, what does it say?
My
Indian
lord,
law does not apply
the
to
foreigner refugees will also have the Article 21 protection, my lord. So, my lord, in view of violation of his...
reject your application, division bench will affirm, go to the Supreme Court, try to invoke Article 142 if the Supreme Court has the power.
My lord, Supreme
Geneva
Court.
Convention, Article 21, there is a specific provision of law which you are invoking.
My lord, only for consideration, my lord, because, my lord, on page 25, my lord, they have advised me to file a application for grant of passport, my lord. Page 25 of my writ application, my lord. In this regard, you are advised to visit Regional Passport Office, Kolkata on any working day through a valid appointment will be issued from passport website along with the original document and meet the
which paragraph? Which clause?
my lord, page number 25, annex to P6.
Which clause of page 25?
My lord, the entire, only one para is there, my lord.
The date
Page
is not
25 is
reflected.
this.
Oh, my lord, the page numbering is wrong, my lord.
My lord, the
After
date-
this document, my lord.
The date is not reflected from
My
here.
lord,
my
the
lord.
email document, my lord.
Document, it says,
Sorry, my
Oh,
lord.
that email, acha.
it's an email, my lord. It says today, but I can't really find, I apologize, my lord, I can't find out the date from here. And,
Neither can I.
and my lord, if
My lord, the date I can confirm, my lord.
You are advised to visit Regional Passport Office, Kolkata.
My lord, if your lordship kindly appreciates, my lord, it's not that he married this woman, the petitioner number 2, and that is why he claims citizenship. It is the second round of litigation, my lord, and in the before he came to the before your lordship, on the first occasion, there was a show cause notice issued to him. He gave a reply to the show cause notice, and the show cause reply to the show cause
Because regarding impounding passport.
my lord. And it says, my lord, it's written in Bengali, my lord. I don't want to bother your lordship with that, but it says that
Bengali?
no, my lord, it's a big one, big
I am not
reply.
bothered at all with Bengali.
And I know, my lord, I bow
Yes.
down. My lord,
What was the premise of that show?
he said that he took help of an agent. He came to India.
Very well.
I can place it before your lordship, my lord, if your lordship directs
Very
me.
well. Ultimately, it was impounded.
Ultimately, it was impounded, and your lordship directed for fresh consideration. And we had given a hearing to him, and he said that he has, my learned friend has annexed the document with this petition, my lord. It says that he gave the reply in presence of his lawyer, and as his lawyer, he has named my learned friend. And thereafter, the order was passed, which is now under
Just I'm
challenge.
sorry, no, cannot.
My lord, at least consideration as per law, my lord. My lord,
Not
if
so
the authorities deem fit, they can reject
Your
it,
quota of considerations is over the last time.
my lord. But my lord, my humble submission, my lord,
no,
my
no.
humble submission, only one folded, my lord. May kindly consider, my lord. My lord, with regard to this email communication, which is of dated 15/7, my lord. My lord, the date is not mentioned, but it's 15/7, my lord.
I'll consider that.
My lord,
that will be reflected in my refusal.
my lord, if the matter is considered as per law, if
Counsel,
the central government did not deem it,
counsel for the petitioner submits that the petitioner number 1 is a Bangladeshi national and married petitioner number 2, who is an Indian citizen. First up, it is submitted that the petitioner number 1 has accrued certain rights under the Citizenship Act by virtue of such marriage and residence in India. First up, on a previous occasion, the petitioner's passport was impounded, full stop. Upon the petitioner having given a representation in that regard, that was not considered, upon which the petitioner approached this court, whereupon the court, with the order dated June 17, 2022, directed the respondent authorities to consider and dispose of the representation of the petitioner as expeditiously as possible. Full stop. However, such disposal met with a further rejection. Full stop. Subsequently, the petitioner's passport, also expired in due course, and the petitioner applied for a renewal, alternatively issuance of a fresh passport. Full stop. Next para. Learned counsel for the petitioner places reliance on Section 20 of the Passports Act 1967 and submits that under certain circumstances, the central government may issue a passport to a person who is not a citizen of India. Full stop. Next para. In the circumstances, since the petitioner is residing with his wife and 2 children, learned counsel submits that the court may take a sympathetic view in directing the authorities to reconsider the issue. Full stop. Next para. Learned counsel for the petitioner also relies on annexure P6 at page 26 of the writ petition, which is purportedly a printout of an email by the passport authorities asking the petitioner to schedule an appointment for meeting the said authorities. Full stop, next para. Learned counsel appearing for the respondent authorities refutes the contention of the petitioner and submits that the petitioner number 1 is not entitled to issuance of a fresh passport. Full stop, in any event, comma, in view of the previous passport of the petitioner being impounded and there being no further change of circumstance, comma, the present application ought to be refused. Full stop, next para. Upon considering the submission of the petitioner and perusal of the materials on record, comma, it is reflected from the order dated June 17, 2022, comma, that there was a previous occasion of the passport of the petitioner number 1 being impounded, comma, upon which a reconsideration of the petitioner's representation was directed by the court. Full stop. Such reconsideration, comma, however, comma, also met with a rejection, and an order of the passport authority dated July 14, 2022 is also annexed to the writ petition. Full stop. Next para. It was specifically observed by the passport authorities in clause 10 of the said order that the show cause reply shows that the petitioner number 1 is neither an Indian citizen by birth nor as on date citizen by registration. Full stop. On such ground, comma, the passport was the impoundment of this passport was sustained. Full stop. Next para. I do not find anything from the records to show any change of circumstances to prompt the petitioner to ask for a reconsideration of such issue. Full stop. In view of the previous impoundment of the passport of the petitioner, comma, on certain valid grounds, comma, recall of the said order cannot be carried out by in the garb of the present writ petition. Full stop. Insofar as the purported email of the authorities is concerned, comma, even if the same is authentic, comma, it merely advises the petitioner to schedule an appointment with the passport authorities and to meet them with all original documents for within double inverted necessary action. Full stop. Nothing in the said email confers any right on the petitioner which the petitioner does not otherwise have in law. Full stop. The petitioner has not disclosed anything to show that the conditions as prevalent on the day of the last refusal of grant of passport by way of affirming the order of impoundment was made, comma, শুরুটা কি করলাম? The petition has not shown. Have changed in any manner insofar as the relevant grounds of issuing a passport to the petitioner is concerned. For some next para, Section 20 of the 1967 Act, comma, in any event, comma, does not confer any right on the petitioner at all, comma, since the petitioner comes with a private dispute, whereas the said section confers the central government power to issue or cause to be issued a passport or travel document to a non-citizen of India only if the government is of the opinion that it is necessary so to do in the within double inverted public interest, comma, which is not the present case. Full stop. In such view of the matter, comma, this court is not of the this court is not inclined to issue a direction to consider a representation, comma, where there is no law to support such representation at all. Full stop. Hence, comma, WPA 5795 of 2023 is dismissed without any orders to cost. Full stop. Nothing in this order shall prevent the petitioner from approaching the passport authority, petitioner number 1, sorry, from approaching the passport authorities for issuance of a fresh passport subsequently, comma, in the event there is any germane change of circumstance for which the petitioner becomes entitled in law to obtain a passport. Full stop. No orders to cause.
Deeply obliged, my lord.
Grateful, man.
Thank
Original side matters, any mentioning?
Yes.
Item number 8.
if it is not assured, my lord, my
310 already.
my learned friend mentioned this matter to get my client has an urgency. But today I am indisposed, my lord, I have to leave court.
Oh.
Kindly pardon me for this day.
Pardon me for?
For this day, item number 8.
8 of the original side list. Ask Mr. Kundu to be there or anybody else to be there. Just prefer time. Definitely I'll grant.
He had get it uplifted. So my lord, position maybe.
The 80 goes down.
My client has urgency. I am indisposed today. I have to leave.
Very good. Mr. Kundu has brought you. That's why.
No, I say personally that when my client
No,
has
Mr.
urgency,
Kundu has brought you.
so
Yes.
I have.
For that, he should be penalized. He has to be present when the matter is.
Yes.
Very well, Mr. Kundu. Yes, I'll.
Yes.
Don't worry. Yes.
Listed matter, item number 1,
One.
Banwarlal Jajodia versus State Bank of India and others.
Yes.
My lord, I appear for the writ petitioner, my lord.
Yes,
They have
please.
served. So this is against, my lord, declaration of willful default, my lord. That I have not been provided with a copy of the review committee's order. I had written a letter to them that kindly provided, it contains 10 pages. They had given only 1 page. So I wrote to them, kindly provide, they have not provided, my lord. But I wanted to place that, but just, my lord, because I cannot prefer any, my lord, writ unless I have the order. I've been writing to them, my lord, they have
So
not.
this writ petition is challenging that review committee order,
Yes,
which
but
you
I,
don't
I
have.
have only first page of it. There are 11 pages. I called upon them to
I'll
give
put
us.
in something in my order so that they give you a copy.
Sorry.
I'll pass an order directing them to
Yes,
give you a copy.
because I'll have to come.
I'll keep
come
the
back.
writ petition pending.
Yes, yes, that will
Writ petition is not for getting a copy, I hope.
No, no, this is for
Very well.
washing,
Very
but I need the order. I'll file a supplementary after.
Learned counsel for the petitioner submits that the petitioner was declared to be a willful defaulter both by the identification committee as well as the review committee. Full stop. However, comma, despite all attempts by the petitioner, comma, the entire copy of the review committee order could not be obtained by the petitioner. Full stop. As such, comma, although the present challenge has been preferred against the declaration of the petitioner as a willful defaulter up to the review committee, comma, the challenge cannot be properly constituted due to absence of the said review committee order. Full stop. Next para. In such circumstances, comma, the respondents are directed to furnish a complete copy of the order of the review committee to the petitioner directly or through the learned advocate on record for the petitioner in this court, comma, within a fortnight from date, within a week from date, full stop. Leave is granted to the petitioner to file a supplementary affidavit incorporating the complete copy of the review committee order.
And additional grounds, my lord.
And incorporating additional grounds if required, comma, on the next date of hearing. Full stop. Next para. The respondents shall act in terms of this order on the basis of a server copy of this order, comma, coupled with a written communication by the learned advocate on record for the petitioner. Full stop. Such communication shall be made by the petitioner at the earliest, comma, as soon as possible after obtaining the server copy. Full stop. The matter shall next be listed on September 11, 2023. That's 20.
Yes, deeply obliged.
Affidavit size filed today. Thank you.
I'm deeply obliged.
Thank you. Yes.
For hearing, item number 2 to 5.
My application.
Yes,
that Your Lordship has given us a hearing before. There's on that point of that scheme.
Oh,
that scheme where আমি petitioner তো আরে এখন উল্টে গেছে আমি কি করব
Mr. Chatterjee is for the
respondent.
All throughout 4 days I was this side.
You have been evading court, avoiding court, everything under the sun. No. Yes.
I've appeared below on every occasion. Can you
You send Mr. Surya Shekhar Chatterjee or he's here?
Surya Prasad.
Oh, Prasad, whatever. Prasad, Shekhar, all the same. Mr. Surya Chatterjee comes every time and
But he sits
valiantly
here every
defends.
He sits here every time, and he's after my life to come every day.
Yes, Mr. Banerjee.
Well, this was in respect of a scheme. Where it will come back to your Lordship. It's in respect of a scheme where certain benefits are payable and they are to be paid to me because I come under the scheme.
Yes.
And the scheme contemplates certain stages. The penultimate stage is an inspection. If on inspection everything is found to be in order, then the money is supposed to be disbursed. On inspection, it is found to be in order, then the money is not disbursed, and therefore I come before the court.
Inspection report is there.
Yes, inspection report is there. That I had indicated, Your Lordship, on the last occasion. That, and there's, well, this petitioner has two different claims. I'll first give a brief outline of what the matter is. Their defense is that
group company adjustment.
That's right. Group company. I knew it will come back to Your Lordship.
No, but something is there.
This group company adjustment, one MFL corporation, which is a part of this group of companies, they have fraudulently taken some benefits under some MM4 scheme. They rely on a PAC committee meeting or recommendation, which is a public accounts committee. And the public accounts committee has held that steps be taken for recovery of amounts from, then there are two companies mentioned, two of such companies.
Manager, do you object to the fact that they are your group companies? No. You say they are your group companies, but that cannot be a valid ground of refusal. That's is your case in this.
That's right. Lord, I had addressed Your Lordship on two counts legally.
Yes.
One is that anything extraneous to the scheme
Yes.
can't be the basis to refuse an order or a benefit under that scheme. So a ground extraneous to the scheme can't be the basis to refuse a benefit under the scheme. One.
Yes.
And secondly, this public accounts committee recommendation was merely a recommendation that had not translated into an order. I had shown a judgment where the Union of India, there's an article which is there, article of the Constitution.
Yes.
And to pass an order, that particular article will have to be complied with for an order to be termed an order under the by the Union of India. So these at best would be interdepartmental communications or recommendations, which is not justiciable either at my end or can't be the basis for the respondent to act upon to withhold my claim. These are two legal issues that I had addressed, Your Lordship, on. On both counts, both these grounds, I had cited a judgment, but just, my Lord, factually, I'll just indicate a few things again, because it's been a while that Your Lordship has heard it. This just gives me a minute, my Lord. Judgments I had given copies, my Lord. I will not take Your Lordship to the judgment again. Lord, the petitioner Bali Fab has two schemes.
Yes.
4 applications. One application under scheme 1.
Yes.
One application under scheme 1. That scheme 1 validity was 1st October 2013 till 31st March 2017. If I remember correctly, my Lordship had noted all of this down.
Yes.
And then the second scheme is from 1st April 2017 to 31st March 2020.
Right.
Under the first scheme, the benefit is 20%. Under the second scheme, the benefit is 30%.
30, yes.
Under scheme 1 application, there is only 1. Under scheme 2, there are 3 applications.
The scheme 1, just
Yes.
can you give me, please give me the repetition numbers so that it will be easier for me later.
My Lord, this writ petition that Your Lordship is hearing of
Yes.
Bali Fab,
So
item number 2.
4 twos, that is
Item
scheme
number
1.
2, WPO 222 of 2022, Bali Fab.
Quadruple 2.
Oh, 42, sorry.
Quadruple 2. That is Bali Fab. That is under scheme 1, 20%.
Bali Fab has both the schemes, applications under both the schemes.
Acha, very well.
Bali Fab has made 1 application under scheme 1 and 3 applications under
Bali
scheme
Fab is
2.
the petitioner in WPO.
Item number 2, yes.
Item number 2.
Yes.
So it has challenged both the.
I have
schemes.
challenged, I have not challenged the scheme.
I'm
I've challenged the fact that they've withheld the
Refusal
benefits
under both the schemes.
under both.
Both
No, there
schemes.
is no real refusal, but
Right.
that's come by way of an affidavit now. But withholding of the benefits under
What
both
about the 2 other writ petitions? Those are.
No, there are
against?
3 other writ petitions.
Yes.
So Bali Fab and Kunta is similar. Bali Fab and koto number 2 and 3 are similar. Similar in the
Both
sense.
Bali Fab.
No, Bali Fab and Kelvin.
Kelvin.
That's item number 3. Similar in the sense, my Lord, there are the schemes in respect of all four matters is the same.
So if I take up the 4 matters, suppose I'll have to consider both the schemes in any event.
In any event.
So in two of the other matters, those concern only one of the schemes each.
Those concern second scheme.
Difference, Lord. I've let him finish. I'm not interrupting. But factually, it will be a little different.
Correct. I'll indicate that fact. But in terms of your opposition, right? Correct. Factually, the only distinction is otherwise the scheme, the application, the eligibility is all the same. The factual distinction is that item number 2 and 3, these writ petitioners, against these two, there is no suit filed by the respondent for recovery. In matters which are 4 and 5, applicants under the same scheme, there is a suit filed by the respondent for recovery of amounts which have been allegedly fraudulently taken under a different scheme.
So suits are against the group companies.
Suits are against petitioners in 4 and 5.
By any chance, these the petitioners in each of the matters, in one of the matters, the petition is not the group company in the other.
No.
These are not your group companies in any of the matters.
Well, Lord, all this is part of some Kankaria group of companies.
No, these are not the indicted group companies which are against whom allegations are there.
No, they are not. They are not. That is the dispute. That's why we are here.
Because you are in one matter you dissociate from the other
Lord, I am
company on the ground that they're your group companies, you have no nexus, and that group company is also the writ petitioner in the other writ petition.
Think so.
No, I'm not saying that. I'm saying that with regard to all 4 petitioners being part of the Kankaria group is not doubted. In the Public Accounts Committee recommendation, there is a reference to take steps in respect of 2 such companies of the group company.
In any event, we have to see through the prism of the scheme.
That
I mean, if the scheme, we cannot take anything extraneous. That is what you are arguing.
That is all. That is my argument. The factual distinction is the Public Accounts Committee has identified the petitioners in item number 4 and 5 to be 2 entities against whom steps should be taken. The respondents have gone ahead and filed 2 suits against petitioners in item number 4 and 5. Rest, there is factually, in my understanding, there is no distinction. I have also checked up the scheme because I was worried that Mr. Chatterjee will look up and come and show a clause which allows like a cross default that we have in loan accounts. There is no such clause to my understanding that I could find. In fact, the scheme specifies grounds on which it may be withheld. So anything that is not there in the scheme, in my understanding and respectful submission, is extraneous to the scheme.
Yes.
Now, just 2 things, Manoj. I don't think Mr. Chatterjee here is today going to say that in the inspection I was not found to be eligible, because that is also not his case. So just one document, Your Lordship.
Written refusal.
There is no refusal also. There's silence. That silence is justified on the basis of a Public Accounts Committee recommendation, which say that one MFL Corporation Limited, which is again part of the group companies, had obtained certain benefits under an MM4 scheme that will now amount that that person has taken will be recovered through suits that have been filed. And the affidavit, they have gone and put themselves out there and pleaded in the affidavit that although suits have been filed, monies that are entitled to be paid under this scheme to these 4 petitioners.
They preempt the suit itself. Please the suit and adjust that from you.
No, that's right. They say it's adjusted and steps should be taken to amend that plaint and go and reduce the amount.
Yes.
This I say is impermissible, because the moment you say that it stands adjusted, you admit to the fact of my eligibility under this scheme. Then to withhold my benefit under this scheme, you'll have to show the court that the scheme authorizes you to withhold benefits on ground which the scheme doesn't provide as ground on which you can withhold. Or in other words, legally what your lordships have called it, grounds that are extraneous to the scheme.
Yes.
Look, 2 things I had indicated on the last occasion. Just for your lordships, just one thing, Milord. Kindly have a look at page 110 once. Well, I can take your lordship to the scheme to show this, but this is a part of the scheme. This is an undisputed document.
Yes.
So revised guidelines for the scheme, own source. So the two types I can borrow money and have it bank finance and purchase it. Then the scheme contemplates a different procedure. If I have paid for it and bought the machine, then this is the procedure. So there is an application. All these steps have to be followed. Penultimate one, your lordship will see the second last one. Inspection to be conducted within 30 days on receipt of Hijra's report. Then incentive to be disbursed. I have stopped at this penultimate where they have stopped for me. Now, there are certain machines which were not found to be eligible, certain machines which were found to be eligible. So my case here is for this writ petitioner, scheme 1, application 1. Whatever you inspected and found to be in accordance, which is also there in the inspection report. I'll not trouble your lordship with that. We'll anyways have to give notes. I'll indicate that. That you disburse to me. Now, scheme 2, 3 applications. 3 have not made similar headways in terms of the process. In one of such application, which is scheme 2, application 2, they have also reached this penultimate stage. Again, there I say, whatever you on inspection you found to be payable, pay this.
Very
So scheme 1, application 1, what you found payable, pay. Scheme 2, application 2, what you find payable on inspection, pay.
So that is regarding one is Balifab, another is Kelvin.
Kelvin.
So these two you have reached that stage and you are
In all 4 I've reached the stage.
Inspection.
Inspection. In all 4 I've reached the stage. The only distinction is
suits.
That in respect suit. Suit in respect of the other 2. Item number 4 and 5. 2 and 3 there is no suit. So the matter, my lord, has now been complicated. Not so much in the affidavit, but then it had the brainchild of better lawyers coming in. And then it got complicated in the supplementary affidavit in opposition that they came up with. In the reflection, I can see Mr. Chatterjee.
I was thinking.
He's wearing a very complicated look.
The opposition.
I am then successful in
Complicating the matter. Yes.
Well, the opposition, your lordship, before I take your lordship to the opposition, just 1 second. Your lordship will just come to the scheme 1. No, no. The scheme starts, my lord. তুমি তো আমার মামাটা করতে দিচ্ছিলে না, পরেরটাই তো আমার ছিল। চলে যা করে। The scheme starts at page 20. Sorry, my lord. The scheme starts at page 22.
The National Medical Commission also has a role to play in this.
No, no, my lord. There's a different matter that I will do.
No, behind you also.
Oh,
yes.
that's
They took half the morning. The rest of the half, Mr. Banerjee himself is taking charge.
Entire medical thing, whatever is there in India, he takes care of that. The entire medical thing is on him.
But it's impossible to do a matter against him because he does these more or less every time I've appeared against him. If I've won before the single man division bench, he makes me lose because he knows these inside out. Some circular, something he comes up with and he'll show the court.
He's competent also, very competent.
Extremely. And he's very fair. So he has that appeal also in court, which.
Fair to me.
So statistically, it's going against him.
Color.
That's I agree.
Statistically, it's now he's to lose. I mean, the next matter. Statistical, not. Yes, very well. National Jute Board, page 23.
Page 23 is the scheme, my lord.
Yes.
Your lordship will find the eligibility criteria. I'll not trouble your lordship. Eligibility criteria at clause number 6.
I have a peculiar feeling whenever any of you say I won't trouble your lordship. It's like saying with utmost respect.
Oh, that. No, but I don't want to take your lordship through.
Nobody respects anybody after saying with utmost respect.
Never.
I've never seen anybody respect someone actually after saying that.
Well, this, in fact, I have noticed in my limited years of experience that the moment somebody says this in court,
Exactly.
He alienates the judge because the judge is expecting disrespect.
No, unless you become brazen and
Then
jaded
not
on this.
anyways, you will
Everybody
get
says that. So you know you will not be respected.
You're not supposed to disrespect somebody on his face. You're not
Don't
supposed to
complicate
do
the matter. Eligibility criteria. Yes.
eligibility criteria, Lordship will see at 6.
What is the relevant one?
No, I'll just taking a Lordship through the scheme
Achha.
to show when they can withhold.
Achha, very well.
9 conditions for grant. And then, my lord, your lordship will come to page 28 once.
Yes.
It's a part of procedure for applying of the scheme. This is what is now formed part of that chart.
So anything in it which is even close to their ground?
Nothing. I wanted to show one thing, my lord. 11, page 28.
Yes.
A total fund of rupees 19 crores shall be provided by the Ministry of Textile to NJB for 4 years under non-plan fund for the scheme. This sentence, my lord, the NJB shall disburse funds to their respective eligible applicants against the non-plan grants for the Ministry of Textile.
What is this non-plan fund?
This would be, I'm not sure, my lord.
Very well.
But
this you are on the shall dispersal part.
Shall dispersal.
Very well. Yes.
The scheme mandate.
I had on the first day say, kindly add the Union of India. This was my prayer because the money will come from the Union of India, and if they don't allow us to disperse, we will not be able to disperse at all.
But you have taken a specific ground for.
I have said so. Lord, in my ground, I've said so. That the money, if it has to be dispersed by the Union of India.
Mr. Chatterjee, do you have a case against him? I mean,
I have a case against him.
So let us hear that if you
and
win
that case that I have against him, my lord,
yes,
is also based on Union of India. My lord, I'll quickly, my lord, say why. Because there might be a situation here, my lord. What happens is, this group of company, they take the money from Union of India, then they have some sort of, my lord, an arrangement with some of the people. And, my lord, if they don't buy the machinery, and, my lord, but they take the, my lord, the money from the Union of India. And there has been situations where, my lord, CBI has come in right now. There is an inquiry going on, and there is a criminal case as well. So till that is done, my lord, our hands are completely tied. And there is a recommendation which is in the form of an order.
Mr. Chatterjee, legally, if you can withhold the funds, I mean, if you can satisfy me that they don't have a case on merit on this, then in any event they go.
I bow down. But if they win, well, I'm against.
Yes, we cannot enforce anything.
We cannot enforce anything against me, and I am bound by the Union of India. Because the PAC, my lord, has given a recommendation which is in the form of an order that you can't do anything with this group of company because they've stolen money earlier. So and my learned friend says that we file suits. My lord, he's come back and given money on his own. On his own.
What about implementing the Union of India?
I am crying this from day one.
Yes.
Well, this point was taken before your lordship on the last occasion. Your lordship has passed an order on the last day. I had shown page 21, 22. It took your lordship exactly 5 seconds to see and understand why Union of India will not be a necessary party.
There was no submissions made. To be very frank,
there was submission. Your lordship saw it. NJB is a statutory body. I won't impede them. Not. They are now. They want this respondent wants the Union of India to come in. So that grounds that are extraneous to the scheme as prejudicial facts are argued before your lordship. It has absolutely nothing to do with the scheme. A statutory body under the scheme has been entrusted to disburse funds to which persons eligible. If your lordship finds me eligible, if they don't disburse, I'll take it up in contempt.
Yes. What else, Mr. Banerjee?
Yes, not so. I have not found any of these grounds here. Now, primarily, what is the ground? Well, on the last occasion, I'd shown to your lordship that on inspection, they had found machineries to be, and the chart wise, I highlight that in the notes. Factually, on these aspects, I don't want to trouble your lordship. But the opposition, your lordship will see once. The supplementary opposition. Supplementary affidavit in opposition.
Yes, yes.
Sorry. কোথায় চলে গেল? না, ওটা নোট ছিল। লর্ডশিপ জাস্ট কোথায় গেল আমার সাপ্লিমেন্টারি অ্যাফিডেভিটটা? ও তো মার্ক করলাম। Just bear with me for 1 minute. অন্য মামলার মধ্যে ঢুকে গেছে। বালি জুট। আমার সাপ্লিমেন্টারি অ্যাফিডেভিটটা এই মামলায়।
Note supplementary.
মানে তোমার
We seek to establish a trail probably between you and the entire. It's a scheme sort of, they say, that you are channelizing that mini mission force scheme, the director system. These things have been pleaded.
These things have been pleaded in the supplement. It must have gone in the other briefs, right?
You can take Mr. Chatterjee's copy, you'll get the underlined portions also.
Mine is.
You can point out those. You can start with those.
না না আমার ওটা কে বলবে এখানেও তুই কম্পিটিশন করবি না না
I'll just kindly have a look at the supplementary affidavit on behalf of the supplementary affidavit.
You can take my copy also, Mr. Banerjee. By now, I almost have it by heart.
I'm very grateful, Mulad. I have that. Mine is marked. That's
you have to deal with para 3. Yes.
ও নোট রয়েছে
আমার নোট আছে না ওটাতে সবকটা পুরো yes Mulad, I'm sorry.
Yes,
this your lordship will kindly come to paragraph 3 once.
Yes,
I say that several anomalies were discovered which were committed by several jute mills which include the petitioners in the mini mission 4 scheme. The Public Accounts Committee, a committee of Lok Sabha, in the 39th report dated 24th, captioned as failure to implement scheme objectives, has noted on query from them that NJB Ministry of Textile has taken legal action against the jute mills for recovery of the subsidy amount wrongly drawn under the said scheme. The PAC is very strict with regard to the recovery of the wrongfully drawn subsidies. Apart from filing of money suits which regard to recovery, simultaneous action were proposed by the committee to bring the perpetrators to justice. The committee has recommended, then it goes on, Milord, your lordship will turn over to the next page. Because I'll have to show your lordship that last 2 sentences of paragraph 3.
They also say that the directorship is common. I say that Bali Fabs is a company which is incorporated under the directorship of the promoters of Bali Jute and
with no document. But I am admitting that is a part of the same group company. I'll give them the highest credit on this in law. That last 2 sentences at page 3, Milord, of paragraph 3.
Yes.
Therefore, this your lordship will kindly mark, Milord. Therefore, in terms with the direction. Now there's no direction. It's a recommendation.
I've marked direction and adjusted.
Adjusted.
I've marked
your lordship, because I'd shown this on the last occasion. Now the PAC report has been annexed.
Which is at page 6.
Which is at page 6. I'm grateful, Milord.
And I have to start with 78,40,000 and end with 8,85,846.
That's right, Milord. 2 additional things if your lordship has marked.
Yes.
NJB by its letter dated where 1 to 12 serial numbers are mentioned, dated 25th August 2020, have forwarded 12 cases for taking up investigation by CBI ACB 1 and 8. Ambika Jute Mills and 8 Bali Jute.
1 and which page?
Same page, Milord. At page number 5.
5. Yes.
Where your lordship has marked the amounts.
The amount I've marked at page 6, yes. Anyway, yes.
Just the preceding.
1 and 8, yes, I have marked. Right.
Then if your lordship is on page 5.
It's pending against Ambika and Bali. Jute.
Ambika and Jute. No pending. NJB by his letter have forwarded dated 25th August 2020 have forwarded the balance 12 cases for taking up for investigation by CBI ACB.
No, suits are probably pending against Ambika and Bali. Jute.
Ambika and Bali, but this recommendation is for
This
CBI.
is on different footing, yes.
No case has been registered. No criminal case is pending. While your lordship is on page 5, kindly look at the first table or that block. Your lordship will find the name of the party is MFL Corporation Limited. An amount of 78,4310 has been recovered from the mill and money suit filed against this. Further action has been taken against the involved officials in the case. Prosecution sanction against Sengupta and so on. So denial of sanction, legal scrutiny. So this adjusted is what your lordship has marked in paragraph 3 of the affidavit in opposition.
Right.
Then page 6. That paragraph, your lordship will allow me to place. The National Jute Board, just before.
Yes. So, marked it. Yeah, I mean, you continue.
Yes. So committee recommend that all involved in the regulatory capital subsidy be blacklisted from availing any benefit under any scheme of the government in future. So these are all recommendations.
Right.
Admitted position is this respondent has not taken any steps on the basis of these recommendations, which they now say PSC is very strict and these are directions. So there is no CBI case against these two. There is no proceeding also. In fact, petitioner in item number 2 and 3, your lordship will not find in this list at all of 1 to 12. The ones whose names have appeared, against them, there is no order of blacklisting. There is no CBI proceeding. There are 2 suits in which they have taken no steps. Summons has also not been served in them. No steps have been taken in that. Now the ostensible defense is adjustment.
Yes.
Now, my lord, only thing is, your lordship will see at page 9, the same thing is again there. Page 8, there's a recommendation that blacklisting be done. And this CBI threat that they've dangled over me, and which they now use as a charm before this honorable court, that there is a CBI case finding, that is also been stayed by this honorable court. So against MFL Corporation, the main person that they filed the criminal CBI investigation against, something they came up and did, we preferred a 482. There's a stay of that. This I'll be able to show the order. I'll be able to show that order. I'm carrying it. And this recommendation, my lord, why I wanted to show to your lordship was the date is important. This date your lordship has seen on page 5, where this recommendation is of 25th of August 2020.
Right.
I think today is the 25th or 25th of August 2023. 3 exact years have passed. This very strict PAC direction, nothing has been done. There is no blacklisting, no suit. This is, I'm addressing your lordship in respect of petitioners in item number 2 and 3. 4 and 5 will be slightly factually different. There, my case is slightly better because of their affidavit. So nothing done, my lord. Therefore, I had on these 2 counts and in these facts, I cited that one judgment where it says extraneous to the scheme. And the other was the Supreme Court decision where it says any steps that are to be taken on the basis of an order, it has to be on the basis of Article 77, if I'm not mistaken. But I'll just indicate that paragraph of the judgment. In fact, I was citing a different paragraph. Your lordship had corrected me. Supreme Court judgment? Hmm. 2009-15 note I had cited. Probably had given a copy also.
Yes.
There your lordship was right in pointing out relevant paragraph. to me. Lot 41 onwards, if your lordship would kindly come to once. The issue deserves to be considered from another angle. All executive actions of the government of India and the government of a state are required to be taken in the name of the president or the governor of the state concerned, as the case may be under Article 77(1). Orders and other instruments made and executed in the name of the president or the governor of a state, as the case may be, are required to be authenticated in such manner as may be specified in rules to be made by the president or the governor. Then 77(3) is quoted, so is this. 42. This means that unless an order is expressed in the name of the president or the governor and is authenticated in the manner prescribed by the rules, the same cannot be treated as an order on behalf of the government. Now, what your lordship had rightly pointed out to me, 44. In state of Punjab versus Sodhi Sukhdev Singh, this court considered the question whether a provisional decision taken by the Council of Ministers to reinstate an employee would be made the basis of filing an action for issue of a mandamus for reinstatement. We are unable to understand this argument. Even if the Council of Ministers had provisionally decided to reinstate the respondent, that would not prevent the Council from reconsidering the matter and coming to a contrary conclusion later on, until a final decision is reached by them and is communicated to so-and-so. Citing this, I want to highlight before your lordship that this PAC, this Public Accounts Committee I checked up, is a committee that is constituted of persons who are chosen as representatives from the members of the parliament, who form a committee of the parliament, who look at the Comptroller General's accounts, audit accounts of the Union of India that are filed before it. They are a recommendatory body. So this recommendation, unless it translates into an order, which so much is being said about the Union of India. So the statutory body, according to them, is distinct and separate from the Union of India. So there is no order as contemplated by Article 77 by the Union of India upon a statutory body to do certain things in a certain way and to act contrary to their own scheme. This statutory body also has not taken this recommendation as a direction and therefore has not acted on the basis of it, because it has not translated into an action at all. With no steps taken against me in the petitioners in item numbers 2 and 3, can a scheme be today abrogated? Because that is, your lordship will not find in the affidavit that under the scheme I'm not entitled. In fact, their case is entitlement and therefore disbursed and then adjusted. It's like lien. Once I've given it up, there can't be a lien. Here they've disbursed under one head, adjusted under another. This, in my respectful submission, is impermissible in law. And to cite that this was contrary to a scheme and could not be done, I referred to the other decision which I cited on the last occasion. Yes. Now, factually, so these two your lordship will keep aside. 2 and 3. 2 and 3, this is what is there. With no suit, no CBI, no blacklisting, nothing. Now, with regard to the other two, my lord, if your lordship takes up Bali Jute and Ambika are the ones who figure on serial number 1 and serial number 8.
Yes.
So that one of them I'm taking Bali Jute. Lord, here your lordship will just once make a note. It comes to that supplementary affidavit straight. Then I'll indicate the factual. Against Bali Jute, there is a suit. Now, the stand in the paragraph 5.
Yes.
I say that money suit number 783 of 2018 and 784 of 2018 was filed against the petitioners for recovery of wrongfully drawn, please mark these three words, drawn subsidy in mini mission 4 scheme. In terms of the direction, now this will become a direction again, and subsequently the wrongfully drawn subsidies were adjusted amounting to 15,20,000 as principal and rupees 879 as interest, that is total 2399. This total amount has been adjusted. So because this is a statutory body, it's an absolute privileged litigant. It files a suit and then it adjusts, and it has disclosed here that I want to go and now amend the suit there. Accordingly, the claim in the money suit being satisfied, the same are yet to be, the same are to be withdrawn. We're not showing this. I want to argue that this is an attempt, and a blatant, flagrant attempt to overreach the judicial process. Because you understand that unless you file a suit, these monies are not recoverable. Therefore, you file the suit. And in another court of law, you come and give this affidavit saying, I have of my own adjusted it, and I'm going to withdraw those two suits. And the same thing, Your Lordship, will again, top priority basis, all that Your Lordship will find again. But one important thing I just have to show to Your Lordship is at page 39. না সব তোমার affidavit এত ভালো supplementary দিয়েছে
39 of what? Bali Jute?
39 of Bali Jute. Supplementary, the same part of document that I was showing to you. Page 12, sorry, it's marked as 39 in.
See there.
Page 12, sorry, page 12. But you will find 2 page numbers there. I got a little confused.
Yes. Right.
There's 139 to confuse.
Yes. Followed by 29.
Followed by 29, and at top there is a 12.
Yes.
Dates of approval and adjustment as provided from the concerned file, that is Joint Director TT, placed at so-and-so on the basis of the date of disbursement, release of payment under JTM and date of adjustment under MCLR rate of SBI has been downloaded, which has been placed before FP. The interest has been calculated on the basis of SBI MCLR and placed at FC for kind perusal of information. Interest also there. As per letter.
So let us wait for the suits being withdrawn, then we'll hold that this is not, they cannot adjust like this.
Recovery so-and-so, the total amount wrongfully drawn under the acquisition of plant and machinery, capital subsidy under Jute Technology Mission, Mini Mission 4 Scheme 6.4 was 1 crore 2 lakhs. The said amount of 1 crore 2 along with interest recovered up to 31st March 2021 was as under. Again, Your Lordship will find the name of Usha. Subsidy
Usha?
amount.
Who is Usha?
Some MFL is Usha.
What?
So same. So it's different company.
Yes.
Different company. 102. Now this is interesting. Your Lordship will mark it, my Lord, please. Amount already recovered. There is a principal and there is an interest. So 1 crore 2 lakhs. Your Lordship has found that total what I had taken was 1 crore 2 that MFL Usha. They have added.
And in the suit, the entitlement of them to their entitlement to take it back. I mean that's in
Is in the suit. That is and that's against MFL. This is not against me.
Oh, that yes, right.
That is a suit that they filed against Usha.
Yes.
Well, look, they are so privileged that they've not only calculated the principal, they have computed the interest also payable at the MCLR rate of SBI. And all this stands today adjusted.
Yes.
It may be seen from FNA that the total principal amount of 1 crore 245 has been recovered or adjusted. And interest of 4871,911 has already been recovered. The next page is a better copy, my lord. Then turns over, disregards it and turns over to page 13 once.
Yes.
This is important. The present file of ISAPM revealed, balance interest of rupees 40, page 13. Ki korcho? Balance interest of rupees so and so is still to be recovered as interest. The present file of ISAPM revealed that 53,52,400 being 20% incentive on eligible 61 machinery cost has been approved by the competent authority. Out of the approved incentive amount of ISAPM, the balance interest amount to be recovered amounting to 48 may be considered for approval, please. Under the circumstances requested to technical as to any other recovery from the related mill is pending, or the balance amount of 496 to be released to Bali Jute Company after adjustment of the above interest.
No, what about this out of the approved incentive amount of ISAPM, the scheme?
Yes, 53.
The balance interest amount to be recovered may be considered for approval. The recovery.
So additional interest also and now the,
right.
So this 4 lakhs according to them is payable. Now 5352. Now, my lord, I'll tell you, Lordship, why this is also absolutely incorrect. I'm sorry, this factually might be a little heavy. But my claim for Bali was total claim that was there. It was 1 crore 50 lakhs. 1 crore 50 odd lakhs, because the first, in respect of the first letter of intent, the claim was 41.56 lakhs. In respect of the second, it was 1.10 crores. So if this has been adjusted, the remaining is admittedly still to be paid. So this they have stated that they've adjusted 23 lakhs on my account at paragraph 5. Your Lordship has seen that. Paragraph 5, they say 23 lakhs has been adjusted. So this paragraph 5 is contrary to this page 13. And this page 13 is contrary to records. So my eligibility under the scheme is not doubted. Except that they say this 5352 has 20% incentive on eligible.
Do I read it correctly? Under the circumstances, it is requested to technical section as to any other recovery from related mill is pending, or the balance amount of such and such
to be released
to
Bali Jute.
To Bali Jute. Therefore, they admit everything that your entitlement.
I'm entitled to.
Their only premise apparently from this is that adjustment.
But kindly keeps that in mind. I'm not saying that he's not entitled.
Oh, right. Very good.
So admittedly, I am entitled. And this is now being withheld, or it has already been adjusted. My lord, exact thing your lordship will find in respect of Ambika, except that Ambika, there are 3 suits. Bali Jute, there are 2 suits. And I can give your lordship the page numbers. Ambika total claim is 1.44 crores.
Give the details.
I'll give all those details in that.
In Ambika, Usha has been mentioned.
Everywhere.
Everywhere, Usha. They must be a fan.
Good one. Yes.
This is their case.
Yes.
This is their case, my lord. So I'll come back to those 2 points again. That is extraneous, and therefore, my lord, these are my respectful submissions.
Yes, Mr. Chatterjee.
But, may I start on the next day?
Why? People are waiting for your version of the defense. I
I'll
mean,
give you a lot of.
if their entitlement is admitted, you adjust it with some other suit and all these things. What about
There's much more to that. Much more to that. But a very innocent argument has been made by my learned friend. But that he's so good and he's done so much of work, he's invested so much of money, and he's entitled under the scheme. Well, entitlement is one thing, but whether he is entitled to receive the money is another thing. The scheme says that somebody who has done A, B, C, and D is entitled to money. Well, he says, I have done something extraneous to the scheme. Well, I have done something to save public money, and I'm entitled to do that. Well,
That's a common refrain for public bodies.
I bow down. I completely.
If law does not support his misal,
I bow down again. I'll show you lordship what law my lord has laid in that lookout notice matter. I'll show you lordship.
Not relevant here.
Very relevant. I'll show you lordship. His problem is that if the memorandum, if the scheme doesn't allow me to stop his payment, I can't stop. Lord, respectfully submitting, first look at what his claim is. Lord, he's claimed not only on the second scheme, he's claimed on the first scheme as well, which was time bar. He's put on, Lord, innocently, he has said that I am entitled, very innocently, my lord, as he looks, very innocently, that he is entitled to the scheme under the second scheme. But if your lordship, I'll take your lordship to the papers.
First scheme as in MS that.
Yes,
MS4.
MM4 I don't know.
Different. This is
modified.
It's a whatever it is, different scheme. But the first scheme, which was there, my lord, he is claiming under that, which when the time he claimed it, it's already gone.
Have you taken the defense anywhere?
Yes. It's a question of law, fact on record. I've taken that defense as well. And it's on record. And what he has now done is, my lord, he's clubbed the two schemes together and said that give me money from both the schemes. One aspect. Second aspect, my lord, that he has admitted to the fact that he's got more money. Why? Because he's come and given the money back on his own. Moment the suits were filed, I'll show you a lordship document.
So, Chatterjee, if he's entitled under the scheme, you have to look only within the conspectus, within the window of that.
That is what I'm going. My respectful submission.
Let us forget the first scheme. He's not entitled. He's not entitled.
So he can't club the
only regarding whatever he does. The second scheme, he's entitled. Then,
Lord, if that's again where I'm, Lord, my respect.
What about that?
Lord, I am trying to, Lord. He's trying to narrow it down. I am trying to widen. I am saying that I can do things, certain things, which I have to under the law. If the Constitution, my lord, allows the PAC to do something under the law, that he can recommend his blacklisting and his group of companies as blacklisting. What is blacklisting? What happens is, my lord, I would also be submitting on, my lord, lifting the corporate veil. What happens is, one person who is a promoter of a company avails public money, doesn't pay, frauds, blood is apparent on the face, finds out that fraud, and he says that very well, I'm not claiming anything. What he does, Lord, he goes and floats another company, Bali, and then he say, Lord, X, he goes and floats Y and says X had money to be paid. X has done fraudulent things, but Y cannot Y is a separate entity. That's where I say, my lord, can he lifts the corporate veil, and it says the promoters. Lord, the scheme is that it's in the scheme that if the promoters have, my lord, indemnified the government of India, that if they have received money, my lord, fraudulently, they are bound to pay it back. So, lordship would, my lord, see who is the person behind the fraud and who has taken money from government of India, not given it back, floated another company and saying, I am entitled under the scheme. The government is entitled to stop it at that, nip it in the bud. And I am a person, my lord, who is being funded by the government of India. It's not my own money. I am only a dispersal agent. I have got no money of my own. I have got no revenue. My revenue is Government of India. So if the Government of India has recommended that he should be blacklisted or his promoters are blacklisted, my lord, I cannot give him, disperse the money. Then the CBI runs after me.
Can there be a blacklisting? I mean, behind the curtains. I mean, if there's a blacklisting, it has to be open that you are blacklisted.
Absolutely.
Was
He
there a
knows
blacklist?
about the recommendation that his other company.
Can there be a blacklisting without
Because
blacklisting?
in the PSC account, there is a specific order of blacklisting the Kankaria.
PSC account, that's your internal communication, internal recommendations.
Yes,
and all.
that's a recommendation.
So you
I have
cannot
to work
blacklist
on.
a person without hearing him.
Lord, I am not blacklisting him as such. I am preventing him from getting the public money. Till the entire
Blacklist him
investigation
formally,
is done.
Mr. Chatterjee, after hearing him, after giving a show cause, if you blacklist him, that you cannot get a loan from, if that is permitted in the law, then you definitely can say so. Otherwise, if he is entitled under the scheme,
This is
whatever
not a
he has
loan,
done.
this is disbursement of the money itself.
Yes.
Money itself, he gets the money.
You are becoming paranoid then.
I am.
You cannot be paranoid. on disbursal of public money, even that. It is your notion, it is your perception that this person, there cannot be a deemed blacklisting. Either he is blacklisted or he is not. Blacklist him, give reasons, give a show cause, blacklist him.
Yes.
Don't give him the money.
That's one
But
part.
if he is not blacklisted, he is definitely entitled.
Now, who is blacklisted? May I ask this question to myself? The person who is blacklisted, my lord, is a promoter of that company.
Who is blacklisted? Has he been blacklisted at all?
That is what is, kindly have a
That is
look
what is
at.
Mr. Kormakar saying, nothing else.
No.
What is the
Kindly-
blacklisting, Mr. Chatterjee?
No, that's a different thing. Then we'll come to that. My lord, I'll show your lordship with respect to how he is what he is and how my lord the
No, the promoter.
Mr. Kormakar is the he's more intelligent than that.
No, but if you have not blacklisted, then Mr. Chatterjee, we cannot say that you blacklist him notionally and you say PSC has told me this behind the curtains and therefore I won't give him the money. You cannot do that. You are a public body. You have to be transparent also.
My lord, I'm being as transparent as I can be.
Yes,
there
you are
are
being that.
I can't be something, my lord, which I'm not. And I can't give money.
Do the precise things you are saying. If this person is on a fraudulent motive, blacklist him, declared him to be an willful or whatever procedure is there in law. Do that and then say I cannot give him a scheme. But once you say that this is the eligibility criteria and he is eligible otherwise, you cannot withhold a scheme, Mr. Chatterjee, by saying that no, because of your some other notional blacklisting in our minds, we won't give you this money.
No, my lord, if under the scheme I'm able
Yes,
to,
under the scheme, if you
able to withhold money.
On what conditions?
There are. I'll show you.
Show me that. Yes. Even if today I'm convinced that this person is not a fraudster, but he's doing something which is not congenial to the economic atmosphere of the country for public at large. Even then, if he's not blacklisted formally, we cannot do that. From the scheme, if there is anything in the
Why I'm
scheme,
drawing
show me.
analogy from my lord's other judgment was, your lordship, my lord, withheld a person from going out, or rather with
Leaving the country.
no, yes, your lordship,
That
no,
is-
not that. Your lordship, my lord, affirmed a lookout notice on the ground of, my lord, apprehension. That this person, if he's allowed to leave, he will cause a lot of problems to the economy of the country.
In that case, Mr. Chatterjee, there must have been an interpretation of the circular of the government.
No, that's what I'm saying. The circular of the government is there. There is not just a circular, the PAC recommendation, my lord, I will show your lordship as statutory force.
Very.
I'll try and, my lord, get to that because my cases, my lord, very limited.
Yes.
I can't say, my lord, anything and everything. I have something over my head.
Yes.
Who is asking me to do something like this?
So the binding force of the PAC circular
That
is
is
one
what is
aspect
very
of the
important
matter,
for
and the other is the scheme. You are saying there are
Absolutely.
some safeguards in the scheme. So what is the safeguard in the scheme?
Yes. Kindly turns to এটা হচ্ছে, হ্যাঁ, এটা বালি ফ্যাক্ট। Kindly first looks to, my lord, page 27. My first attack will be on this 5.
Yes.
In case it is found,
This is which one?
this is Bali Fab, my lord.
Bali Fab. Acha, very good.
First scheme.
হ্যাঁ আচ্ছা এই দুটো সরে আমরা আবার গোড়া থেকে শুরু করছি ওগুলো এখন থাক আপনার কাছে
না ওটা শর্ট সাহেবকে তাহলে একবার দেখি
পেজ 37
yes but it starts off from প্রথম পাতাটা কোথায় গেল দে না প্রথম পাতাটা
27 দেখাবে তো
না আমি দেখাবো প্রথম থেকে 24 থেকে 23 তে দেখ
this is WPO quadruple 2 of 2020
quadruple 2
yes page 37 is something else I mean
no kindly it comes to 23 first
yes
Lord, this is a incentive scheme for acquisition of plants and machinery.
you're not
Then-
ready in the matter
My lord?
you're starting from the first line of this
No, no, it's required. I tell you, Lord. It's really required. And then can you looks to the date, the commencement and duration.
right
The scheme will come into effect from the 1st of October 2013 and continue up to 31st March 27. This is very important. Then
Wait, he'll just indicate one line in his affidavit where he's taken the point. So I could have met it. In his affidavit, in
on the
opposition,
basis
if
of the your on the basis of your annexures he's arguing this
no,
is the
this
part
point
your
of limitation that this was beyond after, if he has taken this point anyway.
limitation is for
Yeah,
the
the question
for
that
the judge to
take the
court
for the
to
judge
find
yes
out.
judge has to consider
Judge has to see.
even if
No,
he
no,
does
that-
not
that- I understand the civil very well. Let him argue. I'll address.
77 Supreme Court page
No, no,
5.
that
It's for the judge to first see.
that's in a civil suit. Very well, let him argue.
yes
No, 77 Supreme Court was not civil suit.
yes
That's a point of law I can take even
Ah,
for the
point
first
of
time in
correct.
Supreme Court.
this is not limitation for filing the writ petition
Yes,
Mr. Banerjee.
yes. Kindly have a look at
this
then.
is your disability to apply under the scheme
Yes. Kindly then, this was the duration, turns to 27.
Hmm. yes
26 দেখাও। Very good.
what is happening behind you
Lord, there is somebody above my head as well.
yes
Then C is B. B টা দেখাতে চাস তো? হ্যাঁ। The applicant will be required to submit
this
claims
is page
within 1 year.
27
26. I wanted to answer my lord's query first before I took your lordship to the others, but they don't want me to do that.
no 26 b
B.
Hmm.
Though this is not related to what I'm submitting right now, but since they want to show your lordship, and I'm fine. The applicant will be required to submit claims within 1 year to be extended to 18 months under special circumstances from the date of issue of the in principle approval. This is on the point of limitation. I will come back to this point later. I will first show 5 at page 27. In case it is found that the incentive has been availed of on the basis of any false information, the company shall be liable to refund to National Jute Board the incentive availed of along with interest to be charged from the date of disbursal to the date of refund. The rate of interest shall be the prime lending rate of NJB's banker at the time of invoking this penal clause. There is a penal clause.
this is relevant for the other matters where it has
But
been
I will show it's even relevant for this matter.
but you are not in this matter you have not even disbursed this, the amount
Milord, the disbursal was in the earlier scheme, and where Milord, he had to Milord put in that money because he took it by way of fraud.
this refund you are speaking
Not
of,
him, basically, but his group company.
that is in
Milord,
respect
I
of
am
the second-
trying to connect dots. And I will try and do that before your lordship, Milord. And I would pray before your lordship, Milord, to kindly consider it.
while connecting the dots Mr. Chatterjee you cannot cross the lines
I will not cross the lines. I will not. But I will
very
have
first
to
connection
connect the
is this,
dots.
you are crossing the line
Milord,
this is false information and refund pertain to this
yes,
particular
yes,
scheme.
yes, yes. Milord, I am using this as a enabling provision for Milord, my client to not pay him because he's already taken money fraudulently somewhere else. This may be open, may not be open. My lord would kindly consider. I will show, my lord, from the other circumstances, how if a person has, my lord, fraudulently done something, my lord, with respect to the government of India, and which affects the economy at large, the government is, my lord, open to stop him, my lord, from getting an incentive, which even if he's entitled.
Mr. Chatterjee, just because the government has a perception that somebody has
Not
committed
perception, has
fraud,
found.
that does not become a fraud.
Has found.
The government has to follow the law as well.
The government has found. My lord, there are CBI inquiries against him. And till that
CBI
is,
inquiry, even a CBI inquiry does not castigate him as a criminal. You have to establish in a court of law still now, as of today. I don't know tomorrow whether you will be required to do it. CBI probably will be passing the orders also, but as of today, no. It's an investigating agency at best.
Lord, I will
How can you
find,
say
I
you
will,
are saying fraud? They are fraudulent persons.
Lord, I am
Indian
not
is not a
saying
referral of
the
property.
PAC after an investigation.
PAC, what is PAC? PAC is neither the parliament nor the executive.
Lord, they have a
PAC
constitutional
is the
force
committee
behind.
of the parliament.
They have a constitutional force behind.
Constitutional force, they can affect the parliament's decisions. But the parliament also has to make a, parliament cannot take executive decisions, Mr. Chatterjee.
No.
You cannot confuse between the two. That is
No.
the separation of powers.
Not at all.
So parliament cannot take executive decisions. If it takes, that is not binding in law. Why should it be?
Lord, I'm not for a second arguing on those lines.
Then
Not for a second.
what is the role of
I
the
am-
PAC here?
What I am trying to, Lord, convince your lordship is
Yes.
two aspects in the matter.
And you are a statutory body under a
I
particular
am,
statute.
but
Yes.
funding is not mine.
Funding may be whatever. Funding on fund.
I am only a disbursal authority. I am
Floated the scheme. You floated the scheme.
Lord, kindly sees that. Come, sees that.
Yes. It's your scheme.
Kindly turns to
The caption is National
28.
Jute Board everywhere.
28. Funding.
Funding is different. It's your scheme. Wherever you are funded from. The funding has to, if you are Mr.
I
Chatterjee, if somebody is eligible under your scheme,
I have
it's
to
your
do-
liability to pay him.
Lord,
The funding, then you sue your funder. You sue your funding authority, Mr. Chatterjee, but you have to pay up.
Definitely. Lord, I'll try and convince your lordship.
National Jute Board in very large font.
That it is.
You are the issuer of the scheme. You cannot say I'm funded by somebody, so no, I won't work.
No, it's not about my working. Lord, kindly have a look.
Let me pass a direction against you. Yeah, I'll record your submission that since you are not funded, you are not liable to pay. Say that, I'll record that. I'll pass whatever orders. I'll direct you to pay. If you don't pay, there will be a contempt in which I'll implement the union. Mr. Chatterjee, that cannot be a legitimate ground.
But these are one of the parts of the matter.
There is nothing
Your
against
lordship
against
to
the
even more, Milord, it's just
This is your best point, Mr. Chatterjee. There is
no. Your lordship wanted to, Milord, know the outline of my argument.
What is your best point?
There are more points to this. My best point would be, Milord, in a lot of ways, I have to show your lordship that limitation part as well. That's probably one of my better points that he applied.
Is your best point.
Which he
That's
applied.
definitely a very good point. Yes. If he did not apply within time.
Exactly. So let me show it quickly. Then I'll take it to your lordship. Kindly turns to, Milord, the application form at 121.
Yes.
Lordship sees the first part. Subroto Gupta, Bali Fab International Limited hereby apply for grant of incentive for modernization of jute industry and the acquisition of plants and machinery scheme as follows. Then he gives the eligibility, Milord. Kindly looks to the date, 21st of August, 2017 at 124.
What was the last date there in this?
March.
Of
The
2017.
scheme ends March. Kindly, that's why I showed
Yes.
your lordship that.
Very well.
That is 31st March 2017, page 23. So this is one aspect in the matter, my lord, and I will also, just gives me 1 day's time, I'll come back with it. And Monday, Tuesday. I Monday will.
Nowadays, Mr. Kormakar is dictating you like anything. I mean,
Your lordship doesn't
this
know, my
looks
lord,
very
is,
odd. I mean,
This is nothing. This is nothing. My lord, in the other matter before Justice Moushumi Bhattacharya, my lord, his lordship was, my lord was annoyed that Mr. Kormakar doesn't let Mr. Chatterjee speak.
no, he is not letting you speak here also.
It doesn't.
So is it an aspersion on Bhattacharyas or judges as in general?
The way your lordship perceives it. He
No, but-
does it not just before the Bhattacharjis, my lord, everyone.
He doesn't even let the judges speak.
That's true. Only the Prabhu, my lord, he is.
But Mr. Chatterjee, apart from this is your best point probably.
That I'm trying to put forward things. I will pick up from wherever your lordship, my lord, has some interest.
But this is a very good point, Mr. Banerjee. Mr. Banerjee, you have to deal with this.
It's not. my lord. He also knows
This
it's
is also not a good point.
He may be
Learned
not
counsel,
ready today.
heard learned counsel for the parties, full stop, for further hearing of learned counsel for the respondents. Let the matter stand adjourned till August 29, 2023. 29th August. Thank you. Oh, একটা order করে দেবেন। হ্যাঁ, চারটে কনসাইকেল একটা single order, right?
আমার কম হয়ে গেছে। I've never been called innocent so many times in court. I thought he was sledging
No,
me.
you
when he
did
was-
not apply in time, Mr. Banerjee. How do you deal with that?
Innocent one.
Yes.
That is not a point. Your lordship wouldn't
Yeah,
be troubled
he is
with
no
that.
Usha. He's
Item
no
number
Usha.
6.
He's no.
Electricity
Six.
Classing Limited.
Grateful.
Lordship, I'm appearing for the petitioner in this matter. Lordship, I'm led by Mr. Kishore Dotto. Lordship, I'm praying for adjournment today. If you can kindly fix it tomorrow.
Very well. Not today, থাক। Order record করতে হবে। Not order record হবে।
Item number 7.
My lord, good evening, sir. Can I?
Yes.
স্যার কালকে একটা ম্যাটার আমার আছে লাস্ট ফ্রাইডে 54 নাম্বার ছিল প্লিজ টেক মাই ম্যাটার টুমরো ऑन अर्जेंट बेसिस
Item 7.
ना ना सर कल के लिए मैं बोल रही थी सर
हाँ?
इस कोर्ट्स फिनिश्ड
No, court is
Sir,
going on. Yes.
सर लास्ट फ्राइडे 54 पे था आइटम नंबर सर कल के लिए मैं
Appellate side. You'll have to mention tomorrow morning.
टुमारो
कल
मॉर्निंग
मेंशन कीजिए आप कल मॉर्निंग।
हो जाएगा
नहीं होता है, लेकिन अब कीजिए जब आप आए हैं इतना दूर, कल कीजिए।
सर लास्ट फ्राइडे
अब
54
ओरिजिनल साइड चल रहा है, वो एपिलेट साइड मैटर है, कल सुबह आइए। Item 6, you are there.
7, my lord.
7 it है, 7
My
yes.
lord, my counterpart Devdotto Sen.
I will find nobody.
Who
Who
is
is?
appearing for Reserve Bank?
Who?
My lord, Devdotto Sen.
Yes.
My lord, his father's portrait will be unveiled today. So probably
So whose portraits will be unveiled today? One is Mr. Sen and the other?
one is of Deepak Kumar Sen.
Oh, acha.
Another one is Dipankar Gupta.
Oh. Very well. Should I record the ground?
Monday. Tomorrow I have another.
None appears for the respondent at the time of
My lord,
call.
Mr. Raya is appearing for the State Bank.
None appears for the respondents other than the State Bank at the time of call. Full stop. On the prayer of learned counsel for the petitioner, let the matter stand adjourned till 28th, August 28, 2023.
Item number 8.
Not I applied for the respondent, Mr.
That matter?
Yes.
You are asking for time in this matter?
Yes, my lord. Well, let it be taken up tomorrow, my lordship. I applied. Fine. Mr.
Mr. Basu mentioned tomorrow.
But tomorrow I'll be in some personal difficulty. It could be on Monday, my lord.
Very
Monday or Tuesday, whenever.
On the prayer of learned counsel for the parties, the matter is adjourned till August 29, 2023, Tuesday.
Tuesday. Grateful.
Well, 29, let it be top of the list, lordship. Kindly.
Item 9. So item number 9.
I'm for the petitioner, my lord. May I file my reply? Affidavits are complete.
Opposition has been filed.
Opposition, we were served with the opposition, my lord.
No, let it be filed first. If it is not there on record, yes.
Because, this is, my lord, in respect of non-payment of subsidy. There has been a previous
Opposition
round of
filers?
litigation.
Yes.
Yes.
Reply.
Yes. There has been a previous round of litigation. My lord, there was a scheme of subsidy which was originally should be applied under that scheme. And subsequently, there was an amendment to the scheme which was brought in.
You're for the petition.
I'm for the petition.
Somebody let us come back tomorrow. I mean, 4 minutes, what will happen?
Very well, my lord.
They are also not there.
Tomorrow calculate for the next. Maybe then next week, my lord. Tomorrow second half. By any chance, there is
None appears for the respondent. You are for the respondent. No, she's with you.
Next.
No.
None appears for the respondent at the time of call. Let the matter stand adjourned till day after.
My lord, Monday. Then
Adjourned till August 28, 2023.
I'm grateful, my lord. Deeply obliged.
চলো আর কি থাকবেন দু মিনিটের জন্য অ্যাপিয়ারেন্স পাওয়া যাচ্ছে না
The affidavits have been taken on record, my lord. My reply.
Affidavit in reply filed today be kept on record. যেটা বললাম তার সঙ্গে affidavit in reply be filed today be kept on record. তারপর ওই adjourned till যা বললাম
Grateful, my lord.
My lord, item number